I had moved this matter on MFM.
Huh?
One MFA insurance company appeal. It has deposited 50% of the award amount. I've had application seeking withdrawal. It may be taken up. Last week also I.
Anta urgency.
Last week move ಮಾಡಿದ್ದ list.
All right, let us see. Yes.
Your Lordship, RFA, Your Lordship, 2022, I filed a memo for withdrawal, Your Lordship. Kindly, it may be taken up tomorrow, Your Lordship. I'm withdrawing memo.
Yes.
Contempt petition.
Huh?
Contempt petition was dropped by the undertaking given by the CEO. Jilla Panchayat, my lord, my representation will be considered within 1 week. But liberty was granted by this court, my lord. If it is not passed, I can file a revival. It is not at passed, my lord. It's filed.
Totally. Yes.
Seal number 33, Babu Metagod intimate ministry. Can you next week anything?
He has to be here. Otherwise, when it reaches bill, you can mention. Yes.
Yes, sir.
My lord, serial number 44, my lords. My lords, I
Huh?
pray for serial number 44, my lords.
Ah,
I pray for a week's adjournment, my lords.
who is on the other side?
My lords, I'll inform them, my lords. I appear for appellants, my lords.
No. If the other side is not here, we don't adjourn matters. Yes.
In serial number 46, Your Lordship, I am for the respondent.
46.
46. I have
Ah.
informed all other side, Your Lordship. Additional SPP is appearing on behalf of the appellant. Kindly week's time I will thank you.
ಯಾರಮ್ಮ ಇದುವರೆಗೂ ಒಂದ್ಸರಿನೂ ಅಪಿಯರ್ ಆಗಿಲ್ವಲ್ಲಮ್ಮ ಇವರು
Your
ನಂದಕಿಶೋರ್ ಅವರು
Lordship, I am the
Huh?
proxy counsel appearing on behalf of the appellant.
4 weeks now. We have not seen him even once.
I will
Every
inform.
time adjournment.
I will inform. Your Lordship.
46. Finally, at the request of learned counsel for the appellant
Respond.
or respondent, deals this matter on 25th of November.
Please.
Full stop. No further adjournments will be granted. Yes.
One complaints of office objections for second time, serial number 1, additional government advocate.
Praise my lord. 2 weeks time, my lord.
At 2 weeks time are granted at the request of learned government advocate for complaints of officer.
Serial number 2 for fourth time, Virangoda Mani Patil.
2 weeks time. 2 weeks.
Finally, 2 weeks time. Yes.
Serial number 3, Neelkanta RM.
Finally, 2 weeks are granted for complaints of office objection.
Serial number 4, additional government advocate.
Serial number 4 to 6, my lord. 2 weeks time, my lord.
Finally, 2 weeks time.
Serial number 7, Ganesh Nayak. Fourth time.
Two weeks for complaints of office objections.
Serial number 8 for fifth time, additional government advocate.
2 weeks finally. Also.
Huh?
2 weeks, my lord. Yes, my lord.
Finally, 2 weeks are granted at the request of learned government advocate for complaints of office objection.
Order serial number 9, Santosh Kumar Maradi.
My lord, I am for the appellant kindly permitted to serve the copies to the LR's application trial court counsel. The correct address is not found. Trace out.
You have filed IA for
For LR's application.
substituted service.
Substitute service is filed,
File
my
an
lord.
application for substituted service.
Filed, my lord.
ಆಗಿಲ್ಲ. ಹಾ. Second time. You have to furnish the correct address and
My
take
lord,
steps.
my lord, that's why I am requesting honorable court to kindly permit to serve the copy to the trial court counsel.
Even if it is served, if they don't appear, it will not be taken as service of notice, sir.
Please, my lord,
What is the use?
2 weeks my time may be granted.
Finally, 2 weeks' time is granted at the request of a learned counsel for the appellant to furnish correct address and to take steps for service of notice on IAS number 123 of 2020.
Please.
CL number 10, Prashant B. Vajantri.
Served ಆಗಿದೆ my lord. I for earlier in. The connected matter also.
Then what is the urgency?
The my lord in the petitioner in the due to in the retirement my lord in the
Huh?
ಅವನು ರಿಟೈರ್ಡ್ ಆಗ್ಲಿಕ್ಕೆ ಬಂದಿದ್ರು my lord.
ಹಾ.
The interim order not stay is not granted in this case my lord. Connected matter is interim order is granted my lord. So
ELRI, what is the urgency? What is the matter about?
my lord in this matters my lord. It is a joint inquiry my lord. Inquiry was conducted my lord.
Retired now.
No, in still in period ಇದೆ my lord.
ಹಾ.
ಇನ್ನೊಂದು ವರ್ಷ ಇದೆ my lord.
ಹಾ.
Due to that my lord.
ಹಾ.
ಅವನು ಎನ್ಕ್ವೈರಿ ರಿಕವರಿ ಹಾಕಿದ್ದಾರೆ my lord. Recovery order is recovery my lord. So urgency is there.
Yes, what do you say?
There is a interim order is there, my lord. There is no threat to them.
Connected matter ಅಲ್ಲಿ interim order ಇದೆ my lord. This matter ಅಲ್ಲಿ ಇಲ್ಲ.
Ilva.
ಇಲ್ಲ.
Also to fix any date, my lord. for hearing it.
200295 ಅಲ್ಲಿ ಇದೆ my lord. He also is one of the
ಈ connected matter ಅಂತ ಏನದು? What is this?
same matter my lord. He also one of the DGO my lord.
So we'll pass interim orders then.
But you also private, my lord, any date for hearing itself, my lord.
Okay. ಇಲ್ಲಾಂದ್ರೆ ಈಗ ಈ ತರ ಪ್ರೆಸ್ ಮಾಡ್ತಾರೆ for early hearing.
ಅಲ್ಲ 22 matter ಇದೆ, lots of private. This is matter for pertaining to 22 years. So 2022 matter.
ಅದು ಅಷ್ಟೇ.
ಅದೇ hearing
ಅದ್ರಲ್ಲಿ interim order ಕೊಟ್ಟಿದ್ದಾರೆ, ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಹಿಯರಿಂಗ್ ಯಾವ್ದಾದ್ರು ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ will.
All right, we will pass the same orders. Learned counsel for the petitioner submits that in respect of another writ petition which has been filed by a person similarly situated. Interim orders of stay have been passed in WP number 200295 of 2022. Stop. Learned counsel therefore seeks for similar interim orders. Stop. Next paragraph. Consequently, there shall be ad interim orders. There shall be an interim order of stay as prayed for until further orders.
Present status, we don't know, my lord, what happened, my lord, after the,
Huh?
since there is no interim order, my lord. Present position, my lord, we
ಅವ್ರು
don't.
ಇನ್ನೊಬ್ಬರದ್ದು ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, so
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
naturally nothing would have happened. Yes.
CL number 11. Fire, writ of habeas corpus
In
petition.
this matter, my lord, I may be permitted to file the status report, my lord. Order. Yes, my lord, that, Superintendent of Police, my lord, appointed the team, my lord, for this purpose only, my lord. This team, my lord, made the, my lord, around the, my lord, that neighbor states and all, my lord, they visited. But they, no use, my lord, not traced those victim and the accused number.
ಏನ್ರಿ ಇವಾಗಿರೋ ಟೆಕ್ನಾಲಜಿಲಿ if you. if
That's why,
people are
even my lord, we use
Going
that
on
one
saying
also.
like this, what is the use?
But kindly see, my lord, that the page number. uh, We also, my lord, trace that mobiles also, my lord. But even statement that passbook also, my lord, seized, whether they are, my lord, using the, my lord, bank.
ಇವ್ರದ್ದು ಇಬ್ಬರದು ಫೋಟೋಗಳು ಎಲ್ಲಾ ಕಡೆ ಕಳ್ಸಿದಿರೇನ್ರಿ?
ಎಲ್ಲ ಕಡೆ ಹಾಕಿದ್ವಿ.
Huh?
Last time also we produced, my lord, even, my lord, Tamil Nadu, Andhra Pradesh, Telangana, all police station, my lord, we sent. And we personally visited to that police station. And this, my lord, victim's mobile also, my lord, and that accused mobile. We requested to give the, my lord, IMEI, but that is not activated.
ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್
Pardon, my lord.
ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್
Bank account also I produced, my lord, there is no transaction. I produced that bank account also.
See, for everything you now read a Aadhaar card.
Yes, my lord.
Even
Aadhaar-
for taking a SIM card, you need a Aadhaar card.
Okay.
Even for opening a bank account, you need a Aadhaar card.
Yes. But Aadhaar card is not linked to the bank account. That is the information given by the bank authorities.
ಹಾ,
But Aadhaar card is not linked.
ಇವಾಗಿರೋ ಅಕೌಂಟ್ಗೆ.
How those?
But if there is no money there, and is not transacting,
ಅಲ್ಲ ಮನಿ ಇದೆ
ಎಷ್ಟಿದೆ?
ಅದು ಸರ್ ತುಂಬಾ ಇಲ್ಲ ಸರ್,
Therefore,
ದಟ್ ಇಸ್ ಅ ಪ್ರಾಬ್ಲಮ್.
if he has to open a new account somewhere, he has to use the Aadhaar card,
Yes, they have to use.
isn't it?
Yes, ma'am.
Huh? Huh.
Even that information also not we sought.
How do you get that information?
Now, no, that's why, my lord, we request your lordship, have it on 25th, my lord. We seriously, my lord, this team is, my lord, going around the neighbor states. Even other side, the other side is given, my lord, some particular, some clue, my lord. Relatives,
ಅವ್ರು ಗೊತ್ತಿದ್ರೆ why would they come before the court like this?
relatives ಯಾರಾದ್ರೂ ಅವ್ರು ಇದ್ರೆ ಔಟ್ ಫೋನ್ ನಂಬರ್ ನಾವು ಟ್ರೇಸ್ ಮಾಡಬಹುದು. ಅವ್ರು ಯಾರಾದ್ರೂ
ಅವ್ರಿಗೆ ಏನಾದ್ರು ಒಂದ್ ಸ್ವಲ್ಪ ಕ್ಲೂ ಸಿಕ್ಕಿದ್ರೆ they'll come and tell you. Why should they hide?
ಕೊಟ್ರೆ, ಯಾಕಂದ್ರೆ ಅವ್ರ ಹುಡುಗಿ ಆದ್ರೂ ಕೂಡ ಆ ಹುಡುಗಿ ಅವ್ರ ಫ್ರೆಂಡ್ಸ್ ಜೊತೆಗೆ ಅಥವಾ ಯಾರಾದ್ರೂ ಚಿಕ್ಕಮ್ಮ ಅವ್ರ ಅತ್ತೆ ಯಾರಾದ್ರೂ ಕೂಡ ಲಿಂಕ್ ಇದ್ದೇ ಇರುತ್ತೆ. ಇನ್ಫಾರ್ಮೇಶನ್ ಅವರು ಇಂತಲ್ಲಿದ್ದೀವಿ ಹಾಗೆ.
Parents have gone under depression. They are admitted in hospital.
They have been taken into custody, isn't it?
My lord.
They have been taken into
Yes,
custody.
parents
No,
are
the
taken.
accused parents are taken,
Huh?
victims' parents. I'm submitting for victims' parents. SP Raichur may be directed to be present.
ಏನು?
SP Raichur
Huh.
may be directed to be present
ಎಸ್ಪಿನೇ ಟೀಮ್ ಮಾಡಿದ್ದೀವಿ.
And do what?
to activate the exercises.
Sorry,
What
that is the report that they have
They are
given.
repeating.
These are all done at the directions of the SP.
All what they are submitting is only repetition of the earlier reports.
No. They have given information as to what happened after this previous order dated 6/11/2024.
Day by
Every
day by
day's
day.
information they have given.
Yes.
7/11, 8/11, 9/11, 10/11 ಎಲ್ಲಾ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲಿ
All information is given.
ಇಲ್ಲಿ ಬರುವವರೆಗೆ ರಿಪೋರ್ಟ್ ರೆಡಿ ಮಾಡ್ಕೊಂಡು ತಂದಿದ್ದಾರೆ. Till yesterday they have prepared the report.
ನೀವು ದೊಡ್ಡದಾಗಿ ಹೇಳ್ಬಿಟ್ರಿ ಅವತ್ತು ಅವ್ರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ಸಿ ಸ್ವಾಮಿ ಸಾಕು ಮಾಡ್ಬಿಡುತ್ತೆ ಎಲ್ಲಾ ಕೆಲಸ ಅಂದ್ರ ಎಲ್ಲ ಅದು ಮಾಡ್ಸಿದ್ವಿ. ಏನಾಯ್ತು?
Lord, my anxiety is the
Now
safety of
those 2 people are in custody because of
safety.
your submission.
Yes, my lord. Yes,
Yes.
my anxiety, my lord. My anxiety, out of my anxiety, I submitted.
ಹೌದ್ರಿ, for no fault of theirs, they are in the custody now
Their son, my lord.
because we directed the police.
Accused is their son.
ಹೌದು, ಅದಕ್ಕೆ
With their connivance, the son has, sorry. I'm sorry.
you can't go on making this kind of submissions. Sir.
I'm sorry.
ಹೈಕೋರ್ಟ್ ಅವರು ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಬೇಲ್ ಅಪ್ಲೈ ಮಾಡಿದ್ರು ಬೇಲು ಕೊಡೋದಿಲ್ಲ.
ಇಲ್ಲ, ಮುಂಚೆನೆ ಅವ್ರು ಮಾಡ್ಬೇಕಾಗಿತ್ತು, ತಾವು ಡೈರೆಕ್ಷನ್ ಮಾಡಿ ಮುಂಚೆನೆ ಅರೆಸ್ಟ್ ಮಾಡಬಹುದು. ಆನ್ ಪಾಯಿಂಟಿಂಗ್ ಔಟ್ ಮೈ ಲಾರ್ಡ್ಸ್,
ಹುಡುಗಿ ಇಷ್ಟಪಟ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಾ, ಏನ್ರಿ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಮೈನರ್, ಮೈ ಲಾರ್ಡ್ಸ್.
ಗೊತ್ತಾಯ್ತು, ಅದಕ್ಕೇನೆ ನಾವು ಇಷ್ಟೆಲ್ಲ ಹೇಳಿರೋದು.
Yes. Beyond this, I cannot make any submission because of minor and the parents.
Done all that. You have noticed in our orders itself.
SP ಕರ್ಸಿದ್ರೆ ನನ್ನ ಸಮಸ್ಯೆ ಬಗೆಹರಿಸಬಹುದು. That is only anxiety, nothing else.
ಏನ್ರಿ ಅವ್ರು ಏನ್ರಿ ಮಾಡ್ತಾರೆ ಬಂದು?
Signal will go. Signal will go to the society. SP will take it serious. 302, when the murder takes within 24 hours, accused are arrested. My lord, this is a very serious case.
Learned government advocate has filed further status report along with various documents. Full stop. Learned government advocate submits that after the previous order dated 6/11/2024, each day's action taken report has been furnished along with the memo. It is submitted that as per the directions of the Superintendent of Police, a team has been formed and the police have made all efforts, not only by collecting information regarding the usage of mobile phones, Aadhaar card, bank accounts, of not only the accused persons, but also the victim and the relatives and friends of the accused persons. Full stop. The team has visited many police stations in the neighboring districts as well as outside the state. Next para. We are constrained to observe that in our previous orders, we have made it clear that the issue is of a very serious nature, since the victim is a minor girl. Full stop. Next para. Release this matter on 25th of November.
Please.
Full stop. If the respondent police are unable to trace the victim girl by the next date of hearing, the superintendent of police, ಯಾವ district is it?
Raichur.
Raichur, is directed to be
Grateful.
present before this
I'm very
court on
grateful.
the next date of hearing.
I'm very grateful.
Yes. ಯಾವಾಗಿದೆ? ಎಲ್ಲ ಸೆಪ್ಟೆಂಬರ್ ಅಷ್ಟೇ. Yes.
CL number 12, Anil Rathod, Jayashree, Swati N, SD Rathod,
Fresh steps, huh? For respond number 4. Huh? R1, 2 and 5 refused, huh? 1, 2, 5 refused. Adhe, 1, 2 and 5 refused. Huh? Notice sent to response number 1, 2 and 5 have returned with postal shara inverted commas only refused. Close it, comma, full stop. Therefore, notice is held sufficiently served on response number 1, 2 and 5. Full stop. Next para. A week's time is granted to the appellant to take fresh steps for service of notice on respond number 4. Yes.
CL number 13, KM Ghate,
Yes. I'm for the respondent. Yes.
My lord, the orders passed by the learned single judge, page 40, my lord, regarding direction to reinstatement of the petitioner complainant, my lord.
He was dismissed from service.
Yes, my lord. There was a direction also by the Education Appellate Tribunal.
Ah.
That direction challenged the writ petition.
Ah.
And now the writ petition filed by the management was came to be allowed. And there was one more writ petition filed by the petitioner herein, having denied the payment of back wages.
Hmm.
That writ petition came to be allowed, and direction was issued that the respondent management, my lord, they shall reinstate the petitioner to his post immediately before the date of his suspension, my lord. This was the order. And the other order, my lord, regarding payment of back wages and subsistence allowance. This order was came to be challenged before this honorable court, my lord, in writ appeal number 291 of 23. My lord, annexure B, page 42, my lord. Herein, the interim order passed in the writ appeal, my lord.
It was directed that he shall be reinstated
Yes, my lord.
forthwith.
Yes, my lord.
But liberty was also reserved to response number 1
yes.
and 2.
Yes, my lord. That was regarding.
Initiate fresh disciplinary action
Yes,
against the appellant.
please, my lord.
He is entitled to suspension allowance
Yes, my lord.
in the event the disciplinary proceedings being not initiated against the appellant. 50% back wages referred to above becomes payable to the appellant after expiry of 2 months
Yes.
from this date.
Yes.
Yes.
My lord, this order was came to be challenged in the writ appeal, my lord. On 14/7/2023, my lord,
Ah.
page 43, may kindly peruse. There shall be a stay of a direction to pay back wages. The de novo disciplinary proceeding shall be by an officer who has not presided over the previous proceedings, and the inquiry officer preferably
So there was a stay granted by the division bench.
regarding
Payment of back
back
wages.
wages, my lord.
Ah.
And direction regarding payment of subsistence allowance. Page 44, my lord,
The
subclause
proceeding
E.
shall be completed within 3 months. First
Yes, sir.
respondent shall, upon receipt of due communication from the appellants,
Yes, my lord.
as regards the institution of proceedings, participate therein
Yes.
to avoid consequences. Otherwise,
Yes.
shall not take any decision on the report so submitted without the leave of the court.
Yes, sir.
There shall be interim stay
Please,
insofar
Lord,
as
this is-
the direction to pay back wages.
Yes, my lord. Which is the only interim stay, my lord.
Ah.
And so far as
The appellants are also
reinstatement
directed
is
to
concerned.
pay subsistence allowance.
Yes. ma'am.
Ah.
So this was not stayed, my lord.
Ah,
Now,
the writ appeal is pending?
no, my lord, now
appeal
they
is
have
disposed of.
withdrew the writ appeal
Writ appeals
after
are disposed-
completion of the
Inquiry
de novo
was conducted.
inquiry.
writ appeals have been disposed of as per next D, mother.
Ah.
Page, the ultimate position is what is the finding recorded in the latest order.
Hmm.
That is found at page number 46. There, my lord, your lordship says, the order of the learned single judge has been extracted.
Hmm.
Kindly go to page number 49 for a moment. Before that, I have to state two things. But the order directing, kindly see page 49.
Ah.
The quoted portion, respondents 1 and 2
Hmm.
shall reinstate the petitioner to his post immediately before the date of his suspension. It does not convey any meaning, it doesn't mean to his post immediately before the date of suspension. He had already been dismissed from service. Liberty is reserved
to respond 1 and 2 in the writ petition number so and so petitioner to initiate disciplinary proceedings against the appellate. We did initiate, and my lord, the retired district judge was appointed as as per
But there
the.
was a direction that
Pardon
you
me?
shall not take action on the report
No,
without the leave of the court.
yes, your lordship.
The interim orders
Yes.
says so.
Therefore, there was an order
Ah.
to the effect that we should not take, in fact, I made that concession before your lordship that though we would initiate an action, in view of the pendency of the matter and that matter being sub judice, I would not take any action unless I seek the leave of this honorable court.
Yes.
Your lordships recorded my statement and said that yes, you shall not do. Pursuant to that, after the inquiry was completed, it should have been completed in 3 months. It could not be for a variety of reasons. Therefore, extension of 15 days time was granted by this honorable. Within that time, in a sealed cover, when the report was submitted by the inquiry officer, who was a former district judge and presently a practitioner here, the report was placed in a sealed cover before. It was submitted to us, but we did not open it. It was not even opened, let alone acting on it. It was placed before this honorable court. The division which went through it, opened it in the open court, and then the Lord directed us to take action in accordance with law. Then my lord, your lordship knows that according to judgment of the Supreme Court in Ramzan's case, we had to give a second show cause notice with a report, which we did furnish. He replied, and thereafter an order of dismissal has been passed, which is the subject matter of an appeal which he has filed. The entire action taken for the second action, it is the disciplinary proceedings culminating in the dismissal ordered by us is a subject matter of writ appeal number, EAT appeal number 2 of 2020.
Is it recorded
Pardon me?
that all this, while disposing of the writ appeal,
Yes, sir.
where is it recorded?
Previous order.
That yes, there was some interim
Yes.
order passed, and now
Copy put in the-
since the report has been submitted,
Yes, I will show it to you.
that,
Page 51, para 4, Malord.
Order copy, isn't it? Innೊಂದು writ appeal article. There was an order passed by this
this
honorable
court
court.
upon opening,
This is a file, one ನಿಮಿಷ ಕೊಡ್ತೀನಿ. ಅದು ಹೇಳಿ. You can open the sealed cover and illegal, ತೋರಿಸಿ. I'm sorry for a minute. ಎಲ್ಲಿ ಹೇಳಿ? Yes. Kindly go to page 51 for a moment now. The first paragraph, about 5 lines from the first paragraph, will read, the management in terms of the liberty has instituted the disciplinary proceeding, and because the inquiry is not completed within the time allowed, management has filed an application for extension. This court has granted extension. See, so and so on this previous occasion had submitted a copy of the inquiry report in a sealed cover for its court's inspection. This court, upon opening the sealed cover and on cursory peruse the report, has returned the same to the learned counsel on the record for the management. She so and so had submitted that the primary question for consideration in these appeals is whether the inquiry against the first respondent must be under the Karnataka Civil Services CCA rules or under the Karnataka Private Education Institutions Rule 78. But this question is rendered academic with the turn of events, and therefore the management is advised to seek leave to withdraw the appeals with liberty to consider the present inquiry report in accordance with law. Kindly permit me to digress for a moment. As the question was purely academic, whether the inquiry should have been held under the CCA rules or under since this honorable court directed a fresh inquiry being held, that too not through the same officer, but through a different inquiry officer as a submitted usage. Since we held an inquiry without seeking to be technical in the matter, we could have contended that no, the inquiry held under the CCA rule itself is correct. We did not want to be technical. We held an inquiry, submitted the report was given to us, we acted upon. Therefore, they said, Why should we waste the public time of this honorable court in arguing a totally academic issue? Because the other side would have said that as an inquiry.
ಆಯ್ತು, ಮುಂದೆ ಓದಿ.
So,
ಏನಾಯ್ತು? What did the
next,
court?
so and so reads says these submissions and seeks leave to withdraw the appeal, and the learned senior counsel further reiterates that there will be no repercussions to the first respondent if the writ appeals are withdrawn, in as much as a present proceedings or as directed by this court on and the culmination thereof will be in strict accordance with law. Shri Ghate, the learned counsel for the first respondent, submit that he cannot really oppose the leave to withdraw the writ appeals. Kindly see, he concedes. But this court must direct management to pay subsistence allowance, not only for the period between 16/4/22 and 28, but also for the subsequent period until the decision is taken on the inquiry office report one way or the other. So he confined in the appeal also, not the.
Regarding subsistence allowance.
Only on back wages. Then what is he finding? The learned, sorry, Shri Ghate proposes to rely upon provisions of the 78 rules to substantiate this claim, contending that the management must be directed to pay subsistence. His whole insistence was on pay back wages. Shri so-and-so submits that the management's
Subsistence
obligation to pay back wages.
Not back wages,
Yes.
subsistence allowance.
Pardon me?
Only subsistence allowance, not back wages also.
No, subsistence, back wages, he also, subsistence allowance we have paid. In fact,
ಓದ್ಬಿಡಿ.
They have paid.
If the
But
court
still
has taken all that into consideration,
that has
we
been
need
paid.
not go back
Yeah.
again.
Then so back wages in terms of the is only if the disciplinary proceedings are not initiated, but the leave of this court to such a discipline are initiated, and this upon consideration inquiry of his report, there is a decision in favor of the first respondent. Management will have to necessarily consider the first respondent's request for back wages. It is my submission. I said, supposing he is reinstated or he is exonerated, in which event we could not deny back wages, because though the settled position in law is no work, no pay, nevertheless, he might insist on it. Therefore, I said, it would result on the culmination of the proceedings. It culminated in a dismissal order, which, as I submitted a minute ago, is the subject matter of an appeal before the Education Appellate Tribunal. He has filed an appeal against the order. Yes, right. That is
Subsequent order.
subsequent order is also the subject matter of an appeal, which I have said in my statement of objection. Then, my lord, back wages in the later applicable, in the event of the present results in order against the first respondent, he will have to work out his remedies as available in law. Then it is obvious from these submissions that in view of the turn of events, the management should be permitted to withdraw the appeals. It is not only my request, the court's judicial opinion was permission should be granted, because we should not waste our time on academic issues. And this leaves open the question whether there may be any direction to the management to pay and allowance beyond what is directed by this court. So question of reinstatement or insist ಮಾಡಲಿಲ್ಲ ಹೇಳಲಿಲ್ಲ. As an afterthought, after filing an appeal before the court, now he has said at the early, ಅದಾದ್ಮೇಲೆ 2 writ appeal ಆಯ್ತು, ತಾವೊಂದು appeal allow ಮಾಡಿದ್ರಿ interim order ಮಾಡಿ, because there was an order passed by a learned single judge directing his reinstatement.
That was the old one.
That was old one, that was already attended final.
The court is of the considered view that such directions cannot be issued in the writ appeals filed by the management, and this question could have to be considered if there was a separate appeal by the first respondent, which he did not file. He did not file. Therefore, there is a waiver, abandonment, and acquiescence. He is therefore estoppel. As such, there cannot be any directions in this regard to the management. Now, my lord, he is now complaining. Kindly see page 14 for a moment. This present contempt of court petition is on the basis of the observation, page 49, David Nodi. Single judge order in the extract again. What is contained in page 44 is repeated in the order of the division bench. Kindly see page 49. Or I will take your lordship to 43. ಅದಕ್ಕೆ ಹೋಗೋಣ. May I read? page number 43.
So
ನಲ್ಲಿ-
your prayer in this contempt petition
Please, he has been paid.
is to
There
take
was a-
action.
Annexure C, mother. Annexure C, he himself had produced it, page number 45. Inquiry ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರು, enquiry ಮಾಡಿದ್ವಿ. Don't take
Why they
action.
should not be dealt with under the Contempt of Court Act, having not complied with the orders passed by the learned single judge.
They have paid him the money.
There was a positive direction according to my lord to reinstate. That is not been taken care of by the management. My respectful submission, my lord, when they withdrew the writ appeals, this honorable court in the writ appeal, my lord, has clearly held. However, this court must observe that the page 54, my lord, that the disposal of writ petitions granting leave to withdraw.
Where in the order,
Please, my lord.
nowhere in the order, anything has been said regarding your reinstatement.
Correct.
No, no.
Now already
The
insist
writ-
on it.
my lord,
Nowhere in the order,
nothing is stated.
nothing is said
But that was not
regarding
stayed also.
reinstatement.
My respectful submission, my lord, that was not stayed also. When it was not stayed, my lord,
Therefore,
till they holds a subsequent inquiry, it was incumbent upon them to reinstate the complainant, my lord. And here, even withdrawal of the writ petition, writ appeals, my lord, this court must observe that the disposal of writ appeals granting leave to the withdraw cannot prejudice the first respondent's right either in the circumstances emphasized. My respectful submission, my lord, the order that is positive action issued by the learned single judge that remained without any compliance.
that is regarding payment of subsistence allowance.
No, my
only.
lord, reinstatement regarding subsistence
No,
allowance,
No, no.
I am not agreed, my lord.
Right? You have not even made a submission. Nothing is recorded.
No, one submission, my lord, if I have not made the submission also, it is part of the record. They were knew it very well when they preferred the appeal, my lord. It was not prevented them to seek the interim order on that direction also. Now they have not sought the direction to be stayed by the honorable court, my lord. Now, what they says, my lord, after this, their statement of objections are being filed. This honorable court has taken a view already. Order dated 23/9/2024, my lord. Kindly,
That was only a passing observation, that is not a final order.
unnumbered para 3, my lord.
Hmm.
However, it must be noticed that the order of the learned single judge dated 23/5/2023 had a direction Roman 2 order for reinstatement of the employee to his post at the same stage before the date of his suspension. No doubt, liberty was reserved to initiate fresh disciplinary action has culminated in an order of termination dated 30th/3/2020. My lord, this is 24, what the typing mistake, but at least between the time 23/5/2023 to 20 March 2024, the direction of the learned single judge for reinstatement ought to have been complied. This is a prima facie view, and the respondent accused are to, in writing, take a stand for not having reinstated the employee between the date of order of the learned single judge till 30th March 2024, which was a fresh order for dismissal, termination after fresh disciplinary proceedings, as referred by the order of the learned single judge. The other contentions by counsel for the employee as regards the setting aside the direction of the reinstatement, which continues in operation and its non-compliance also amounts to contempt, is kept open. Therefore, my humble submission, merely because I have not
Why did you
raised,
not insist before the division bench in the appeal?
please, my lord.
Why did you not insist?
No, it was there in
Please
there.
don't entertain the appeal without compliance of the orders of the learned single judge that I have to be reinstated.
And he even participated in the inquiry.
No,
He
no,
never.
That's
raised
what,
the-
that's what, my lord.
Liberty was given by the
Please, my lord.
division bench
Please,
that
my lord.
permitting them to go ahead with the fresh inquiry.
Please. Therefore, my lord,
You are directed to participate.
yes, my lord.
Ah.
Therefore,
You
the
didn't
last
insist.
observation made by this
You didn't
honorable.
insist. Let them do it, but I have to first be reinstated. You never said so.
No, no, it
On the
was
other
knowing to them, my lord, already.
Yes, sir, it was also known to you that there is a order passed by like this by the learned single judge and they have
Yes,
not
Lord.
complied.
Yes.
Why did you not insist that I should be reinstated first? You not reinstate, you not press for it. You participated in the inquiry.
My humble submission, my lord, because
And
of the,
now whether you like it or not, there is a fresh order of dismissal.
No.
Now where is the question of reinstatement?
that is a subsequent issue, my lord.
And
My,
you have,
my only
you
humble
have filed
submission.
an appeal.
Yes, my lord.
You have filed an appeal.
That is subsequent order.
Where is the question of reinstatement now?
No, during that tenure, my lord.
That is what, sir, during the pendency of the appeal before this court,
Yes.
you did not insist. Look here, there is a direction given by the learned single judge that I have to be reinstated.
It was,
Without me getting reinstated, I will not participate in the inquiry. You should have said so.
no, if I have not said so, my lord,
Kept quiet, you
One
accepted,
submission.
you
if I have not said so,
acted in terms of the directions given by the court.
my humble submission, merely because I have not mentioned that one, whether the positive direction issued by the learned single judge can be just waived up, my lord. That is the,
It was there for you to insist upon. You did not insist.
Yes.
You simply complied with
under
the
the-
directions given by the court,
my lord, under the bona fides,
the inquiry.
under the
Now-
bona fides, my lord, they,
When there is an order of dismissal again,
please, my lord.
where is the question of reinstatement now, sir?
No, that is not during that tenure, what was prevented them to reinstate me, my lord? They should come up with a definite stand that what was there, because order was not stayed. And while withdrawing the appeal also, they were having knowledge about it. For that particular period, what was their difficulty to reinstate me, my lord? They have not stated so anything
Correct, you should
elsewhere.
have questioned it then only, sir.
That's what, my lord.
When the matter was open before this court.
No, that's
Why
what
did
I
you
am
not
submitting.
insist?
The,
Why did you participate in the inquiry then?
pardon,
Why did you participate in the fresh inquiry?
that participation in the fresh inquiry, whether will take away the life of this order, my lord. The order which was there,
Is an order of reinstatement. It's an order of reinstatement
yes, my lord.
subject to further inquiry that could be held, which was permitted by the court.
The reinstatement, they should have done it, my lord.
Therefore,
Yes.
you should have insisted.
Wherever
First,
two,
ask them to reinstate me.
yes, my lord.
Otherwise, I will not participate in the inquiry. You did not do so.
So that was not properly advised. That is also one of the, maybe a ground, my lord, because ultimately,
After the turn of events, now when there is a fresh order of dismissal,
yes.
how can we direct them? No, you
No, no,
reinstate
this
now.
fresh order of dismissal is passed later on if I'm, after I
That
filed,
is
first I have
after
filed appeal.
Permission of
Yes,
the court was obtained.
Was obtained only regarding conducting inquiry, my lord.
Correct. That is what we
Nothing
are
was
saying.
stated regarding reinstatement, my lord.
Kept quiet all those days and you participated in the inquiry. And now when there is a fresh order of dismissal,
After filing the appeal.
I leave it to the honorable court, my lord, because what the last order, portion of the order in the writ appeal, my lord, what I submit, my lord, my rights have been
I
protected.
have not said anything regarding your reinstatement.
That's what I'm, lord, I am submitting by giving the permission to withdraw the appeals, my lord. My rights have been protected. So
Regarding
therefore,
what, sir?
pardon,
Regarding what?
regarding reinstatement,
You never made any submission regarding your reinstatement. Nowhere in the order, anything has been said regarding the reinstatement.
now,
Otherwise, you
No.
will have to go get a clarification from the same bench. That is what the Supreme Court says in that judgment. If there is any
please, my lord,
ambiguity,
please.
then it is better to send the parties back to the court which passed that order to get a clarification. Put it. See in this Jareshwar Prasad Paul, this is what the Supreme Court says. If the judgment or order does not contain any specific direction regarding a matter, or if there is any ambiguity in the directions issued therein, then it will be better to direct the parties to approach the court which disposed of the matter for clarification. This court, as a contempt court, should not go into these aspects of the matter. That is the direction. Instead of court exercising contempt jurisdiction taking upon itself the power to decide the original proceedings. This court cannot do it.
We'll ask for clarification.
Perkal.
My rights may be,
You want to go get
Protect-
clarification? We
Yes.
will permit you to. do.
please go, please.
Learned senior counsel, Sri Subramani Joyce, appearing on behalf of the respondent. Respondents,
2 and 3. Go.
2 and 3. Submits. That consequent to the writ petition being disposed of at the hands of the learned single judge on 23rd of May 2023 with certain directions to the second and third respondents. More particularly for reinstatement of the petitioner, semicolon, for payment of subsistence allowance. It should have been subsistence allowance. Suspension allowance and
Annexure C. We have paid it. He himself
subsistence
has
allowance.
produced it.
Subsistence.
Page number 43, brother.
And payment of 50% back wages. Nevertheless, liberty was also reserved to the respondents to initiate fresh disciplinary action against the appellant. Full stop. These respondents preferred an intra-court appeal in WA number 20091 of 2023. Where by interim order dated 14/7/2023, an order of stay was passed insofar as payment of back wages is concerned. Full stop. Permission was also granted to the respondents to initiate disciplinary proceedings de novo at the hands of an officer who has not presided over the previous proceedings and that the officer shall preferably be a retired district judge. Full stop. Directions were also issued to the complainant herein to participate in the disciplinary proceedings. Full stop. Accordingly, disciplinary proceedings were initiated and a report was submitted by the inquiry officer in sealed cover. Full stop. The sealed cover containing the report was also placed before this court in the writ appeal proceedings. Full stop. Consequently, by order dated 12th of February 2024, the writ appeal was disposed of, clearly stating that the court, upon opening the sealed cover and on cursory perusal of the report, has returned the same to the learned counsel on record for the management. Full stop. submission was also made on behalf of the complainant herein that the complainant cannot oppose the leave to withdraw the writ appeals, but it was submitted that this court must direct the management to pay subsistence allowance. Full stop. Accordingly, the writ appeal was permitted to be withdrawn by the management. When while clearly stating that this court cannot issue such directions to the management to pay any allowance beyond what was directed by the writ court. Full stop. Learned Senior Counsel submits that no doubt the court has observed that the disposal of the writ appeals cannot prejudice the writ petitioner's rights either in the circumstances emphasized by the Learned Counsel or otherwise. Full stop. Learned Senior Counsel submits that in paragraph number 6 of the order passed by this court, the submissions made by the Learned Senior Counsel has clearly been recorded. That the obligation to pay back wages in terms of the orders passed by the writ court is only if disciplinary proceedings were not initiated, but with the leave of the court, disciplinary proceedings were initiated afresh, and therefore on reconsideration of the consideration of the fresh inquiry report, depending on the outcome of the decision that could be taken by the management, the writ petitioner may work out his remedies. Full stop. The Learned Senior Counsel would therefore submit that the complainant herein never insisted on reinstatement throughout the proceedings before the coordinate bench of this court. Full stop. The complainant has accepted the directions issued by the coordinate bench, participated in the inquiry, and now after consideration of the report, when fresh orders of dismissal have been passed, question of reinstatement at this stage would not arise. Full stop. Next para. For contra, it is the contention of the Learned Counsel for the complainant that there was a direction issued by the learned single judge directing the respondent management to reinstate the complainant, writ petitioner, forthwith. Full stop. That order has not been complied. Full stop. Next para. In the considered opinion of this court, having regard to the fact that the complainant herein did not insist on reinstatement during the proceedings of the writ appeal. And on the other hand, participated in the fresh inquiry. And now that there is an order of dismissal, this court, in the contempt jurisdiction, cannot decide as to whether the coordinate bench said anything about the reinstatement of the writ petitioner in terms of the directions issued by the learned single judge. Full stop. Further, having regard to the judgment of the Honorable Supreme Court in the case of Jareshwar Prasad Paul and another versus Tarak Nath Ganguly and others, bracketly 2002, close 5 SCC 352, wherein it was held that if the judgment or order does not contain any specific direction regarding a matter, or if there is any ambiguity in the directions issued therein, then it will be better to direct the parties to approach the court, which disposed of the matter for clarification of the order, instead of court exercising contempt jurisdiction, taking upon itself the power to decide the original proceedings in a matter not dealt with by the court, passing the judgment or order. Full stop. Well, here of the considered opinion that the complainant may seek clarification on the aspect as to whether the coordinate bench intended to say anything insofar as the reinstatement of the complainant is concerned, having regard to the directions issued by the learned single judge. Full stop. Next paragraph. 3 weeks are granted to the complainant herein to seek clarification as noticed herein above.
Please.
Yes. Yes. Huh? Illa. We have not dropped the proceedings. We have only said, go seek a clarification. If the coordinate bench says, yes, by giving that leave, we intended that we said something about reinstatement also, then let them pass orders and we will consider. Otherwise, if the coordinate bench says, accepts your submission, that nothing was said insofar as reinstatement is concerned, we have not dealt with that issue at all, and no liberty was granted.
In order to protect the interest of the complainant also, because it is my duty as a counsel for you. What I will request your lordship is, present petition is disposed of a drop. Liberty being expressly reversed by the court.
Ango ಮಾಡಬಹುದು.
ಅವಾಗ limitation question ಬರಲ್ಲ. I cannot and I do not reason. Proceedings are dropped with liberty reserved. He can file a fresh petition. He can always file a fresh petition.
With these observations, the contempt petition is disposed of while reserving liberty to the complainant to revive the contempt petition if clarification is issued by the coordinate bench that it intended to grant liberty to the writ petitioner insofar as the question of reinstatement is also concerned.
Please.
Yes.
Seal number 14, Deepak B. Barad.
In this matter, my lord, I will take notice for respondent 1 to 4, my lord.
I have
But
filed
state
this.
has preferred the, my lord, SLP before the apex court, my lord. That is, my last occasion I produced that copy of the SLP number. My lord.
Lords on On 2/10/2024 itself, they have filed a SLP, which is in diary number till date, my lord. And there is no interim order as such.
That's why we also moved that matter, my lord, that
The order of this honorable court is of 30/10/2023. And only the promotional benefits and retirement benefits has been granted by this honorable court. And all the exercise has to be done within 3 months from the date of order. Already 1 year has been expanded. He is already retired person.
Yes.
that's why my last occasion I made the submission, my lord, that we also moved that matter, my lord. Maybe the date will be fixed for premier hearing, my lord, that matter before the apex court. But we'll also pay out next week, my lord. By that time, my lord, we'll get the further stage of the, my lord, SLP matter.
We have made it clear that if you don't get an order of stay,
That is, my lord, we moved
you
that,
have
my
to
lord.
proceed.
We moved that, my lord, date is not given. That is the problem for us, my lord.
Sir, merely because you preferred an SLP.
But not, no, we are only also moved that matter also, my lord, before the CJ. But date is not given to us.
Yes.
That is a maybe fixed, my lord, next week, my lord. Once again, my lord, we'll request the, my lord, Chief Justice, my lord, to that is without, my lord, permission from the department, my lord. She attended the, my lord, PUC regularly student. So that is not permissible, my lord. That is.
ಅವೆಲ್ಲ notice
Yes,
ಮಾಡಿದೀವಿ
that is, my
What
lord,
is
that
this?
your lordship is, my lord, pass the detailed order, my lord, but state has taken the decision, my lord. That is the reason, my lord. Yeah. Another 10 days time may be given, my lord. You will also pay out on 25th. By that time, my lord.
No. It is not for that purpose. We will give you 2 weeks time for compliance. If you want to comply, you comply, otherwise we'll proceed. Aste. Again, we can't go on saying, no, we'll wait for orders to be
By
passed.
that
by
time,
the-
we'll,
No, we are
we'll
not
make
going to
effort,
do
my
that.
lord, to get.
In the previous order, dated 23/10/2024, we had directed. We had adjourned the matter at the request of the learned government advocate that the respondents will seek orders of stay at the hands of the Honorable Supreme Court in the SLP filed by the respondents. Full stop. We had also directed that if no order of stay is passed by the Honorable Apex Court, this court will proceed with the contempt petition. Full stop. Admittedly, no orders have been passed by the Honorable Supreme Court in the SLP filed by the respondents. Full stop. Next para. Therefore, release this matter on 27th of November 2024.
Please.
Either for compliance or to enable this court to proceed with the contempt petition in accordance with law. Yes.
CL number 15, Sri Devi Sharana Basappa.
Here I complied to office objection. Here, suit for partition and separate position, my lord. Respondent 192 filed in OS, my lord.
Fresh steps for respondent number 3.
Here I am for appellant.
You will have to take fresh steps for service of notice on
Yes,
respondent
sir.
number.
I
Yavaka.
now,
Today,
yes,
learned counsel for the appellant submits that the needful has been done. Full
Sir.
stop. Office to verify and issue notice to respond number 3.
sir, stays.
ಏನಮ್ಮ
FDP court commissioner report ಈಗ await ಆಯ್ತು.
ಇವಾಗ ಇವಾಗ ಮತ್ತೆ ಕನ್ಸಿಡರ್ ಮಾಡಕ್
Sir, already 192 are appeared. They filed in OS suit, my.
Alama, when the matter had come up for admission. At that point of time, you should have insisted for interim orders, not now.
My lord, here without appellant evidence
Not
in trial
convinced,
court, they
Huh?
passed the order, my lord.
Delay ಇದೆಯಲ್ಲ 647 days delay ಇದೆ.
Yes. They
How
are,
can we pass interim orders?
they are.
Yes.
Serial number 16, Liaquat Farid Ustad.
So I am for the respondent two, my lords.
Yes.
Kindly see, my lords, the order dated. Passed in WP at page 10, my lords. Page 10, my lords. Fourth para, my lords. It's a consideration of representation, my lords. Lords, in pursuance to the order passed in the
Considered.
page 15, my lords, they made another representation, my lords. Kindly see, my lords, on 26/8/2024 itself, my lords, the order was complied. Lords, I will file next week and with an affidavit, my lords.
ಏನದು?
Lords, there is a issue in regard.
PDA.
There is a issue in regard to.
ಸಾರ ಅನುಮೋದನೆ ಇದ್ದ ರಸ್ತೆಯನ್ನಾಗಿ ಮಾಡಿ ಸಂಚಾರಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿಕೊಡಲು
There is a issue in regard to, my lords, vending zone. Street hawkers, my lords, in one set of parts, street hawkers files frequent writ petitions from 2017. There are several interim orders, my lords. Lords, these complainants were property owners, my lords. They complain saying that, my lords, because of street vendors, they don't have access to the road to reach their shops. How? They made a representation, my lords. The Leonard Single Judge passed an order directing us to consider, my lords.
Yes.
Now, my lords, the corporation has taken a decision. A resolution is passed by the corporation saying that, my lords, we need to get, my lords, disposed of the writ petition first, my lords.
ಯಾವ writ petition?
There are several writ petitions filed by the street.
Where is the complaint?
Next week, my lords, I will file the detail with affidavit, my lords.
Learned counsel. Shri Amresh S. Roja appearing for
Lords,
Yes.
accused two, my lords, respondent two, my lords.
Commissioner of the City Municipal Council.
Corporation, my lords. Now it is a corporation.
Huh?
Now it is a corporation.
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 Vijaypura.
ಅವಾಗ ಸಿಟಿ ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್ ಅಂತ ಬರಲ್ರಿ, ಇಟ್ ಇಸ್ ಎ ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್.
ಹೌದು, ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್.
ಇಫ್ ಯು ಯೂಸ್ ಸಿಟಿ ದೆನ್ ಇಟ್ ವಿಲ್ ಬಿಕಮ್ CMC.
ಹೌದು, ಅವ್ರು
ಇಟ್ ಇಸ್ ಎ ಸಿಟಿ ಕಾರ್ಪೊರೇಷನ್ ಅಷ್ಟೇ ಇವಾಗ. ವೈ ಡು ಯು ವಾಂಟ್ ಟು ಪುಟ್ ದಿಸ್ ಸಿಟಿ ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್? Commissioner of the second respondent corporation, municipal corporation, submits that pursuant to the directions issued by the learned single judge, communication has been made to the petitioners.
Complainant number, my lords, 5. Complainant 5 specifically communicate.
Complaint number 5. Full stop. However, learned counsel seeks for a short accommodation to place
Please,
the information before this court along with complaints
please,
report.
please.
Release this matter on 20th of November.
20.
Yes.
Take notice for R1, my lord. R1
Learned
served, my
government
lord.
advocate takes notice for respondent number 1.
Please.
Applies.
Serial number 17, Mahesh Patil for withdrawal of petition.
You filed the memo for withdrawal this one.
Huh?
You filed the memo for withdrawal the appeal.
Learned counsel for the petitioner and the petitioner have filed a memo dated 3/9/2024 seeking leave of this court to withdraw the writ petition. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn.
Serial number 18, hearing on IA, Sidram Reddy, Venkana Paraddi,
Matter is called out. There is no representation for either of the parties. Full stop. Release this matter on 20th of November.
serial number 19, Ratnayan Shoyogimat,
My lord, I am for the complainant, where the accident took on 23/4/2015. And in this accident, there
Can
was,
be heard and disposed of?
Only on contempt.
No,
Appeal is filed only on contempt.
no need for trial court records?
Trial courts records are necessary.
Not necessary.
Necessary. Madam.
Necessary.
Yes, madam.
ಬಂದಿದೆಯಾ?
ಬೇಕು ಮೇಡಮ್ ಸೆಕೆಂಡ್ 3 ಡಾಕ್ಟರ್ಸ್ ಎಕ್ಸಾಮೈನ್ ಮಾಡಿದ್ದಾರೆ.
Call for trial court records.
ಡಿಲೇ ಮೇ ಬಿ ಕಂಡೋನ್. Subject to denial of interest.
Order on IA number 1 of 2018. There is a delay of 212 days in filing the appeal. Full stop. Learned counsel for the respondent insurance company
Yes, ma'am.
submits that the delay may be condoned, subject to the condition that the appellant should not be entitled for payment of interest during the delayed period. Full stop. Next para, accordingly, while condoning the delay, we direct that the appellant shall not be entitled for payment of interest during the delayed period of 212 days. Stop. IA 1 of 2018 is accordingly disposed. Call for trial court records.
serial number 20, Santosh Kumar
Well, I
Paraddi.
beg to appear for the National Highway Authority, the appellate. But there are connected appeals. But it relates to the construction of Sindhudurg highway by the state government. But the state government had acquired properties under the Land Acquisition Act for construction of a road. Thereafter, my lord, they upgraded it to state highway.
You are
And then,
appearing
my lord,
on
it-
behalf of the appellants.
I am for the appellate, my lord.
Appellant.
Yes, the National Highway Authority is for the appellate. According to us, we are not liable to pay the amounts because it was an acquisition conducted by the state government. The state government has not filed an appeal.
Then why did you not make the submission before the reference court?
But we made a submission before the reference court. We filed a written statement. He recorded our submission but did not say anything about it. He simply said that the claimant should be paid so much of an amount. He does not say anything about us. Our
And
objections, nothing.
What is your prayer in the appeal?
Not to say that we are not liable for the award amount. That is our prayer.
Pray that the honorable court may be pleased to call for records so and so. After looking into the legality and validity of the judgment and award, be pleased to quash and set aside the award. Yes.
Yes, my lord. With regard to the appellant.
Exactly the opposite argument which was made yesterday.
No. I have passed orders. on
Yes,
this,
your lordship has
taking
passed
note
orders.
of this kind of submission. Do you
Sir,
have a copy?
Sir, serial number 3, the 20.3, idralli passed order. Honorable court last occasion.
But that is an order your lordship had passed in a delay condemnation application, as I understand.
We are
But
not
your lordship is referred. And
party ಮಾಡಿದ್ರೆ
No, we called upon the state government to give any information, to say, no, the project has been handed over to National Highways and they are only responsible for everything. No information as such was available. And therefore we held, it is only the state government which is answerable and they are the contesting respondents. And these, National Highway Authority could not have been made a party. That is all. Your claim will continue insofar as the state is concerned.
If I am right, that order was passed in my appeal. MFA 31872 of 2012.
ಆಗಿದೆ ಆಗ್ಲೇ.
ಇವತ್ತು
So
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. ಆ ಕೇಸಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂತಂದ್ರೆ ನ್ಯಾಷನಲ್ ಹೈವೇ ವಾಸ್ ನಾಟ್ ಅನ್ ಪಾರ್ಟಿ ಬಿಫೋರ್ ದ ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್ ಫಾರ್ ದ ಫಸ್ಟ್ ಟೈಮ್ ಇನ್ ದ ಅಪೀಲ್.
ಅಲ್ಲರಿ, even if it is a party, the learned counsel is submitting, we have filed a statement even before the reference court saying we have not got anything to do with the question of compensation. At best, we have been handed over to take over the project and do the work aste. We have got nothing to do with payment of compensation. That stand has already been taken by them. E case, that is what is being submitted. In that case, they may not have been made a party also there. Here, they wanted, you implemented them as parties in your LAC. Correct? So it's the same thing. The order 202158 ಅಲ್ಲಿ we have already passed order. State highway ಆಮೇಲೆ ಅಲ್ಲ ಅದು ಏನೇ ಇರಬಹುದು. No. They are saying we are not beneficiaries. We are not beneficiaries. We have been handed over the project to proceed. We have not got anything to do with the acquisition process or payment of compensation. If the state government has requested us to do the work, we are doing it. We have got nothing to do with payment of compensation. That the state government will take care. That is their stand.
That's the
And
difficulty.
accordingly, we have passed this order. Idal ಮಾಡಿದೀನಿ. ಕೊಟ್ಟಿದ್ದೀರೇನ್ರಿ ಅವ್ರಿಗೆ 202158 of 2019. ಅದೇ ಅವರು ವೇಗವಾಗಿ ಇವರೇ ಕೊಡ್ರಿ ಅಂತ ಹೇಳಿ ರೆಸ್ಪಾಂಡ್ ಡೈರೆಕ್ಟೆಡ್. So therefore, that question has not been decided by the reference court. They are insisting, yes, so you please pass an order.
Go to this order, my lord, and ಇದೇ ಕಷ್ಟ ಆಗ್ತಾ ಇರೋ ಸುಮ್ನೆ. ಯಾವಾಗ when it is convenient for them, my lord, they say
Project director,
necessary or otherwise.
deputy general manager, ಇದರಲ್ಲಿ in this matter also you are the appellant.
Yes, my lord, we are the appellant. In trial court, they are impleaded as a beneficiary. But objection is taken in trial court also. They will not consider. In page number 54 is there, my lord. The statement and objection, written statement is filed by the.
And similar contentions made on behalf of the National Highway Authority, that it's clear from the material available on record that action was initiated by the state government under the provisions of the Land Acquisition Act commencing from the year 2005, much after the National Highways Authority Act came into force in the year 1988. This court has held. That was the detailed order was passed in some other.
31872, my lord.
ಅದೆಲ್ಲಿದೆ?
Look, ಇದು
ಕೊಡಿ, ಅದು ಕೊಡಿ.
ಇದರಲ್ಲಿ interim order
ಅವ್ರನ್ನ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಡಿದ್ರು.
ಆರ್ಡರ್ ಆಗಿತ್ತು 20%.
So they were not parties before the reference court. ಇಲ್ಲಿ appeal ಅಲ್ಲಿ MFA ಅಲ್ಲಿ they were made a party and therefore they filed an application.
Impleading application ಮಾಡಿದ್ರು.
Non impleading
IFR
application.
impleading.
I filed an application.
That is objected by
Appellant
them.
filed a
Filed
impleading
application that was allowed.
Seeking
After
to-
their appearance, they submitted that towards, after completion of the project, the highway was handed over to them and they had nothing to do with the acquisition or payment of the land. Lords,
That the lands were not acquired for the benefit of the third respondent, National Highway Authority of India.
same arguments. my lord.
The 4-1 notification was issued on 10/11/2020 and 6-1 notification was issued 2002. The award was passed on 30/12/2002. it was also clear from the record that the third respondent has not deposited any amount with the respondent SLAO, since the land was never acquired for the benefit of the third respondent. Nevertheless, since a portion of the national highway, which was developed by the state division of the national highway, was handed over to the National Highway Authority of India in the year 2016, it is now sought to be contended at the hands of the respondent state that the third respondent is the beneficiary, and therefore state also took that stand.
Oh, state took that stand.
State also took that stand. No, we have handed it over to National Highway Authority of India. So let them pay. And
Exactly. Now party ಮಾಡಿದ್ರು ಕಷ್ಟದಲ್ಲಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರು ಕಷ್ಟದಲ್ಲಿ. Ultimately, my lord, our awards are, my lord, these are all, my lord, the court is used as a tool, my lord, to, my lord, deny the.
And in this case, my lord,
Really, the argument is same. We are not the beneficiary because acquisition was not put at motion because of.
anyway, see, no prejudice is caused to the claimants.
Lord, this is.
Because state government is held answerable and liable to pay the compensation.
Allah, state government stand is, we are not liable now because we have handed over the project.
Yavaga 2016 ಅಲ್ಲಿ 2016,
Yes.
after the project was started, in the midway it was given to them to go on with the work.
ಅದನ್ನ ಅದೇ ತರ ಇದೆ.
My lord, may I make one submission, my lord? It was not, the project was not handed over.
Once we have
The road was
accepted
constructed,
the
it was
condition,
upgraded.
we have passed this order.
ಈ ಕೇಸಲ್ಲಿ state had satisfied the compensation amount awarded by the reference court. In the appeal filed by the landowner, government took a stand that during the pendency of the appeal, the project has been handed over to the national highway. Hence, it is also a necessary party to the proceedings. I made an application that application subsequently recording the statement submission of the council appearing for the national highway. Noting that award.
What prejudice is now caused to you? We have held that the state government is liable.
Allah, my lord, it's not the question of, my lord, prejudice caused to, my lord, recovery can be against them as well as not this person. It is, my lord, the issue of, my lord, the position of law. Lord, there cannot be two positions of law because, my lord, one, my lord, doesn't prejudice you or one prejudices you.
You
Position
see, it
law
all
has to
depends
be, my lord,
as
the
to
same.
how, it depends as to how the project has been handed over.
Allah, my lord, that's the difficulty. My lord,
That is,
the handing over of the
court is
project,
required to consider that one.
my lord, the handing over of the project is between, my lord, state and, my lord, a different authority.
Yes.
Those terms, my lord, will never come to notice to the, my lord, claimants.
Bekagilla, what is your interest now? You want the compensation to be
Allah,
satisfied.
my lord, academically, I am, my lord, with the NH. Lord, my academical stand is, my lord, beneficiary is somebody for whose benefit acquisition is initiated.
Yes.
Lord, I am with the NH.
Yes.
My only concern is, my lord, let there not be, my lord, two views, my lord, on this, my lord, by this court. My lord, that's my concern. My lord, anyhow, my lord, these orders were not known to us, my lord. We would like to, my lord, submit on this, my lord. I was not aware, but that is the position. If your lordships have taken, my lord, that will be the end result. If anything to be submitted, my lord, we will do that, my lord.
Where is that statement filed by you before the reference court?
My lord, it has been referred to, my lord, in the impugned order at page
Why have you-
14.
why
of
have you
the
not
LP, my lord, I
produced a
produced
copy?
impugned order. Page 14 of the impugned order, my lord, he's referred to our contentions, but he has not passed any, he's not considered that. He simply refers to it. Your lordship will see paragraph 6 of page 14. May I read, my lord? Respondent number 2 contends that the National Highway Authority of India has not acquired the land and that the acquisition of the land is made by the LAO in the coming under the state government. The state highway has been renamed as National Highway and the possession of which is handed over to the respondent number 2 year in the year 2013/14. Hence, the petition against the respondent number 2 is misconceived, not maintainable, and hence liable to be dismissed.
National Highway Authority of India is concerned, there's a different ground for them. The special enactment, National Highways Act
Section 11 will come.
empowers the authority itself to acquire lands. They need not ask any, the state government to
Yes.
acquire lands for them. They are empowered to acquire lands. Therefore, their stand is, the act came into force in the year 1988. That act came into force in the year 1988. And we don't depend on the state government for acquisition. If we want, we acquire the lands and we proceed in accordance with law. That is their stand. So insofar as national highway is concerned, it's a different.
That's not in dispute. The question is, my lord,
Here-
handing over of a project.
No, that is why, see, it depends on facts of the case. It is clear, we have accepted that contention that under the National Highways Act, that is what we have observed here. Correct. ಅವ್ರಿಗೆ ಪವರ್ಸ್ ಇದೆ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ. ಸೊ ದೇ ಡೋಂಟ್ ನೀಡ್ ದಿ, ಇಲ್ಲಿ ಬರ್ಕೊಂಡು ಇಲ್ಲಿ ಹೇಳಿದೀನಿ ನೋಡಿ. In the year 2016, in terms of section 11 of the National Highway Authority Act, section 11 of the act empowers the central government to issue notification in the official gazette to vest or entrust to the authority such national highway or any such thereof as vested in or entrusted to the authority such national highway or any such thereof as may be specified in such notification. Learned counsel would submit that part of the national highway was handed over in terms of section 11 of the act 1988 only for the purpose of maintenance and upkeep of the highway. ಎಲ್ಲ ಆಗೋಗಿದೆ ಮಾಡಿ, it is only handed over for maintenance ಅಷ್ಟೇ in terms of section 11. So it depends on why have you not placed all that material? What was the notification issued?
Sir, details ಇದೆ sir, appeal memo ದಲ್ಲಿ.
ಎಲ್ಲಿದೆ? Where is the notification?
2005.
ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಸಂಗಿಲ್ಲ.
Foreign notification
Which is
issued
the-
on
ಅದಲ್ರಿ, notification entrusting the highway to you. Where is that notification?
notification is not.
When was it handed over to you?
2013 and 14.
By which order? Where is that order?
My lord, if you lord, see, my lord, MFA 31872, there in second paragraph at page 3. No, they have produced a demand draft which is, my lord, issued by the Special Land Acquisition Officer, National Highway Division.
ಯಾವ್ದು?
Amounts, my lord, referring to, my lord,
31872.
the original
The
order
other-
on the basis of which the
31872.
of
Yes.
2012.
31872.
ಈ order ಅಲ್ಲಿ page number 3, my lord, second paragraph.
We have noticed all that.
Here, my lord, the payment is made by
We
national.
have noticed all that.
The National Highway Division is the state government division.
ಅದು state highways division ಅದು. We have taken note of everything.
You have to maintain the records.
Two types.
Are the owners of the.
Highway can either be a state highway or national highway. State highway, if for the formation of the state highway itself, if notification is issued, it will be issued under the Land Acquisition Act. If the National Highways Authority of India is acquiring, it will be under the National Highways Act, where the central government will notify.
No, this land is entrusted. to-
This is all notified by the state government under the Land Acquisition Act under section 4161.
ಇವ್ರು ಅಲ್ಲೆಲ್ಲ ಅವಕಾಶ ಇದ್ರು ಏನು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸಿಲ್ಲ. They have not stepped into the witness box. They have not produced.
ಅಲ್ಲ ರೀ, ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ, you know.
ಅಲ್ಲ ಈ ಮ್ಯಾಟರ್
4161 notification is issued.
ಅಲ್ಲ
by-
ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, the matter on hand, ಆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ they don't produce any of the documents.
Why have you not produced the statement of objections filed by you before the reference court? And where is the notification by which it was handed over to you?
My lord, we have not produced in the appeal, my lord. It is in the
Please
rover court
produce all
records,
that.
probably it is there.
Please
Because-
produce all that.
Yes, I'll produce it, my lord. Lordship, may kindly give me a week's time, I'll produce it. No difficulty. Because I had called for the records, but I didn't get the records.
Learned counsel for the appellant, National Highways Authority of India is requested to furnish. Trial court records ಬಂದಿದೆಯಲ್ರಿ ಇದರಲ್ಲಿ?
Yes, the low court records have come.
ಕೊಡಿ.
Not
Serial number
produced.
20.
ಇನ್ನೂ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಇಲ್ಲ ಅವ್ರ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದ್ರಂತೆ ಅವ್ರ ಆಫೀಸರ್ ಇಂದ ಅದು ಬಂದಿಲ್ಲ ಅಂತ.
ಅಲ್ಲ ಇಲ್ಲಿದು
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ದೇರ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ they are saying we have already filed a statement in this regard along with that document.
Nothing.
We can look into it. ಕೆಳಗಡೆ ಇದೆಯಾ?
Lord, your lordship may grant me a week's time. I'll produce, my lord, the objections as well as the notifications. Notifications are public document.
Furnish a copy of the statement of objections filed by the appellants before the reference court, along with the copy of the notification by which the
Yes.
project was entrusted to the appellant
Yes.
by the state government.
Yes.
Release this matter
Lordship of submission.
on
20.4 ಅಲ್ಲಿ IA pending ಇದೆ.
you know
20.4
for withdrawal of amount.
all connected matters already withdrawn, the permission is granted.
ಯಾರು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ?
National Highway Authority.
You have deposited.
Yes, my lord.
Yes, yes, we have deposited.
We cannot, because if we are allowing the appeal, we'll return the amount. It cannot be given to you.
ಇನ್ನೊಂದು ಸ್ಮಾಲ್ ಸಬ್ಮಿಷನ್
Matter on
ಸೀರಿಯಲ್ ನಂಬರ್
20th of November.
serial number 20 ಅಲ್ಲಿ first matter. Lords, respondent number 1 is dead. I have filed application to come on record as respondent number 5 and 6. These applicants, they are not the lords wife or children of the, in a family partition under registered partition deed. The land acquired lords had been allocated to the share of the applicants. Lords, hence lords, I have filed application to lords come on record as respondent 5 and 6. And I,
If the appeal itself is going to be allowed, then
Liability.
They will
Hello.
have to come up.
it would be of no consequence whether
Alla.
you come on record or not.
alone,
Because they see, we will be saying that no liability can be fastened on them.
ಇಲ್ಲ ಉಳ್ಕಿದ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಅವಾಗಾದ್ರೂ ನಾನು
This is an appeal filed by them
Yes.
contending that we are not liable for payment of compensation. So therefore, if this appeal is going to be allowed, it would be inconsequential whether you come on record or not. ನೀವು, if you have not preferred any appeal
no,
or enhancement,
no, we have not.
then you can go and state claim in respect of the compensation before the competent authority.
Because the order will be against a dead person. It may be necessary for him.
No, no.
ಅಲ್ಲ ಆರ್ಡರ್ ಅಗೇನ್ಸ್ಟ್ ಡೆಡ್
We are not saying anything in respect of the.
No.
ಅಲ್ಲ
Followed, my lord. There were two persons held to be liable. One person's liability is, my lord, absolved. Insofar as, my lord, recovery against that person, my lord, the absolvement is there. So, my lord, it's a
ಇಲ್ಲ.
formal thing, my lord.
ಅಲ್ಲ
It may be
I
necessary.
think it will have any
Right.
bearing. Yes.
My lord, serial number 32 is also.
ಇದಾರೆ ಕ್ಲೈಮೆಂಟ್ಸ್ ಇದಾರೆ, ಇದ್ರಲ್ಲಿ ಬರೋದಿಲ್ಲ. ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು, they have to work out their remedies before the competent authority. A reference court ಅಲ್ಲಿ we do not know whether this person is
no, during the pendency of the appeal, what's respondent number?
pendency of which appeal?
This
The
appeal. Yes.
What happened to the reference?
Reference, he was alive, lords, I had
He was a party
party.
before the reference
Yes.
court.
In appeal, he lords,
If there is a order passed, a judgment passed enhancing compensation, and you are also entitled to seek compensation, you will go before the competent authority. ಈ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಅಲೋ ಆದ್ರೆ we will be absolving the National Highway Authority of any liability. ಅಷ್ಟೇ ಆಗೋದು ಇದ್ರಲ್ಲಿ, ಇದು ಅದ್ಬಿಟ್ಟು ಇನ್ನೇನು ಆಗೋದಿಲ್ಲ.
ಇಲ್ಲ ಆರ್ಡರ್ ಅಗೇನ್ಸ್ಟ್ ಎ ಡೆಡ್ ಪರ್ಸನ್ ಆಗುತ್ತೇನ ಅಂತ ಹೇಳಿ, ಸಿನ್ಸ್
Sir, it is a general order considering all the claimants. The contention is that only the state government is liable to pay the compensation. I am not a necessary party. I am not going to pay any compensation. So remove me from the array of parties. That is the prayer. How can that order be said that it is passed against a dead person? Matter is contested.
Oh.
Whether he is there or not, it's irrelevant. It is the state government which has to take a stand. And we have considered the stand of the state government also earlier. And the state government will continue to be liable to pay compensation. So your recovery will be only against the state government. Yes.
My lord, serial number.
21st of November.
My lord, serial number 32 is also connected matters.
32
Serial number
is also same,
32.
my lord.
Same notification, connected matters, my lord.
32.
My lord.
So all one batch is there.
Yes, my lord. Some of the matters memo for retirement is filed earlier. Council kindly be consider retirement application.
Yardu?
Shravan Kumar Mutt is earlier appearing standing counsel. They have filed retirement application.
Shravan Kumar.
Yes, ma'am.
Now Santosh Kumar
Yes,
Marati.
ma'am. I am for the appearing.
ಇಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿ ಆರ್ ವಿ ನಾಯಕ್ ಶ್ರವಣ್ ಕುಮಾರ್ ಅಂತ ಎಲ್ಲ ತೋರಿಸಿದ್ದಾರೆ ಆ ಮ್ಯಾಟರ್ಗಳಲ್ಲಿ ಸಿನ್ಸ್ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಸಂತೋಷ್ ಕುಮಾರ್ ಮರಡಿ
Yes, ma'am.
has entered appearance for the appellant. The name of learned counsel Shri so and so may be removed from the cause. Yes. Same order. Idರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ವಿ ಅದೇ order. Let it come upon.
Lord, can it be on the 22nd, my lord? The 20th, I have some difficulty on the 21st.
No, not on Fridays.
Any other day, my lord, other than 21st, I have some personal difficulty.
You want it on 19th?
19, I am ready. Yes.
19th.
Yeah, 19 I'll get ready.
19th.
I'm obliged.
Yes.
Seal number 21.
The respondent number 1 had expired, my lord. Filed necessary applications to bring the legal representatives of respondent number 1 on record.
Respond number 1.
Yes, my lord.
I had appeared for R1. my lord.
Claimant,
Yes,
claimant.
Yes, claimant.
One of the claimants. my lord.
One of the claimant.
Lord, I will take notice for the.
Counsel Shri Harshavardhan or Mali Patel undertakes to appear for the proposed legal representatives of deceased respond number 1.
Please.
Full stop. Learned counsel would also submit that IAS number 1 to 3, which are filed by the appellant to bring on record the legal representatives of deceased respond number 1 may be allowed. Full stop. Accordingly, delays condoned and applications are abatement is set aside while permitting the legal representatives to be brought on record. Please, full stop. Learned counsel for the appellant shall carry out the amendment to the cost title and furnish amended cost title within a period of 1 week from today.
Please.
One small request, my lord. I'm told the deposit is already made. There was an order for my lord release on 25/5/2021. That was in favor of my lord.
Will not file the acknowledgement.
Acknowledgement is to be filed, my lords, but it is deposited, my lords. I'll file the acknowledgement.
My lord, the release was in favor of my lord the respondent 1 to my lord 5 claimants. Now that my lord 1 is deceased, if your lordships can clarify that, my lord, in place of 1, my lord, his LR. 25/5/2021.
You have already passed order.
Yes, my lord. There is already an order for release in favor of my lord claimants respondent 1 to 5. Since R1 is now replaced by his LRs, Lord, he will be eligible, my lord. If that is clarified, my lord, that would take care. 25/5/21.
Alle next para. Having regard to the legal representatives of deceased respond number 1 being brought on record, the order dated 25/5/2021 permitting the release of the amount deposited by the appellant in favor of the claimants, comma, it is clarified that in the place of deceased respondent number 1, comma, the legal representatives who are brought on record will be entitled to seek release of the amount.
Right.
Which defendant number 1 was entitled.
Respondent 1 was
Deceased respondent number 1 was entitled.
Yes, please. Oblige.
Serial number 22. Sheshadri Jaishankar. It's
Yes.
Appeal against conviction, my lords.
Life imprisonment. Delay for
notice stating.
delay.
Learned additional SPP takes notice for the respondent. Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures in the learned additional SPP.
Please.
Next para. There is a delay of 404 days in filing the appeal. Stop. Having regard to the fact that
Valid.
the appellant is convicted for offences punishable under section 302, 504 and 506 bracket 2 of IPC. Comma, we are inclined to condone the delay. And accordingly, delay is condoned. Yes. Yes.
Serial number 23, additional SPP.
My lords, it's a state appeal, wherein the alleged offences are 498A and 307.
Call for trial court record.
Please.
Lords, in this matter, the original complainant has filed one more appeal. That is 2,254,000 of 22. 2,254,000 of 22. That is been admitted on 12/6/24.
List this matter along with the criminal appeal 200,254 of 2022 on
12/6/24 it was admitted. As such,
their
state is also a party. As such, this appeal would not survive for any consideration.
appeal is filed by
The original complainant.
complainant.
How the 372. Now they have come up against the acquittal. Two appeals would not survive. Otherwise, one have to go. The earlier appeal filed by the complainant in the year 22 would survive. And that being admitted, the state appeal would not survive now.
Why?
ಅಲ್ಲ ಈಗ ಅದರಲ್ಲೂ ಅವ್ರ ಪಾರ್ಟಿ ಇದ್ದಾರೆ. They have a right of audience as a respondent.
So what?
Two appeals are in the common judgment of acquittal.
So what? What is there?
Victim can seek enhancement of compensation also.
ಹೌದು. ಅದಕ್ಕೆ ಅದು
For that he has filed appeal.
372 would be a wider scope.
No, for club ಮಾಡಬೇಕು.
ಆ ಕ್ಲಬ್ ಮಾಡು.
ಅದೇ
ಅದನ್ನು ಮಾಡು.
along with so and so on 25th of November.
Next matter.
Serial number 24, B. Bhima Shankar.
Suit for partition, appeal by defendant.
312 days delay.
Yes, my lords.
312 days delay.
Yes, my lords. I have placed the ex parte before the trial court, my lords. The service of the suit.
Delay ಇರುವಾಗ we can only issue notice. We'll issue notice ಅಷ್ಟೇ.
The surveyor issued the notice to me to survey the lands. For filing of a final decree proceedings, driving up of a final decree may be stayed.
Ex parte ಅಂದ್ರೆ though you received notice, you have not appeared. What can we do?
During the COVID period, my lords, during the extreme COVID period on 3/2/2021, I was unable to instruct my counsel and engage counsel for the rules of COVID rules.
What about the other defendants?
They are the other family members.
Out file ಮಾಡಿಲ್ವಾ appeal?
No, my lords.
Huh?
No, my lords.
Appeal file
File
ಮಾಡಿಲ್ಲ.
madil.
You are purchaser.
I am purchaser. Appeal by the purchaser, man.
Purchaser.
Yes,
You are contesting.
This is the collusive suit, my lords, and written statement, they admitted the plaintiff arguments.
ನೋಟಿಸ್ ಸರ್ವ್ ಆದ್ರೂ ನೀವು ಹೋಗಿ ಅಪಿಯರ್ ಆಗಲ್ಲ ಅಂತಂದ್ರೆ ಏನ್ ಮಾಡಿ?
During the period of COVID, my lords, pandemic. I'm unable to engage the counsel.
September 2023, the judgment is passed.
Judgment is passed, my
Then-
lords, but the service of notice is on 3/2/2021.
Huh?
Service of notice and placed ex parte on 3/2/2021.
Huh?
My lords, thereafter,
What were you doing till
I approached one counsel, they were stated that another notice will be issued to you, and therefore I.
after service of suit summons, defendant number 2 and 3 have put their appearance through their counsel, and defendant number 2 has filed written statement, and defendant number 3 has filed memo adopting WS. Defendants number 1 and 4 to 7 have remained absent. Hence, they are placed ex parte.
Even now also they are not taking. Now also you are not filed written statement.
I have filed a written statement with permission, I number 3, my lords. Yes. Wherein I have pleaded the other suit properties were not added to this suit.
Huh?
Other suit scheduled properties, other properties of the family were not added to the suit, my lords, for seeking partition and non-joinder of other property.
There are other properties also.
Yes, my lords.
You have identified them.
Yes, my lords, I have filed in the written statement,
Illide.
pleaded in a para number 5, my lords,
Para 5.
of the written statement.
Apart from the suit scheduled properties, the family of plaintiff is having landed property in survey number 10/4. Which was sold in favor of one Shivaya. And sold under Mugitalri.
But that has to be
Why?
included in the partition.
Why?
suit. That is a family, joint family property.
Houdri,
They are
if all
seeking-
of them have sold it.
No, my lords, partly item number 3 and 4. And this one property has. not-
9/1 measuring 2 acres, which was sold by defendant 1 in favor of one Sidramappa,
Extent of 1 acre.
and another 1 acre in survey number 69/1.
Observe ಮಾಡಿದ್ದಾರೆ. 5 to 7 are at liberty to seek the allotted property. You are 5 to 7 defendants.
5 and 6 minutes.
ಅದೇ,
5 and 7.
Your liberty is also given to you by the
To
trial
seek
court.
to allot the property purchased by them to be shared.
Equity ಮೇಲೆ ಮಾಡಿರಿ ಅಂತ ಮಾಡೋದು.
Other properties, non-joinder of other properties.
Huh?
Non-joinder of other properties also become.
Other properties ಹೆಂಗ್ರಿ ಬರ್ತದೆ? ನೀವೇ ಹೇಳಿದಿರ ಮಾರಾಟ ಮಾಡಿದಾರೆ ಅನ್ಬಿಟ್ಟು, ವಾಟ್ ಇಸ್ ದಿಸ್?
Even in your attempt, trial court has protected his rights.
ಅಲ್ಲಿ ಹೋಗಿ ಅವ್ರೇನ ಇದು ಫೈನಲ್ ಡಿಗ್ರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಯು ಪಾರ್ಟಿಸಿಪೇಟ್ ಅಂಡ್ ಯು ಸೇ ಎನಿವೇ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ has given you that liberty to work out your remedies.
Bring up a final decree.
Please see the final order, sir, operative
sir.
portion. You are at liberty to seek allotment of your property for your, to your share
Yes, ma'am.
or to the share of the
Share of
your
the
vendors.
vendor.
ಹೌದು.
Working out equities in final decree proceedings.
Total extent of land history shoot schedule ಅಲ್ಲಿ
ನೀವು ಪರ್ಚೇಸ್ ಮಾಡೋದು ಯಾವ ಪ್ರಾಪರ್ಟಿ ಇದರಲ್ಲಿ? ಪ್ರಾಪರ್ಟಿ ನೀವು ಯಾವ್ದು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರಿ? ಲ್ಯಾಂಡ್ ಸರ್ವೆ ನಂಬರ್
Survey number, notes. 9/2.
9/4
9/2 and 4.
9/2
2, my lords.
ಐಟಮ್ ನಂಬರ್ 3 ಆಮೇಲೆ ಇನ್ಯಾವ್ದು ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರಿ?
That one, my lords. 9/2.
But
For
why you are
one,
seeking that?
my lords.
For all the suit property.
Earlier it was 10 acres, my lords, and partly 5 acres and 5 acres.
ಅಲ್ಲ ನಿಮ್ಮ ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು ಸರ್ವೆ ನಂಬರ್ 9/2 ಒಂದೇ.
Yes,
But why you are seeking stay to all the
with required to that property.
ಅದನ್ನು ಈಕ್ವಿಟಿ ಮೇಲೆ ಮಾಡ್ರಿ ಅಂತ ಮಾಡಿದ್ರು.
And another,
they have noticed that you have purchased the property and therefore liberty is given to you to work out your remedies there in the final decree proceedings.
I have pleaded the
Issue notice to the respondents on IA 1 of 2024.
driving of a final decree.
ನಿಮ್ಗೆ ಎಷ್ಟು ಸೇರಿ ಹೇಳ್ಬೇಕು ಅರ್ಥ ಆಗಲ್ಲ ಹೋಗಿ. ಎಸ್
CL number 25, Levi and Chimcode, was hoping to complain.
This matter, my lord, we already comply the direction of the learned single judge. Yeah, may be permitted to.
Huh?
They already considered the, my lord, direction of the learned single judge. Tahsildar is present before lordship, my lord.
consider representation.
Yes, ma'am.
Yes.
But page number 13, my lord, of the learned single judge order. Writ of mandamus is issued directing the respondent 1 and 2 to
One and two
consider the
consider.
representation of the petitioner dated 25/5/2023 by annexure J, pass suitable orders within a reasonable time in accordance with law, not later than 3 months. But now I producing that endorsement, my lord. This land, my lord, which is seeking for grant is a Gairana land. And also, my lord, there is one public interest litigation was filed in writ appeal, my lord, that is.
For seeking grant of land.
How?
Yes, Lord.
So that is rejected, my lord, since it is a Gairana land.
Learned government advocate submits that in terms of the directions issued by the learned single judge to consider the representation given by the complainant seeking grant of land for the trust, educational trust, the respondent Tahsildar, fourth respondent Tahsildar has issued an endorsement dated nil 3/2024.
16/5/2024, my lord, it is.
16/5/2024. Stop. It is stated in the endorsement that since the land sought by the complainant trust is a Gairana land, and since directions have been issued by this court in writ appeal number 1353 of 2006, dated 18/11/2006, that no part of survey number 1403 bar * measuring 74 acres 6 guntas being Gairana land should be allotted to any person or institution, the authorities cannot grant the said land to the petitioner complainant trust. Full stop. Next para. Consequently, the contempt petition is closed while reserving liberty to the complainant trust to seek allotment of any other land or to challenge the endorsement issued in favor of the complainant trust in accordance with law.
They take notice for all the respondents.
Starting early, learned government advocate takes notice for all the respondents.
Great.
Number 26, Sanjay A. Patil.
Not appellant is convicted for life, not for the offense under section 376A and B. How read with section 12 of the POCSO Act. But he was never on bail during trial. He was not on bail during trial. That is one. The appeal may be admitted, call for records.
Should we take it that you're not pressing IA number 1?
ಇಲ್ಲ ಬೇಡ ಸರ್.
ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದಾರಾ?
ತಗೊಂಡಿದ್ದಾರೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದಾರೆ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಬೇಕು.
1 week to be posted next week.
Allah, he is saying admittedly the accused person was not on bail during the trial.
Yes.
Therefore, admit and call for records on them.
Please.
And
Admit, call for trial court. Yes. ಬಂದಿದೆಯಲ್ರಿ ಆಗ್ಲೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ. Admit.
Paper books to be. Paper books to be prepared.
ಆಫೀಸ್ ಅವರೇ ಮಾಡ್ಬೇಕಾ?
ಹೌದು.
ಪೇಪರ್ ಬುಕ್ ಬಂದಿದೆ, ಅದು ಬಂದಿದೆ. 2024 ಬಾರಿ ಫಾಸ್ಟ್ ಆಗಿದೆಯಲ್ಲ ಇದು.
Since the victim girl is 6 years old, ಹಾಗಾಗಿ earlier bench had made an order.
Yes.
Number 27, Harsha Shetty.
I'm appearing for appellants, my lords. Last date of hearing, the respondent number 4 and 5 has sought. They sought for time for filing a statement of objection on year number 2 of 24, my lords. Till date, they have not filed and we have not received the copy, my lords.
Lordship may kindly pass over, make submissions in them. Lordship may kindly pass over.
We sought for interim direction, my lords.
Interim direction.
Yes, my lords.
Objections.
During the pendency of the writ petition, my lords, the respondent have issued a recruitment notification dated 17/8/2022 and 3/6/2023, my lords. Pursuant to that, two persons were appointed in this as against the petitioner's post, my lords.
Your writ petition has been dismissed.
Yes, my lords, writ petition was
Only
dismissed.
giving you a small opening to seek regularization of your appointment, if it is
Yes.
permissible in law.
Yes, my lords. There was an interim direction by the learned single judge when we filed the writ petition, my lords. All the further proceedings pursuant to the impugn notification dated 17/8/2022 produced at annexure D is subject to the result of the writ
Correct.
petition.
Howdo, now that the finding is clearly against you, that you are aged about 46 years.
But during the time of my initial appointment, my lords, I was within the set age limit, my lords. I have put in 22 years of service. After that, the respondent has come up with a recruitment notification. That the same notification I have challenged it, my lords. And
the since you are not eligible for seeking appointment, your contentions were negative.
I have placed reliance of the reliance on judgment of the sound.
What is that you want now?
Now
what directions?
Direction, the appointment made in pursuance of the notification, two notification. After that, they have called for recruitment notification, and they have made a two ad hoc appointments as against the services of the appellants, my lords. That may be treated as lispendence, and the same would be subject to the result of the writ appeal, my lords.
The court, the learned single judge has noticed that you are no more eligible for seeking appointment because you are beyond the age. That age bar is there, so you cannot seek appointment, and therefore that is why your writ petition has been dismissed.
My lords, kindly pass over, my lords. So senior is held up in other court, my lords. 2:30, my lords, 2:30.
I have to pass over.
Serial number 28, Mahesh Patil.
Lord. The petitioner, Lord, is challenging, Lord, the order of the KT, Lord, is that 331. My Lord, the departmental inquiry, my Lord, was held against, my Lord, the petitioner and several other persons. My Lord, the punishment, my Lord, was, my Lord, the impounding of the pension, the entire pension of the, my Lord, the petitioner, along with, my Lord, the recovery of, my Lord, rupees 1 crore 87 lakhs.
petitioner.
Hmm.
My lord, the petitioner, my lord, is now retired. My lord, is working. He was earlier working as a technical assistant.
Ah.
My lord, the charges, my lord, were, my lord, that in a supervisory role, my lord, the charge memo is at Annexure A1, my lord, page 34. Page 36 is the relevant. That, my lord, ಕಾಮಗಾರಿಗಳನ್ನು ಪೂರೈಸಿದ್ದೇವೆ ಎಂದು ಸಂಪೂರ್ಣ ಹಣವನ್ನು ಪಾವತಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ನಷ್ಟ ಉಂಟು ಮಾಡುವ ಕುರಿತಂತೆ ಸದರಿ ಕಾಮಗಾರಿಯನ್ನು ಮೇಲುಸ್ತುವಾರಿ ವಹಿಸಿಕೊಂಡಿದ್ದು ನೀವು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಲಿ ಅಂತ ಮಲ ದಟ್ ಈಸ್ ದಿ ಚಾರ್ಜ್.
Where are you reading?
Please note page 36.
36.
That is the charge.
How many people are proceeded against?
My lord, there are several other, my lord, that is at page 44. My lord, there are several other, my lord, persons, my lord, around 26 here, my lord, at page 44. This is the entrustment, my lord, entrustment order. Page, my lord, here. My lord, the petitioner was working only as a technical assistant. My lord, he had, my lord, he is neither was working in supervisory role, nor he's a, my lord, a drawing and disbursing officer. My lord, absolutely had no role, my lord, whatsoever, my lord, in this episode, my lord. And my lord, throughout the inquiry, my lord, he was, my lord, requesting, my lord, and had taken contentions, my lord, that he has no role whatsoever, even of iota, my lord, of, and they have not produced, my lord, any materials, my lord, in the inquiry, nor, my lord, they have, my lord, produced any, my lord, evidence, my lord, against.
Who is it that your your contention is not accepted by the KAT?
Yes, my lord, that is, my lord, initially, my lord, there was an, my lord, interim order. My lord, KAT, my lord, they largely went on the figures, my lord, that ishtu koti agide.
Alright, if this is your contention,
please,
that I am not in a capacity or no powers are entrusted to me.
Yes, my lord.
That can be said that I have control over the matter.
Yes,
If that was your contention, how is the tribunal considered it?
May I, my lord, first, my lord, point out in the inquiry report, my lord, where with regard to, my lord, my role is discussed.
Bidri,
Please.
see, if this is your main contention,
please,
I am only a technical assistant.
Yes.
I don't have that power, financial control.
Yes.
I am not in any way given that responsibility.
Please.
It is the engineers.
Yes.
If that is the stand, how is it considered?
Yes, my lord, that is not considered at all, my lord. That is my contention. Lordship, my lord, had, my lord, they had went, my lord, on the my lord, the overall, my lord, the report, that was, my lord, page 331. They have not considered, my lord, that aspect at all. And, my lord, one more, my lord, what had happened, my lord, initially, my lord, in charge memo was issued against, my lord, individual charge memos were issued against me. Thereafter, my lord, the departmental inquiry, my lord, by the entrustment, my lord, it was entrusted under, my lord, 14A, my lord, by converting into joint departmental inquiry, my lord. And, my lord, since
Paragraph number 7 of the impugned order, whether the applicant being a technical assistant had any authority to work without the approval of the action plan or to enter into an agreement with contractors or to verify the work bill to send them to the account section.
Yes.
So you have entered into an agreement.
No, my lord, that was my contention as to have not entered into any agreement, nor contractors, nor I am an check disbursing authority. My lord, and nor I, my lord, hold any supervisory role. And even I have produced, my lord, my work allotment in the PWD code, my lord, as to what is the work of the role of the technical assistant, which is at page, my lord, PWD code, wherein, my lord, page 301, my lord, 301.
Both are holding your Already my lord, already I really for 7 months. That you permit to continue.
My lord, in respect of other court delinquents, my lord, the matter had come up before, my lord, this honorable court. My lord, in respect of all of them, my lord, this honorable court has, my lord, the stayed, my lord, on the ground that, my lord, there could not have been, my lord, initially, my lord, individual, my lord, charge memos were issued. Thereafter, my lord, it was converted into a joint inquiry. This honorable court prima facie was of the view, my lord, that such an conversion of joint inquiry, my lord, could not have been, my lord, done. My lord, because, my lord, the roles of each delinquent officials have to be specified. My lord, they could not have converted in, my lord.
Respondents are restrained from taking any further action till the next date.
My lord, all final order, my lord, stayed, my lord, in the fourth, my lord, fourth page, second para.
Adari,
Ah, ತರ
after noticing that, this was the direction given. Respondents are restrained from taking any further action till the next date.
That was the, my lord, that was the
Want
order.
similar orders.
That was the order, my lord. But here, my lord, in one more, my lord, in my, my lord, individual matter, my lord, my lord, my lord, two authorities, they have functioned as a disciplinary authority, my lord. They could not have, my lord. I belong to PW department.
All right, sir, but we can only pass similar orders. If you are saying this court has considered the writ petitions filed by other delinquent officers and they have passed this order, you will also be entitled for similar orders. That's all.
Please.
Perfect. Learned government advocate takes notice for all the respondents. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on learned government advocate. Full stop. Next para. Learned counsel submits that in respect of the co-delinquent officers, in WP number 21218 of 2024, at the principal bench, and in WP number 202489 of 2024, before this bench, interim orders have been passed directing the respondents not to take any further action till the next date of hearing. So, learned counsel seeks for similar directions. Stop. Next para. Having regard to the interim order dated on 19/9/2024 in WP number 202489 of 2024, the respondents are restrained from taking any further action against the petitioner hearing till the next date of hearing.
Please.
List this matter along with WP number so and so.
Please.
CL number 29, Section 3, Version 3.
But I am for the petitioner, my lord.
Yes.
The petitioner who is working as assistant director midday meals, my lord, had approached the tribunal, my lord, challenging the order of suspension on the ground, my lord. The committee which was constituted to investigate the matter, my lord, the members of the committee, my lord, had demanded illegal gratification for my lord submitting a favorable report. When she refused to adhere to their demands, my lord, they submitted a report against her. Based on that perverse report, my lord, I was placed under suspension. But I approached the tribunal, my lord, challenging that said order on the ground that the same is violative of Rule 10.3 of CCA rules, my lord. My lord, though the tribunal, my lord, after hearing the matter, my lord, never considered my interim prayer, my lord. Your lordship may kindly come to page 18, my lord. In fact, my lord, a order of transfer that was made on 31/7/2024, my lord, transferring me from that place was stayed by the Honorable Tribunal. During the pendency of that application, my lord, she was placed under suspension.
You have come on this interim order.
Yes, my lord. Well, no interim order is granted, my lord, not even considered, my lord. Though I had specifically pleaded and argued. There is no reference to the interim prayer either rejecting or, my lord, granting, my lord. Your lordship may kindly see page 18, my lord.
Yes.
Lord, learned counsel for the applicant has filed a memo for production of documents and same is taken on record. Learned AGA is directed to accept the notice for R1 to R3 for reply statement call on 20/12/24. No interim order. Repeatedly requested for interim prayer.
The intention is that the government advocate will have the opportunity to look into the documents and make submissions.
But my lord, I had already approached on 2 occasions, my lord. The first
next date is given.
Yes, my lord. Next date is given, my lord.
December.
Yes, my lord. 2012.
20th of December.
Yes, my lord.
That is next month.
What?
But you also direct the my lord, tribunal to my lord, consider his
prayer made.
Your lordship may kindly see proviso to section 24 of the Administrative Tribunal Act, my lord.
Lords may given liberty to him to move this matter, my lord, before the tribunal. And you will also direct the
My lord,
tribunal.
let there be an interim order, my lord. When I have specifically sought for interim prayer, my lord, not even no order is passed on the interim prayer. Kindly see proviso to section 24 of Administrative Tribunal Act, my lord.
Yes, of course, it has got power. It has got powers to pass interim orders.
Yes,
there is no doubt about it.
Yes.
Yes.
No orders have been passed, my lord. And in fact, my lord, in the previous order, my lord, where I had challenged the order of transfer, my lord, transferring me from the said place, my lord, the tribunal has considered and my lord, they have granted an interim order of stay. I produced that, my lord. Your lordship may kindly come to page 84, my lord. '86 is the order, my lord. A detailed order has been passed, staying the order of transfer. And during the pendency of this application, they could not have placed me under suspension, my lord. Page 86, my lord. Last paragraph. The learned counsel for the applicant urges that the applicant working as assistant director midday meal scheme at Taluk Jevargi, Kalaburagi, he was posted to the said place by way of counseling by an order dated 22/4/22. The said post is a specified post covered under the Karnataka State Civil Service Regulation of Transfer Act 2020. As per that, posting of the said post is by way of counseling or by government in exceptional circumstances. Therefore, the present order issued relieving the applicant from the post of 4th respondent with the direction to report to the 6th respondent is without authority. The CEO has no authority to issue such an order and to post the respondent number 7 to the said post. Therefore, the learned counsel for the applicant sought for grant of interim order, directing him to report to the 4th respondent and posting of some other person to the consent. The learned AGA states that the 4th respondent, on considering the applicant is not discharging the duties properly on instructions, 5th respondent on such order is issued to get information and to make submission. On considering the submission made by the counsel for the applicant and also the learned AGA for respondent 1, 3, and 5, I am of the view that the post of assistant director midday meals is covered under section 8 of the Transfer Act 2000 and posting of the said post by way of counseling and in exceptional circumstances by government as provided therein. Therefore, the authority alone is competent to take action to shift the government servant from the place where the 4th respondent has no authority. In view of the said circumstances, I am of the view order required to be stayed. Accordingly, the order bearing number so and so is stayed. This order was passed on 18/9/2024, my lord. And on 31/10/2024, my lord, I have been placed under suspension. Earlier also, my lord, I was placed under suspension by an order dated, my lord,
You
27
are
12
working as assistant director.
Yes, my lord, assistant director.
Assistant director.
Yes, ma'am.
How is it that this transfer of teachers would apply to you?
Lord, I am a assistant director, my lord, and a specialized work, my lord, on counseling. I have been posted to that work, my lord. As a teacher, my lord, it is a special. That is the 2020 Act provides for the my lord, the filling up of these posts, specialized posts, my lord, including the assistant director of midday meals through counseling after passing a prescribed examination. And on passing the prescribed examination, the list is prepared, my lord. As per that list, seniority list, my lord, select list, my lord, the counseling is held to fill up these assistant director midday meals, my lord. It is under the Sarva Shikshana Abhiyana scheme, my lord.
And thereafter, you withdrew the application.
My lord, that is, my lord, when the order of suspension was withdrawn and the order of suspension was revoked, I withdrew my application. Thereafter, I was transferred. That order was also challenged. That order of transfer order was challenged, my lord, and the stay was granted on 18/9/2000, on 4/9/2024. Now, my lord, once again, I have been placed under suspension during the pendency of the said application. The headmasters of the high school, my lord, are permitted to write those exams. It is my specific contention, my lord, to accommodate one Babu Chittapurkar, my lord, I have been placed under suspension, and even transfer was also to accommodate him.
See that that application and the interim order that you read
Yes,
out.
Yes, ma'am.
In application number
2373, 2173.
That was only
yes,
in respect of
yes, ma'am.
your transfer. They sought
Yes.
to transfer you.
Yes, ma'am.
Nothing else.
Yes, ma'am.
But after that, show cause notice has been issued to you.
Yes, my lord, I submitted my explanation. Without considering the explanation, my lord, they proceeded to place me under suspension. And it was my specific contention, my lord, before the third respondent that the committee which has submitted a report, my lord, had in fact demanded, my lord, amount to submit a favorable report. Based on that investigation committee's report, my lord, I have been placed under suspension. Your lordship may kindly see the ground which I have specifically taken in the application, my lord, at page. At page 28, my lord. The applicant respectfully submits that the alleged irregularities regarding supply of food grains and other materials to the schools have been denied by her from time to time to the show cause notice issued by the third respondent. Third respondent proceeded to investigate the matter by constituting a committee who in fact demanded illegal gratification for submitting a favorable report, and on refusal of the same by the applicant, a perverse report has been submitted based on which the applicant is being placed under suspension.
Page number 55, my lord, for a moment, my lord. Page number 55. This is the evidence, my lord, in her mobile only. ಸದರಿಯವರ ವಿರುದ್ಧ ಆರೋಪದ ಕುರಿತು ಪ್ರಾಥಮಿಕ ವಿಚಾರಣೆ ಕೈಗೊಂಡು ಶ್ರೀ ಸೂರ್ಯಕಾಂತ ಮದಾನೆ ಉಪನಿರ್ದೇಶಕರು ಶಾಲಾ ಶಿಕ್ಷಕ ಇಲಾಖೆ ಕಲಬುರಗಿ ಈಶ್ವರಪ್ಪ ನಿಡಗು ಶಿಕ್ಷಣಗಳು ಜಿಲ್ಲಾ ಪಂಚಾಯತಿ ಕಲಬುರಗಿ ಮತ್ತು ಹಾರ್ನಾಳ್ ಜಿಲ್ಲಾ ವಯಸ್ಕರ ಶಿಕ್ಷಣ ಕಲಬುರಗಿ ಇವರುಗಳಿಗೆ ಸದರಿಯವರು ಮೊಬೈಲ್ ಮುಖಾಂತರ ಸಂದೇಶ ಕಳಿಸಿ ತ್ರಿಸದಸ್ಯ ಸಮಿತಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ವರದಿಯನ್ನು ನನ್ನ ಹುದ್ದೆಗೆ ಧಕ್ಕೆಯಾದಲ್ಲಿ ತಮ್ಮ ಹೆಸರಿನಲ್ಲಿ ಡೆತ್ ನೋಟ್ ಬರೆದಿಟ್ಟು ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಳ್ಳುವುದಾಗಿ ಮತ್ತು ಸದರಿ ತ್ರಿಸದಸ್ಯ ಸಮಿತಿಯು ಸದಸ್ಯರು ಗುಂಡುಗಳನ್ನು ಬಳಸಿಕೊಂಡು ಕೊಲೆ ಮಾಡುವುದಾಗಿ ಬೆದರಿಕೆ ಹಾಕಿ ಸದರಿ ಅಧಿಕಾರಿಗಳು ಮಾನಸಿಕ ಹಿಂಸೆ ನೀಡುತ್ತಿರುವುದು ಉಲ್ಲೇಖ 4 ದಿನಾಂಕ 10/8/2024 ಮೂಲಕ ಸದರಿ ಅಧಿಕಾರಿಗಳ ಮೇಲೆ ದೂರು ಸ್ವೀಕೃತವಾಗಿದೆ. ಒಬ್ಬ ಸರ್ಕಾರಿ ನೌಕರರಾಗಿದ್ದುಕೊಂಡು ಮೇಲಾಧಿಕಾರಿಗಳ ಮೊಬೈಲ್ ಸಂದೇಶದ ಮೂಲಕ ಈ ತರಹದ ಸಂದೇಶ ಕಳಿಸೋದ್ರಿಂದ ನಿಮ್ಮ ಕರ್ತವ್ಯ ಎಸೆದು ಮೇಲೋಟು
When I had submitted a representation stating that there is a demand for illegal gratification and they proceeded to submit a report against me, my lord, I had no option but to, my lord, say.
From where will they get the information through your mobile now?
No, my lord, my submission is this, my lord, I had
Please
specifically.
understand, they are saying you have sent these messages from your mobile. They have given the mobile number.
My lord, only it all happened, my lord, only after, my lord, I submitted on their demand. When I refused to adhere to their demand, my lord, a perverse report has been submitted. Based on that, they could not have placed me under suspension.
Let the tribunal consider. Anyway, no orders have been passed.
Let there be a direction to pass interim order, consider my interim order, my lord.
Learned government advocate takes notice for response number 1 and 2. Notice to respond number 3 is not necessary for the following reasons. Next para. The writ petitioner is before this court aggrieved of the fact that the Karnataka State Administrative Tribunal has not passed any orders on the interim prayer made by the petitioner along with the application number 2155 of 2024. Full stop. Next para, having heard the learned counsel for the petitioner, the learned government advocate, and perusing the petition papers, we find that serious allegations have been made against the petitioner. More so in respect of a mobile message, a message sent through the cell phone of the petitioner to the members of the inquiry committee.
Investigation committee. Full
stop. On the other hand, it is the contention of the petitioner that the members of the inquiry committee have sought for illegal gratification at the hands of the petitioner for giving a favorable report. Full stop. Next para. We are therefore of the considered opinion that if the tribunal has directed the learned government advocate to accept notice and secure instructions, the tribunal has given some time to the respondents to secure instructions and make submissions having regard to the interim prayer made in the application. Full stop. However, learned counsel has pointed out that the matter has been adjourned to 20th of December 2024 for the reply statement of the respondent. Stop.
May I submit?
Therefore, the learned counsel would submit that this court should consider the interim prayer made by the petitioner. Full stop. Next para. Having regard to the narration made herein above, we are of the considered opinion that the tribunal is required to expedite the process of consideration of the interim prayer made by the writ petitioner in the application before the tribunal. Full stop. Accordingly, the writ petition stands disposed of with a request to the the Karnataka State Administrative Tribunal to consider the interim prayer made by the writ petitioner in the application.
May I submit?
Ah,
Lord, the Kalaburagi bench, my lord, because of a retirement of judicial member, my lord, is sitting
Only
only on
Friday they are
Fridays. my
sitting.
lord.
only
let it-
Fridays.
Yes, my
Only
lord.
on
Only
Friday.
Friday.
22nd, my lord.
We are also informed that the Kalaburagi bench of the tribunal, KSAT, is sitting only on Fridays.
Yes,
Full stop. Therefore, the matter may be taken up on 22nd
please.
of November 2024 for consideration of the interim prayer made in the application.
Please.
Stop. Ordered accordingly.
Please.
Hearing matters, CL number 30, Ilappa Yero.
Lord, I am for the petitioner. Petitioner is suspended on 3 to 4 occasions. On an earlier occasion, on learned KT as well as this honorable court have set aside the suspension orders. To begin with, my lord will peruse annexure A1, where I have been suspended at page number 35, annexure A1, page number 35. This suspension order has been stayed by the KT, annexure A2, page number 43. Subsequently, the suspension order has been set aside by annexure A3. Lord will peruse page number 51.
Please wait. A1.
Suspension order.
You are before this court on an interim order or final order?
Interim order.
Interim order.
Yes.
A1. What are the allegation?
Allegations, my lord, I have given recommendation for sanctioning of private traded schools without going
Private?
into that. Not only myself, not that there are 8 to 10 persons who are all
16 of
involved.
them.
I was BO at that time.
Ah,
The allegation is that I have recommended for admitting their schools into 8.
grant in aid.
Yeah.
Ah,
That has been stayed by the Honorable KT and it has been allowed. That suspension order has been set aside.
ah.
Followed by mod annexure A4. Once again, I am suspended.
On the same ground.
No, if this side, my lord, this time it is different ground. My lord will peruse page number 62.
Ah.
The ground is that during
SSLC
the
ಪರೀಕ್ಷಾ ಕಾರ್ಯ ನಿರ್ವಹಿಸುವಲ್ಲಿ ವಿಫಲರಾಗಿ ಕರ್ತವ್ಯ ಲೋಪ ಎಸಗಿರುವ ಸಂಬಂಧ.
I was to monitor examination centers of entire district
Ah.
by sitting at a particular place.
Ah.
There, my lord, there are connectivities, my lord, internet problems. There are certain schools I could not monitor. On that ground, I am suspended as per annexure A5. Annexure A4, this annexure A5 I filed. Thereafter, my lord, I am advised to take back and make an application. My lord will find page number 70, annexure A6.
ಅಲ್ಲರಿ A4 you questioned again before the tribunal.
Suspension order.
For the tribunal or before?
Tribunal. Yes.
Ah.
Tribunal in application number, my lord will find at page number 70, annexure A6. Application number 20537 of 24. Subsequently, my lord, been advised to withdraw the application and make an application before the authorities. Accordingly, I approached this honorable court in WP number 201024. My lord will find annexure A5, page number 65. With the permission of this honorable court, I have withdrawn with a liberty to make representation before the authorities.
To withdraw the application and give representation to the competent authority
Yes.
for revocation of
Yes.
suspension.
Yes.
Ah,
Annexure A7, my lord, I have given representation. This representation came to be rejected as per Annexure A8. My lord will find at page number 79, Annexure A8. Not considered and this has been rejected. While rejecting, my lien has been shifted from Bijapur to Mangalore. My lord will find page number 81. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮಾನ್ಯ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಸೋಂಡ್ಸೋ ತೀರ್ಪಿನಲ್ಲಿ ನೀಡಿರುವ ಅವಕಾಶದಂತೆ ಶ್ರೀ ಸೋಂಡ್ಸೋ ಅಮಾನತಿನಲ್ಲಿರುವ ಉಪನಿರ್ದೇಶಕರು ಶಾಲಾ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಇವರು ಅಮಾನತು ತೆರವುಗೊಳಿಸಿ ಸ್ಥಳನಿಲ್ಲಿಸಿಗೊಳಿಸುವಂತೆ ದಿನಾಂಕ 3/5/24 ಮತ್ತು 9/5/24 ಸಲ್ಲಿಸಿರುವ ಮನವಿಗಳನ್ನು ತಿರಸ್ಕರಿಸಿ ಆದೇಶಿಸಿದೆ. ಮುಂದುವರೆದು ಸದರಿಯವರ ಲೀನನ್ನು ರೀಡರ್ CTE ಮಂಗಳೂರು ಇಲ್ಲಿಗೆ ಸ್ಥಳಾಂತರಿಸಿ ಆದೇಶಿಸಿದೆ. ಐ ಹ್ಯಾವ್ ಬೀನ್ ಶಿಫ್ಟೆಡ್. Accordingly, my lord, I made a representation to the authorities annexure A9 to make my suspension allowance from Mangalore office only. That is my request. Having been shifted my lien, I requested the authorities to pay my substitution allowance from the Mangalore office. That is annexure A9, my representation. Lord, once again, I approached KT Bangalore bench because my lien is shifted to Mangalore and I have to approach invariably to principal bench. Principal bench has stayed the order.
with what prayer?
Suspension order of annexure A4, which I withdrawn with liberty to file representation. Representation rejected. Once again, I approached KT because my lien is shifted to Mangalore. My jurisdiction comes to Bangalore. I approached KT Bangalore. KT Bangalore has stayed the order. My lord will find at page number 84 is annexure A10. Operative portion, my lord will find at page number 86 and 87. Learned counsel for the applicant personally present. Heard their learned counsel for the applicant on the interim prayer of stay of the impugned order under annexure A20 and 25. I have perused the pleadings and also the documents produced by the applicant. So also consider the oral submission made by the learned counsel for the applicant. After perusal of the entire materials, I am of the considered view that the impugned suspension order bearing number so-and-so annexure A20 and impugned government order bearing number so-and-so dated 35/20/2024 annexure A25, both orders passed by the first respondent are hereby stayed till next annexure A8 and A10. And my lord will find annexure A11, authorities have considered and I am posted back to Bijapur as DDPI. ಶಾಲಾ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ಉಪನಿರ್ದೇಶಕರು ಹಾಗೂ ತತ್ಸಮಾನ ವೃಂದದ ಅಧಿಕಾರಿಯಾದ ಸೋಂಡ್ಸೋ ಶಾಲಾ ಶಿಕ್ಷಣ ಇಲಾಖೆ ವಿಜಯಪುರ ಇವರನ್ನು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋಂಡ್ಸೋ ಅಮಾನತನ್ ಇವರಿಗೆ ಮುಂದುವರಿಸಿ ದಟ್ ಮೀನ್ಸ್ ಐ ಹ್ಯಾವ್ ಬಿನ್ reinstated as DDPI Bijapur. Again, my lord, the application which I filed before the principal bench has been dismissed. Annexure A12. Main order has been passed and it has been dismissed. I approached principal bench in writ petition annexure A16, A13, page number 116.
Your application is dismissed.
Dismissed. KT dismissed. KT Bangalore bench has dismissed. Earlier it has granted interim stay. Subsequently, my main application has been dismissed. My lord will find annexure A13, page 116. Agreed by order of the KT Bangalore bench. I approached the principal bench in writ petition number 25800 of 2024. My lord will find it annexure A13, page 116. And honorable principal bench, my lord, part of the bench, and granted an entry order of status quo. That is page number 117. My lord will find operative portion.
As on today.
As on that date.
ಅದೇ status quo as on today. ಅಂದ್ರೆ ಏನರ್ಥ?
ನಾನು DDPI ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
No. By that time, order of suspension is already passed. Then
order of suspension has been stayed, followed by dismissal of the application.
21st of September 2024, isn't it?
Yes.
Order was passed by the tribunal when?
10th September. 10th September.
So allige, on the date when this order was passed by the principal bench, It simply said status quo as on today. What was the status
On that day,
on that day?
I was working as DDPI,
How?
but by virtue of the stay order and authorities passing the order, reinstating me as DDPI Bijapur.
Sir, you continued till
Yes.
that order was passed by the
Yes,
tribunal.
dismissal, till dismissal, I was continuing. I was in the office. After dismissal, order is, dismissal order is passed on 10 September.
10th September.
Yeah, 10 September.
Ah,
And I approached the Honorable High Court Principal Bench on
ಆಯ್ತು ಇರ್ಲಿ
24/9.
correct.
Stay
This
order is
order was passed on 21st of September.
10th September. Dismissal order.
ಅಲ್ಲಲ್ಲ
Stay order.
Stay
Status
order
quo. Yes, yes.
was passed on 21st of September.
Yes.
It said status quo as on today shall
Yes,
be
ma'am.
maintained.
Yes, yes, yes,
Yes.
yes. I was in office on that day.
That is your
Because
contention.
the simply dismissal order was not implemented till then.
Ah.
Certified copy I obtained, immediately rushed to
ಸರಿ
Honorable High Court. Stay.
ಆಯ್ತು.
Okay. Leave blank. Next, Annexure A14, one more suspension order is issued.
That is
Supersession of all earlier orders. My lord will find Ulleka 2, page number 119, suspension order.
14/10/2024.
Yes. ಇದರಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ನಲ್ಲಿ ಉಲ್ಲೇಖ 2 ಮತ್ತೆ ಉಲ್ಲೇಖ 3 ಕೋಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇವೆರಡು ರದ್ದಾಗಿವೆ. Annexure A3, that is ಉಲ್ಲೇಖ 2, 30/30/1/24 ಗೆ. I request my lord to peruse Annexure A3. Annexure A3, my lord will find
Again, you
page
are
number
suspended.
61.
Yes.
Page number 61.
Yes.
30/1/24 ಆರ್ಡರ್ ರದ್ದಾಗಿದೆ. ಇಲ್ಲಿ ಕೋಟ್ ಮಾಡ್ತಾರೆ ಮತ್ತೆ ಉಲ್ಲೇಖದಲ್ಲಿ, ಎರಡನೇ ಉಲ್ಲೇಖದಲ್ಲಿ. Now followed by third ಉಲ್ಲೇಖ, that is ಸರ್ಕಾರದ ಆದೇಶ so and so. This is Annexure A14, Annexure A4. Just quoting those two orders, once again I am suspended.
Yes.
Again reiterating Annexure A1, that is on which ground I am suspended. Once again, all those officers are also involved. Along with them, I am suspended.
Yes.
And I approached KAT. KAT has directed a learned government advocate to take notice. And as far as the stay is concerned, declined to grant. Operative portion, my lord will find at page number 128 and 129. Uma Devi, my lord has specifically directed the government advocate when already tainted my lord, the officer is there. She has been given charge of this post. And my lord has directed government advocate to find out whether she has been given charge or whether she is still holding the charge.
No, we are given to the other charge.
That is what I'm only bringing to my lord's.
ಏನಾಯ್ತು? What happened after 14/10/2024?
I approached KT, my lord.
What is this, Annexure A15?
Annexure A15, Annexure B. Annexure B.
What is Annexure A15?
A15, my lord, status code. Annexure A15,
ಅಲ್ಲಲ್ಲ.
the charge has been given to a tainted officer along with me who has been.
ಸರ್ಕಾರದ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಆಡಳಿತ ಹಿತದೃಷ್ಟಿಯಿಂದ ಶ್ರೀಮತಿ ಉಮಾದೇವಿ ಸೊನ್ನದ್ ಪ್ರಾಂಶುಪಾಲರು ಸೋನ್ಸ್ ಇವರಿಗೆ ಉಪನಿರ್ದೇಶಕರು ಹುದ್ದೆಯ ಪ್ರಭಾರವನ್ನು ಹೆಚ್ಚುವರಿಯಾಗಿ ವಹಿಸಿ ಆದೇಶಿಸಿದೆ.
ಇಲ್ಲಿ my lord will find on page number 122. She is also there along with those officers who have been charge sheeted.
In that
Annexure A14 suspension order. And KT has taken this, my lord, plea. How can a charge be given to a tainted officer along with the applicant? Based on that, my lord, our ಹೆಸರು ಇದೆ ಇಲ್ಲಿ. ದಯವಿಟ್ಟು page number 9.
Respond authorities also going to initiate a departmental inquiry against Uma Devi. Under this circumstance, it is just necessary to direct respond authority to make necessary arrangement to take additional charge of the post of applicant other than Srimati Uma Devi is also facing similar charges.
We given to the charge for the other person.
Not made out any prima facie case insofar as suspension is concerned.
Page number 122 ನಲ್ಲಿ her name finds place at item number 9.
Why is it that you did not file a contempt petition before the principal bench?
Against what one?
You said
Status quo.
there is an order
Status quo.
passed on
Ah,
21st
yes,
of
yes.
September 2024.
Status quo, status quo. man.
Status quo as on today shall be maintained.
Yes.
ಅಂತ ಅಂದ್ಮೇಲೆ
ಹಾ.
how could they pass this government order on 1410?
That is what my grievance is. That is my grievance.
Remedy is contempt.
I could not file like that.
Why?
I approached,
ಹೋಗಿ ಈಗಲೂ ಫೈಲ್ ಮಾಡಿ.
ಇಲ್ಲ. Now I am placed back to Bijapur as DDPI.
How, sir?
By virtue.
They could not have passed this order when there is a direction issued by the principal bench that parties shall maintain status quo as on today. How could they pass this government order?
Only government.
Would it not amount to contempt of the order passed by the principal bench?
Only government can answer.
No,
Only
you
government.
should tell what was your remedy.
Well, once again, I am suspended. Agreed by that time.
Adhe re, this order of suspension could not have been passed in the light of the interim directions given by the principal bench.
ಇಲ್ಲಿ ಚಾರ್ಜಸ್ ಬೇರೆ ಮಾಡಿದ್ದಾರೆ. Annexure A14 ಅಲ್ಲಿ ಚಾರ್ಜಸ್ ಆರ್ ಮೇಡ್ ಡಿಫರೆಂಟ್ ಚಾರ್ಜಸ್. ಅಲ್ಲಿ SSLC ಇತ್ತು. ಅದರಲ್ಲಿ A14 ಅಲ್ಲಿ
21st of September 2024 was on which suspension order?
again A4.
The last one.
A4. The last one is A14.
Different charge, my lord. That is different charge. my lord.
Charges are different.
Here, my lord, this is the annexure, which is, my lord, my learned friend is challenged before the KAT. That is entirely different. That is page number 121. 9 charges are there.
Huh?
9 charges, page number 121. Annexure A4 charges is
ಇಲ್ಲೂ
different.
ಎಲ್ಲ ಆಫೀಸರ್
This is the
ಇನ್ವಾಲ್ವ್
entirely
ಮಾಡಿದ್ದಾರೆ.
different.
ಎಲ್ಲರನ್ನು ಸೇರಿಸ್ಕೊಂಡಿದ್ದಾರೆ ನನ್ನ ಜೊತೆಯಲ್ಲಿ. A1 ರೀತಿನೇ ಇಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
That, my
A1
lord,
is in fact set aside.
Enquiry, my lord, will conducted against all the officials who are involved in this, my lord. Page
ಮತ್ತೆ
number
ಉಲ್ಲೇಖದಲ್ಲಿ
121
1,
ದಲ್ಲಿ
2 ಸೇರಿಸ್ತಾ ಇದ್ದಾರೆ. ಅದು ಅವೆಲ್ಲ ರದ್ದಾಗಿ ಹೋಗಿವೆ.
Some of the, my lord, given the applicant by colleges given the application, that is not at all considered, and there is no intimated to them also. There is no chance to them to appeal also. Reasoning, my lord, kindly see, 100 page number 122. ಒಟ್ಟಾರೆ ವಿಜಯಪುರ ಜಿಲ್ಲೆಯ 2024-25 ಸಾಲಿನ ಸಲ್ಲಿಕೆಯಾಗಿರುವ 122 ಅರ್ಜಿಗಳನ್ನು ನೇಮಸಾರ ಪರಿಶೀಲಿಸಿ ಇತ್ಯರ್ಥಪಡಿಸುವ ಪ್ರಕ್ರಿಯೆ ಸರಿಯಾಗಿ.
Please come to page number 89. Application number 1984 of 2024.
Yes, my lord.
This application is regarding which charge?
SLC, Annexure A4. Annexure A4.
That is the second one.
Yes.
Correct? Huh?
Yes.
You are still on that one only.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಅದು KT ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಸ್ಟೇ ಆಯ್ತು ಮುಂಚೆ. ನಂತರ ಅದು ಡಿಸ್ಮಿಸ್
ಆಯ್ತು.
Correct.
Yes.
That upheld our suspension.
ಏನ್ ಚಾರ್ಜ್ ಇದು?
ಅದು Annexure A4 ಅಲ್ಲಿ the charge was
Sir, A4
page number 62. ಅದು SLC ಮೇಲೆ ಬಂದಿದ್ದೇನೆ. I was suspended on SLC examinations irregularities. Web hosting. My web hosting exercise was to be done throughout the
Page
entire
number-
district.
Page number 63, my lord.
Allah re, this application in page number 89 pertains to which charge, sir?
Annexure A4,
Annexure A4.
Where do you find that?
page number 63, my lord, that is
62 page number.
Point out from this order, sir. 89. Because that is 2024 application.
impugned order 15.
Cannot be in respect of A4. It is
ಅಲ್ಲ,
in
withdraw
respect of
ಮಾಡ್ಬೋದು.
A14 only.
Application was filed before KT
15-4.
Kalaburagi bench.
So please point out which is the charge that you had challenged there.
My lord, same. Annexure A4 charges.
ಹೌದು. Page number 90 ದಲ್ಲಿ
First, impugned order dated 15/4/2024
And 34-24.
and
35-24. Annexure A8 and Annexure A10.
Huh?
Annexure A4 and Annexure A8. My lord will find Annexure A8, A4, 15/4/24.
Thereafter, he given the representation brought, revoked the suspension, my lord. That is rejected. They are.
That application is 35.
SSLC ಪರೀಕ್ಷೆ.
ಹೌದು.
SLC ಪರೀಕ್ಷೆಯಲ್ಲಿ ವೆಬ್ ಹೋಸ್ಟಿಂಗ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. As a DDP, I should monitor entire district.
Correct.
They said that there are irregularities and there
Correct.
is lapse. On that I was suspended.
Correct.
That is annexure A4.
Correct.
ನಾನು KIT Gulbarga ಹಾಕಿದೆ. Later on, I have on declining interim prayer, I approached this honorable court. This honorable court advised me to make an application. I withdraw.
Correct.
Annexure A4. That is proceedings. After withdrawing, I made a representation annexure A7. It came to be rejected as per annexure A8. Having rejected, I approached KIT and KIT has stayed as per annexure A10.
Status quo.
Status quo. Annexure A8 granted interim. Annexure A9 ಅಲ್ಲಿ ನನಗೆ ವಾಪಸ್ ಕಳಿಸಿದ್ರು. ಮಂಗಳೂರಿಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಕಳಿಸಿದ್ರು.
That was regarding SSLC examination.
Yes, web hosting. Entire proceedings.
So what we are asking you is this order of the principal bench.
Yes, this is against that SLC only. Yes.
When there is an order of status quo
Against that.
maintained, how could they pass this government order is what we are asking you.
Yes. That is my grievances.
ಮತ್ತೆ?
Despite of there being
Then what
status
is your
quo.
remedy?
But
Contempt petition.
ಅದು contempt suspension charges are different.
Yeah.
ಅದು ವೆಬ್ ಹೋಸ್ಟಿಂಗ್ SLC ಇದು. ಇಲ್ಲಿ ಮತ್ತೆ ಅವರು ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಗಳಿಗೆ ನೀವು ಶಿಫಾರತ್ ಮಾಡಿದಿರಿ, ಸರ್ಕಾರಿ ಬೊಕ್ಕಸಕ್ಕೆ ಹಾನಿಯಾಗಿದೆ, ಸುಮಾರು 8 ಜನರಿಗೆ they have issued charge sheet.
Now we will come to A14. A14 is what charges?
On page number 63, my lord.
A14.
ಅದೇ A14 ದಲ್ಲಿ page number 122, 121. ನಾಗ್ನೂರು ಉಪ ನಿರ್ದೇಶಕರು ವಿಜಯಪುರದಲ್ಲಿ ಇವರು ನೀಡಿರುವ ಲಿಖಿತ ಹೇಳಿಕೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. After considering his reply, my lord.
Is regarding which charge?
This is the, my lord, fresh charges, my lord, against the applicant.
One more.
Yes, my lord, because, my lord, there is a different, my lord, charges. Earlier charges is different. That is only pertaining to the SSLC board exam.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಬೇರೆ.
Same charges are
ಬೇರೆ
for this.
ಇದಾ?
ಇದು ಮತ್ತೆ ಬೇರೆ.
ಪ್ರೈವೇಟ್ ಏಡೆಡ್ ಸ್ಕೂಲ್ಗಳಿಗೆ ಶಿಫಾರತ್ ಮಾಡಿ ಗ್ರಾಂಟಿನ ಅಡ್ಮಿಟ್ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದ್ದೀರಿ.
Higher authorities approval ಮಾಡಿ he sanctioned the, my lord. There is a serious allegation against him.
As many as 9 officers are there in this.
But serial number 3 then.
In respect of those charges.
All are charge sheeted.
ಅದು A1 ಅದು
A1. ಅಲ್ಲಿ 9 ಜನ ಇದ್ದಾರೆ.
This is also pertaining to
Yes,
A1 only.
Yes.
A14
of
the same
charges.
A1.
Yes.
You said that A1 has been stayed.
Set aside. Annexure A3, my lord.
Has been set aside.
KIT has set aside. 30th January. Kindly see annexure A3. KIT has set aside. Page number 61. My lord will see.
61.
Page number 61. KIT has application is allowed. The application is allowed.
Correct.
Annexure A1 suspension order dated 30th January is set aside.
That impugned order, annexure A7, has been quashed and set aside. That
Yes,
is the
A1,
order of suspension.
A1. Yes.
Order of suspension.
Yes.
Admel, you were reinstated. You were reinstated.
Yes.
Isn't it?
Yes.
Now, what is this A14?
A14 is present suspension order on the ground that all 8 to 9 persons we have recommended to the government for admitting the schools, private schools into granting aid. And thereby Sarkar Bokosake loss madidiri anta charge. Lord, main intention is to remove me from that place and post their candidate. That is my grievance. 3 ಸಲ ಸಸ್ಪೆಂಡ್ ಮಾಡ್ತಾರೆ ನನಗೆ ಅಲ್ಲಿ ಅದೇ ಪೋಸ್ಟ್ ಲಿಂದ. And honorable courts set us interferes and this set aside the suspension orders.
We'll continue at 2:30.
Submission. Syllabus 33 met good is there. Syllabus 33 met good is there. Next week any date.
No date fixed.
With the lordship kind permission, serial number 27, my lord. It got passed over. 19th. Last time Leonard Pen took for time to file the counter. He did not file the counter. That is why my colleague was there. 19th you lost me.
You want it on 20th?
19th.
Mr. Lakshminarayan.
Sorry, 19th.
Serial number 27, at the request of learned senior counsel Sri Lakshminarayan, appearing for the appellants, released this matter on 19th of November. Yes.
Finally, sir. Bill number 45, last year your lordship ordered my lord to keep parties present. All the parties are present, my lord, they have to go to again their 45, sir.
Yeah, family court matter.
Family court and partition suit, sir. Even if it is taken by 230, my lord.
We were saying that
Eight
ikade 5 jana ಆಗ್ತಾರೆ, ಆ ಕಡೆ 3 jana ಆಗ್ತಾರೆ.
They are ready to give allowed 19 acre, 38 guntas they want to retain. And remaining 16 acre, 10 guntas land they want to give to the appellant.
You should put it to the other side.
I am also for same with this.
Then who is on the other side?
I already intimated this, my lord. I already intimated. If the matter is taken by 230, my lord, again they have to go to.
Let us.
Please, sir, please.
ಮತ್ತೇನ್ ಕಂಟಿನ್ಯೂ ಕರೀತಾರ ಏನ್ ಪಾಸ್ ಅವ್ರ ಕರೀತಾರ?
ಪಾಸ್ವರ್ಡ್ ಇಲ್ಲ ಕಂಟಿನ್ಯೂ.
ಸರ್ 44 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗಿದೆ ನೋಡ್ರಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 44 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡಾರ
ಇಲ್ಲ ಆಗಿಲ್ಲ. ಹೌದು ಇಲ್ಲ 33 ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ ಅಂತ. ನನಗೆ ಹೇಳಿದ್ದು ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ ಅದೊಂದಿತ್ತು ಅಂತ ಹೇಳಿದ್ರು. ಡೇಟ್ ಹೇಳಿಲ್ಲ ಸಾಹೇಬ್ರು. ಮಧ್ಯಾಹ್ನ 2:30 ಬಂದು ಕೇಳಿ ಮತ್ತೊಮ್ಮೆ ಹೇಳ್ತಾರೆ. ನೀವ್ ಹೇಳೋದನ್ನ ಕೇಳಲ್ಲ ಸರ್, ಬಂದು ಹೇಳ್ಬೇಕು ಅವ್ರು ಸಾಹೇಬ್ರು.
ನಮ್ಮ ಹೊರಗಡೆ ಕಾಯ್ದೆ ಈಗ ಟೆಸ್ಟ್ ಮಾಡಕ್ಕೆ
With permission of your lordship,
Yes.
serial number 49. I am appearing for appellant, my lord. I request on short accommodation. ನಮ್ಮ ಆಫೀಸಲ್ಲಿ ಪೂಜೆ ಇದೆ ಸ್ವಾಮಿ ಇವತ್ತು ನನಗೆ.
So Ravi V. Patil. He is not here. We will see. The matrices will adjourn. Yes.
Serial number 30.
Lord, I am for petitioner. Lord's query was.
So we will come back again to annexure A1. Sorry, annexure A4.
Yes, annexure A1 is set aside. As per the order dated 30th January, Lord will see
that order of suspension was set aside. Thereafter you were reinstated.
Reinstated, I was functioning.
Now
Once
again
again-
you have passed this order of suspension.
Once again, A4 is issued, suspending me.
On what grounds?
Web hosting of SLC examinations.
Don't confuse between the two now. Initially, it was regarding what is that?
Recommendation of private schools admitting to grant lineage.
Correct. Adralli 16 jana. Action was sought to be taken against 16 persons. That order of suspension you questioned, and finally it was set aside. Initially, there was an interim order. Thereafter, it was set aside. Then you were reinstated. Now,
No, by virtue of stay, I was in service.
I thought. That's why he said.
Okay.
Initially, there was a stay, you were reinstated, and thereafter, that
Continue.
order of suspension itself was quashed. Now, what is the cause of action for passing this order of suspension?
Annexure A4, my lord. One more suspension order
A4 ಅಲ್ಲ.
before this.
Confuse ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಅದು ಬೇರೆ.
14.
Please don't confuse the second one.
I'm sorry.
Now, again, they have come back. They have passed an order in respect of that initial charge memo.
Initial charge memo clubbed with not permitting the new private schools for opening.
For
That is the
opening.
another charge.
One more charge is
Yes,
added.
yes. Against 8 officials.
That is annexure A14.
Here A14. That is passed on 14/10/2024. Page number 123.
So should we take it as a separate independent charge now?
Yes. Yes. Yes.
Independent
Yes.
allegation against
Yes.
you? Not connected with the other two?
No. Totally 9 persons, 9 officials. My lord will find page number 122. There are as many as 9 officials involved. And in one of the 9th employee, 9th staff member is given charge after suspending me. That is annexure A15. KAT pointed out, despite of there being a tainted official along with the petitioner applicant, how could you hand over the charge? That was the observation made by KAT. And government lord also, my lordships also have directed government advocate to find out. Now he says that charge has been reintroduced.
This matter is pending consideration before the KAT?
KAT.
Why have you filed this writ petition?
My lord. Interim prey declined. Against grant of interim prey, I am before this honorable court. Page number 129.
The records. Submits respond are all going to initiate departmental inquiry against Srimati Umadevi, and this is necessary direct to make necessary arrangement to take additional charge of post of applicant other than Srimati Umadevi, who is also facing similar charges. Accordingly, we hold that the applicant has not made out a prima facie case insofar as suspension is concerned. Yes.
And my lords will see page number 125. Oh, he is one of the official who has been charged with me. Annexure A15 charge has been directed to be handed over to him.
That's why
I have handed
KAT
over.
directed
That
us to.
observation has been made by the KAT itself. Now it's not about that.
I have handed over the charge on 16/10. As on the date of status quo, my lords have asked me this question. page number 117.
ಇಲ್ಲ ಇವಾಗ that cannot be confused with this. This is a new allegation against you.
That is what I was submitting, is different charge.
ಅದೇ.
Yes.
So
Against
therefore-
that time before I approached KT, KT has declined to grant interim stay. Therefore, I am before.
Yes.
This is third suspension order.
Yes. So what is your submission? Why what is your interim prayer? To stay.
To
stay
grant
annexure
interim
A14
stay.
and
A14. Annexure A14.
A14 and
Yes,
15.
Yes.
Huh?
Yes.
Yes.
Page number dated 1410.
Yes.
Page number 1 to 3.
Yes.
This is my grievance.
See, there are 3 sets of allegations made against you, one after the other.
True, my lord.
Huh?
True.
And now, insofar as the second charge is concerned, charge memo is concerned, your application has been dismissed by the KAT.
Yes. Yes, ma'am.
When that is the position,
Yes. That, my lord,
it does not inspire any confidence in the court as to why we should interfere in such orders of suspension.
True, my lord, true. Annexure,
One after the other allegations are being made against you.
kindly permit me to make a
So
submission.
insofar as the charge sought to be given to Srimati Uma Devi, there is already an observation of the tribunal that what you have done is not correct. So there is a direction that they have to give charge to some other person who was not involved in this case, or there is no such a charge against them. So now independent of that, what is your submission?
My
with
submission, my
respect of
lord.
A15, A14.
My submission, my lord. As far as my lord's observation, 3 suspension orders.
Yes,
1 suspension order has already been set aside by KT.
yes,
Second suspension order has already been interfered by the Honorable High Court Division Bench, Bangalore Bench. Status quo order is granted against that suspension. Despite of these 2 suspension orders, once again I am
correct, sir, but there is a new charge against you.
True, my
It's
lord.
a new set of allegation.
Despite of there being a status quo, there I am continuing.
Nothing to do. That is why we said we were also initially confused.
No, I'm
Now
sorry.
it is very clear
I did not confess.
that no, not that you tried to confuse. Now we got confused.
Yes.
Now it's a third independent allegation made against you.
Deliberately they are made. One after another, they are getting set aside by the honorable courts. And this also, my lord, issued.
The second one has been upheld, and your challenge raised to the order of suspension has been negatived, and your application has been dismissed.
Yes. Honorable High Court interfered.
It is only a direction asking them to maintain status quo. Nothing else is
By virtue of, my lord, by virtue of status quo order,
regarding the second charge.
I was in service.
Now it's an independent allegation
Yes,
against
yes,
you.
Yes.
What is wrong in it?
But
Why should we interfere?
these allegations are nothing but the allegations that were there already made. Those allegations were already interfered by the honorable tribunal as well as this honorable court. Now the third suspension order is nothing
You are
but
saying there is a reference to
ಉಲ್ಲೇಖ
earlier-
2 ಮತ್ತು 3 ಇದೆ. ದಯವಿಟ್ಟು ನೋಡಿ. ಉಲ್ಲೇಖ 2 ಮತ್ತು 3 ಇದೆ. 2 ಮತ್ತು 3 ಎರಡೂ ರದ್ದಾಗಿವೆ. ದಯವಿಟ್ಟು ಪೇಜ್ ನಂಬರ್ 119 ಅಲ್ಲಿ ಉಲ್ಲೇಖ 2 ಮತ್ತು 3, ಉಲ್ಲೇಖ 2ರದ್ದು KT ನ ಅಲೋ ಮಾಡಿದ್ದಾರೆ, ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದೆ. ಈ 3ರಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್ ಬೈ ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್. ಈ ಎರಡು ಕೋರ್ಟ್ ಮಾಡ್ತಾರೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ದೇ ಆರ್ ನಾಟ್ ಇನ್ ಫೋರ್ಸ್.
ಹಿಂದಿಂದು suspension order was, my lord.
And they have attained finality. They have not challenged this order. And attained finality. Despite of that, they quote this and strengthen their case for suspending.
What has attained finality?
These 2, my lord, ಉಲ್ಲೇಖ 30th annexure A3, my first suspension order.
Eradu government order dated 30/1/2024. Is that?
Yes, annexure A3. Annexure A3, kindly.
A3.
Yeah, yes. Kindly. Page number 61. Kindly.
That is only regarding order of suspension.
Yes. And this order has attained finality. Government has not challenged this order. The ಉಲ್ಲೇಖ 2 ಹೋಯ್ತು. It goes. Second reference goes. Third reference, this is annexure A4.
A4. SSLC ಪರೀಕ್ಷೆ
15/4/24 ಗೆ ವೆಬ್ ಹೋಸ್ಟಿಂಗ್ that has been also allowed interfered with the Honorable High Court.
ಏನ್ interfered?
ರದ್ದಾಗಿದೆ.
The tribunal has found fault.
Yes, true.
Has not found fault any in the order of suspension. Again, there also it was regarding order of suspension, isn't it?
Yes, ಅಲ್ಲಿಯೂ ಅದೇನೆ, ಇಲ್ಲಿಯೂ ಅದೇನೆ. Even present writ petition is also against suspension only.
Please understand, we are repeating again. This is a third set of allegation being made against you. No order has been passed because they are not permitted to proceed with the inquiry. Inquiry is still to be held.
True, my lord.
In any of these three allegations, of course, this is the latest one, even in respect of the two other allegations, inquiry is still to be held.
My lord, annexure.
What was considered by the court was only order of suspension pursuant to the charge memo or show cause notice issued. No inquiry is still held.
My lord.
You cannot say.
My lord, when the
courts have interfered, no, that is only in respect of order of suspension.
KT when order
ಮೂರ್ ಅಲಿಗೇಷನ್ ಈ ತರ ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಮೂರ್ ಅಲಿಗೇಷನ್ ಗಳಿದೆ ನಿಮ್ ಮೇಲೆ.
ನಾನು ಒಬ್ಬನ ಮೇಲೆ ಇಲ್ಲ, 9 ಜನರ ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ. There are 9 officials involved and
yes,
the government, my lord, the respondents are bent upon.
9 officials are involved and order of suspension is passed only against you.
All the officials.
Then
all the officials.
What is wrong then?
Well, wrong is
wrong?
The government is bent upon, respondents are bent upon shifting me from that place.
No, not
to bring their own
that
candidate.
is why we asked you.
To bring their own candidate.
Allegation is made against 9 persons and orders of suspension have been passed in respect of all the 9 persons.
They are in different categories,
Then,
different capacities, different positions.
Houdu.
My post, they wanted to bring their own candidate. Their own.
Adike directions have already been issued by the tribunal. That will take care of it.
Interference of this honorable court. When KT declines to grant interim prayer, agreed by that time before my lords. It is a good case on merits. It is a good case on merits.
How can you say it's a good case on merits, sir?
ಉಲ್ಲೇಖ 2-3 ನೋಡಿ
That is why we are.
ಉಲ್ಲೇಖ 2-3.
We have heard you in detail. We have found that again and again allegations are being made against you. This is the third independent allegation made against you.
Those allegations
not connected with the earlier two.
ಎರಡು ರದ್ದಾಗಿವೆ. ದಯವಿಟ್ಟು ಉಲ್ಲೇಖ 2-3 ಅಲ್ಲಿ ನೋಡಿ.
ರದ್ದಾಗಿದೆ sir, that is only an order of suspension.
I leave it. I will not make
only an order of suspension.
I will not make any
inquiry is still not held.
I leave it to. My only request was to interfere. 6 till suspension order is passed 16/10.
So action is taken against all the 9 of them. Inquiry ಆದ್ಮೇಲೆ ಗೊತ್ತಾಗುತ್ತೆ. ಟಾರ್ಗೆಟ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಅದು ಬೇರೆ. So if allegations are made against 9% and order of suspension has been passed against all the 9%, then we can't find fault.
No, this suspension is only against me, the 1410 annexure A14. Our ಬಗ್ಗೆ discuss.
Not in respect of.
No, it's only against me. Annexure A14, my lord will see. Kindly see 123 page number.
ಇದರಲ್ಲಿ
ಇಲ್ಲ.
ಇದರಲ್ಲಿ it may be pertaining only to you.
Yes.
But we want to know whether similar orders of suspension have been passed in respect of the other.
Separate orders are there, my lord. That will be produced before the KT.
No. You please produce it.
Yes, my lord, I will produce. Madam, for a moment, my lord, 122 page number, kindly see, my lord. Page number 122. Serial number 5. ತಿರಸ್ಕೃತಗೊಂಡ 64 ಅರ್ಜಿಗಳಲ್ಲಿ 54 ಅರ್ಜಿಗಳನ್ನು ಶ್ರೀ ನಾಗನೂರ್ ಅವರು ಅಮಾನತುಗೊಳ್ಳುವ ಮೊದಲು ಮಾರ್ಚ್ ಏಪ್ರಿಲ್ ಮಾಹೆಯಲ್ಲಿ ಅಂದರೆ ದಿನಾಂಕ 15/4/2024 ಮೊದಲು ತಿರಸ್ಕರಿಸಿದ್ದು. ಸದರಿ ಅರ್ಜಿಗಳಿಗೆ DSC ಮೂಲಕ ತಿರಸ್ಕೃತ ಆದೇಶ ನೀಡಿರುವುದಿಲ್ಲ. ಇದರಿಂದ ಸದರಿ ಶಾಲೆಗಳು ತಿರಸ್ಕೃತಗೊಂಡ ತಕ್ಷಣ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಲು ಅವಕಾಶ ವಂಚಿತರಾಗಿರುತ್ತಾರೆ. Then my lord kindly submit conclusion. ಒಟ್ಟಾರೆ ವಿಜಯಪುರ ಜಿಲ್ಲೆಯಲ್ಲಿ 2024-25 ಸಾಲಿನ ಸಲ್ಲಿಕೆಯಾಗಿರುವ 122 ಅರ್ಜಿಗಳನ್ನು ನೇಮಸಾರ ಪರಿಶೀಲಿಸಿ ಇತ್ಯರ್ಥಪಡಿಸುವ ಪ್ರಕ್ರಿಯೆ ಸರಿಯಾಗಿ ನಡೆಯದಿರುವುದನ್ನು ಗಮನಿಸಬಹುದಾಗಿದೆ. ಸಲ್ಲಿಕೆಯಾದ ಅರ್ಜಿಗಳು 33 ಅರ್ಜಿಗಳು ಶ್ರೀ ನಾಗನೂರ್ ಅವರಿಂದ ಅನುಮೋದನೆಗೊಂಡಿದ್ದು 25 ಅರ್ಜಿಗಳನ್ನು ಶ್ರೀಮತಿ ಉಮಾದೇವಿ ಸೊನ್ನದ್ ಅವರಿಂದ ಅನುಮೋದನೆಯಾಗಿರುತ್ತದೆ. ಹಾಗೂ ಸದರಿ ಅನುಮೋದಿತ 58 ಅರ್ಜಿಗಳಲ್ಲಿ 19 ಅರ್ಜಿಗಳಲ್ಲಿ DSC ನೋಂದಣಿ ಪ್ರಮಾಣ ಪತ್ರ ಅನುಮೋದನೆಯಾಗಿರುವುದಿಲ್ಲ. ಅನುಮೋದಿತ ಅರ್ಜಿಗಳಲ್ಲಿ 40 ಶಾಲೆಗಳು ಕಟ್ಟಡ ಪೂರ್ಣಗೊಂಡ ದಾಖಲೆ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. 27 ಶಾಲೆಗಳು ಭೂ ಪರಿವರ್ತನಾ ದಾಖಲೆ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. 33 ಶಾಲೆಗಳು ಬ್ಯಾಂಕ್ ಬ್ಯಾಲೆನ್ಸ್ ಹೊಂದಿರುವ ದಾಖಲೆ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. 43 ಶಾಲೆಗಳು ಅನುಮೋದಿತ ಕಟ್ಟಡ ನಕ್ಷೆ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. 31 ಶಾಲೆಗಳು ಜನಸಂಖ್ಯೆ ವರದಿಯನ್ನು ಸಲ್ಲಿಸದಿದ್ದರೂ ನಿಯಮಾನುಸಾರ ಶಾಲೆಯ ಅಗತ್ಯತೆ ಗುರುತಿಸುವುದಾಗಿ ಅನುಮೋದನೆ ನೀಡಿರುವುದು. 16 ಶಾಲೆಗಳು ಖಾತಾ ಪ್ರಮಾಣ ಪತ್ರ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. 47 ಶಾಲೆಗಳು ಕಂದಾಯ ಪರಿಶೀಲನೆ ರಸೀದಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. 8 ಶಾಲೆಗಳು 30 ವರ್ಷಗಳ ನೋಂದಾಯಿತ ಲೀಸ್ ಡೀಡ್ ನಿವೇಶನಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. 4 ಶಾಲೆಗೆ ಕಟ್ಟಡ ಸುರಕ್ಷತಾ ಪ್ರಮಾಣ ಪತ್ರ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. 5 ಶಾಲೆಗಳು ಅಗ್ನಿ ಸುರಕ್ಷತಾ ಪ್ರಮಾಣ ಪತ್ರ ಸಲ್ಲಿಸಿರುವುದು. ಹೀಗೆ ನಿಯಮಾನುಸಾರ ಅಗತ್ಯ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿದಾಗ್ಯೂ ಸಹ ಅಂತ ಶಾಲೆಗಳಿಗೆ ನಿಯಮಬಾರವಾಗಿ ಅನುಮತಿ ನೀಡುವುದು ಅನುಮೋದನೆಗೊಳಿಸಿರುವುದು. ಅರ್ಜಿಗಳಿಗೆ DSC ಮೂಲಕ ಸಕಾಲದಲ್ಲಿ ನೋಂದಣಿ ಆದೇಶ ಜನರೇಟ್ ಮಾಡದಿರುವುದು. ತಿರಸ್ಕರಿಸಿದ ಅರ್ಜಿಗಳಿಗೆ DSC ಮೂಲಕ ಸಕಾಲದಲ್ಲಿ ತಿರಸ್ಕೃತ ಆದೇಶ ಜನರೇಟ್ ಮಾಡದಿರುವುದು. ಹೀಗೆ 24-25 ಸಾಲಿನ ಹೊಸ ಶಾಲಾ ನೋಂದಣಿ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ನಿಯಮಬಾರ ಕೃತ್ಯ ಎಸಗಿ ಇಲಾಖೆಗೆ ಮುಜುಗರ ಉಂಟು ಮಾಡುವ ಪರಿಸ್ಥಿತಿಗೆ ಕಾರಣರಾಗಿರುವ ಶ್ರೀ ನಾಗನೂರ್ ಹಾಲಿ ಉಪನಿರ್ದೇಶಕರ ಆಡಳಿತ ವಿಜಯಪುರ ಜಿಲ್ಲೆಯವರನ್ನು ಅಮಾನತುಗೊಳಿಸಲು ಮತ್ತು ಶ್ರೀಮತಿ ಸೋನ್ಸೋರ್ ಅವರ ವಿರುದ್ಧ ಶಿಸ್ತು ಕ್ರಮ ಜರುಗಿಸುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್. ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಶ್ರೀ ನಾಗನೂರ್ ಇವರು ಆನ್ಲೈನ್ ನೋಂದಣಿ ಸಂಪೂರ್ಣ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಬುಡಮೇಲು ಮಾಡಿರೋದ್ರಿಂದ ಇವರನ್ನು ಉಪನಿರ್ದೇಶಕರ ಆಡಳಿತ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದುವರಿಸುವುದು ಸೂಕ್ತವಾಗಿರುವುದಿಲ್ಲ. ಸದರಿ ಅಧಿಕಾರ ಮೇಲೆ ಮೈ ಫ್ರೆಂಡ್ ಇಸ್ ರೆಫರಿಂಗ್ 2 ಮತ್ತು 3ರಲ್ಲಿ ಓದಲಾದ ಸರ್ಕಾರದ ಆದೇಶಗಳಲ್ಲಿ ಈ ಹಿಂದೆ ಕರ್ತವ್ಯ ಲೋಪವೆಸಗಿರುವ ಆರೋಪಗಳನ್ನು ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅಮಾನತುಗೊಂಡಿದ್ದರೂ ಇವರು ಕಾರ್ಯವೈಖರಿಯನ್ನು ಯಾವುದೇ ಧನಾತ್ಮಕ ಬದಲಾವಣೆ ಉಂಟಾಗಿಲ್ಲ. ಸದರಿ ಅಧಿಕಾರಿಯು ಈ ಪ್ರಕರಣ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳನ್ನು ತಿರುಚುವ ನಾಶಪಡಿಸುವ ಅವಕಾಶ ನೀಡದಂತೆ ಸದರಿಯವರನ್ನು ಸೇವೆಯನ್ನು ಅಮಾನತುಗೊಳಿಸಲಾಗಿದೆ.
So that reference is only to say that earlier too he was.
Yes, that is even then, my lord, he is not.
Number 2 and 3.
Even not, my lord, he is not still.
And
says,
out of 9 officials, only I am suspended.
Where to get this 9?
Item number 1, page number 122, my lord.
1?
Page number 122, lot serial number is 9.
ಅವ್ರ ವಿರುದ್ಧನೂ ಶಿಸ್ತು ಕ್ರಮ ಜರುಗಿಸಿದೆವು.
It is only against you and that Umadevi ಅಷ್ಟೇ.
Yes, ma'am. Yes.
9 ಜನ ಇಲ್ಲ.
Items ಇವೆ. Items 9.
Items
2 officials. 2 officials. And I have been directed to hand over the charge to this madam.
That is clarified by the KT.
ಅದು ಸರಿ ಆಯ್ತು.
KT has already.
ಅದು ಸರಿ ಆಯ್ತು. ನನ್ನನ್ನೇ ಬಾಲ್ಕನೈಸ್ ಮಾಡಿ they are suspended.
Yes, but they have given reasons.
No, reason is, my lord.
Therefore, inquiry has to be held.
True, my lord. True. When suspension order consecutively issued, one after another.
What is the law laid down by the Honorable Supreme Court in respect of order of suspension?
Not suspension order, my lord.
Why is it issued? To ensure that the officer will not have access to the documents. Chances are the documents can be manipulated. Therefore, it would be very essential that during the pendency of the inquiry, that person should not have access to the documents, and therefore he is required to be suspended and ensure that he doesn't enter the office.
Lord,
this is the ruling of the Honorable Supreme Court.
May I make one submission?
Yes.
The documents, materials, which are all they are referring, are not with me, and I am not the custodian.
It is in the office.
I am not the custodian, not in my office. They are in the office of the commissioner, additional commissioner, public instruction. Additional Commissioner Public Instruction. ಶಿಫಾರತು ಅವ್ರು ಶಿಫಾರತ್ ಮಾಡಿದ್ರು ಇವರಿಗೆ. ಅವ್ರು ಶಿಫಾರತ್ ಮೇಲೆ ನಾನು ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ರು.
No. We do not know if all the documents are taken away.
ನಾನು ಶಿಫಾರತು ದಯವಿಟ್ಟು ನಾನು ಸಲಹೆ.
But that is what is the ruling of the Honorable Supreme Court.
True, my lord.
So it is in the interest of justice that these persons should not work in that office.
Fully true. I agree. My lord, the material and all the documents are with the commissioner.
Adalla, we cannot go into all those aspects. Having regard to the law regarding suspension.
That I, but it is true, my lord. I'm
For that purpose, if order of suspension has been passed.
Official should be kept away from the material. I agree for that.
Correct.
But this material, I'm not the custodian.
Angalla, we cannot accept.
I leave
all
it to
those.
madam. I leave it to.
You want an order, we'll pass an order. Otherwise, we will simply say you go before the tribunal. Aste.
Now, in earlier occasions, my lord, have interfered and directed KA to consider in accordance with law by next date of hearing. In my own cases, my lords have made this observation. And my lord, if that is, my lord feels satisfied, kindly pass the same order. Granting interim relief till next date of hearing and directing KAT to consider in accordance with law by next date of hearing. I have taken orders from my.
Only thing that we can say is, despite the allegations being made against two persons, this person and that Uma Devi, how is it that you wanted to give charge to that Uma Devi?
That's why I'm not directed the KAT, my lord, to shift the charge to others, my lord. We are already system. Yes, that is there, my lord.
Tribunal ಹೇಳೋದಲ್ಲ.
ಅಲ್ಲ ಮಾಡಿದರೆ ಅದು ಬೇರೆ ಗ್ಯಾರಂಟೀಸ್ ಇಲ್ಲ ಅಂತ ಕೊಂಡು ಅವ್ರಿಗೆ ಇದು ಮಾಡಿದ್ದಾರೆ.
ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
That is the reason, my lord, we shifted to the other charges.
ಬರ್ಕೊಳ್ಳಿ. The petitioner who had approached the Karnataka State Administrative Tribunal calling in question impugned order of suspension dated 14/10/2024 and an official memorandum dated 16/10/2024 by virtue of which Srimati Uma Devi Sonnad was directed to take additional charge of the post of the Deputy Director, bracketly administration. He is aggrieved of the fact that the interim prayer made by the petitioner has been rejected. Full stop. Next para. We have heard the learned counsel for the petitioner, the learned government advocate, and have perused the petition papers. Full stop. We find that there are three sets of allegations made against the petitioner. Full stop. The first set of allegations pursuant to which order of suspension was passed on 30/1/2024 is found at Annexure A1. Full stop. However, the Karnataka State Administrative Tribunal in application number 20116 of 2024, by order dated 12th of July 2024, has set aside the order of suspension dated 30/1/2024. Pursuant to which the petitioner was reinstated into service. Full stop. In fact, by virtue of interim orders passed in the said application, the petitioner was already reinstated. Full stop. The second set of allegations and the consequential order of suspension was passed on 15/4/2024. However, insofar as the attempt made by the petitioner challenging the said order of suspension dated 15/4/2024 in application number 20537 of 2024 was truncated in view of the withdrawal of the application at the hands of the petitioner. Full stop. By order dated 2nd of May 2024, the application was permitted to be withdrawn with liberty reserved to the petitioner to file a fresh application. Full stop.
Writ petition order is, if agreed, he can approach once again. Annexure A5 writ petition order.
In the meanwhile, the petitioner's lien was shifted to Mangaluru,
Yes.
Dakshin Kannada.
Yes.
And therefore, the petitioner approached the Karnataka State Administrative Tribunal at Bengaluru in application number 1984 of 2024. Though the impugned order dated 30/5/2024 was stayed by an interim order passed by the tribunal, nevertheless, by order dated 10th of September 2024, the application was dismissed. Upholding the order of suspension. Full stop. In writ petition number 25800 of 2024, filed by the petitioner before the principal bench of this court at Bengaluru, an interim order was passed on 21st of September 2024, directing the parties to maintain status quo as on the date when the order was passed. Full stop. Next para. However, on a third set of allegation, the impugned government order has been passed on 14/10/2024. Once again, suspending the petitioner from services. Full stop. The tribunal has in its order dated 22/10/2024 found fault with the charge directed to be handed over to Srimati Uma Devi Sonnad, who is also alleged with the same charge as found in the government order dated 14/10/2024. Full stop. Appropriate directions have been issued by the tribunal to ensure that the charge is not handed over to Srimati Uma Devi Sonnad, since she too suffers from the same allegation. Full stop. Next para. We find that the allegations or charges imputed against the petitioner in the government order dated 14/10/2024 is independent of the other two charges or allegations pursuant to which orders of suspension were passed earlier. Full stop. In that view of the matter, we are not persuaded to accept the submission of the learned counsel for petitioner that the principal bench at Bengaluru, in WP number 25800 of 2024 has directed the parties to maintain status quo. Full stop. That order is in respect of the order of suspension arising out of government order dated 15/4/2024, as we find that the charges are independent of the one sought to be imputed against the petitioner in the present government order. Full stop. There are serious allegations made against the petitioner in the matter of recommending recommending
Opening of new schools by the private.
recommending grant of permission to open new schools.
New schools.
In Vijaypura district. Full stop. It is stated in the impugned government order that the petitioner has not followed the requirement of law, the procedures, more particularly the online registration, and has not ensured that all the requisite compliance are ensured while recommending grant of approval to start new 33 schools. Full stop. Out of 64 applications, the petitioner has recommended the case of 33 schools where it is found that there is no compliance of many requirements. Full stop. These documents it is therefore opined that in order to protect the information which are still available in the said office, it would be inevitable to suspend the writ petitioner so that he will not have access to any of the documents. Full stop. Next para. Having regard to the law laid down by the Honorable Supreme Court in the matter of orders of suspension, there can be no doubt that such orders of suspension are required to be passed to ensure that the delinquent officer will have no access to the records. Full stop.
On submission, the opening sentence itself says that the records are with the commissioner. ಮೇಲೆ ಒಂದರಲ್ಲಿ ಓದಲಾದ ಆಯುಕ್ತರ ಕಡತದಲ್ಲಿ.
ಹಂಗನ್ಬಿಟ್ಟು ಆಯ್ತು ಪರವಾಗಿಲ್ಲ ಎಲ್ಲ ಅಲ್ಲಿದೆ ಇವ್ ಮಾಡಬಹುದು ಅಂತ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ, that is only reply. I am replying to my lord's queries. Even by, I don't want to make.
That is why we said if you are making all these observations, then it will become even more difficult for you. What to do? You wanted an order.
No, kindly dispose of with the direction to KT to consider in accordance with law next date of hearing. Earlier, my lords have passed very many orders. I only have taken.
ಅಲ್ಲಿ ಏನಾಗಿತ್ತು, your application was still not considered. ಇಲ್ಲಿ it is considered and rejected.
My lord will see. KT order, what KT says is, no prima facie case is made out.
Correct.
ಹಂಗ ಹೇಳ್ತಾರ ಅವರು. ದಯವಿಟ್ಟು my lord may dispose it of writ petition, directing KT to consider in accordance with law by virtue of the latest situation where this madam charge has been
ಅದು ಬೇರೆ. That is why he said tribunal itself has found fault with them. No, you could not have given charge to that Uma Devi.
Yes.
So to that extent, the tribunal itself has noticed and it has passed necessary
in view of that,
that has got nothing to do.
My lord may dispose of with the direction to KT to consider my request.
It is held that the prima facie case is not made out and the
tainted officer is given charge. That has been acted upon.
In that regard, appropriate directions have already been given. And the government advocate has also undertaken to ensure that that order is recalled. But that by itself is not going to help you.
Charge has been taken back.
Next para. However, as rightly pointed out by the learned counsel for petitioner, in the impugned order dated 22/10/2024, the tribunal has only held that the applicant has not made out a prima facie case insofar as suspension order is concerned. Full stop. This would mean that the interim prayer has not finally been considered and rejected.
Yes.
Full stop. Therefore, this writ petition is disposed of with a request to the tribunal to reconsider the interim prayer made by the petitioner. And if the petitioner satisfies the tribunal regarding the interim prayer, comma, it may proceed to pass appropriate orders. Full stop, ordered accordingly.
Till then, my lord, interfere with the, till then, my lord may interfere with the suspension order.
ಬರೋದಿಲ್ಲ.
Nothing but succeeding.
Yes. ಅದ್ ಕರೀರಿ ಅದ್ಯಾವ್ದು?
CL number 45. Sudhir Kulkarni.
Where is Mr. Sachin? Sachin Mahajan.
Sachin M. Mahajan for respondent.
Yes, Mr. Sachin. Huh?
Given a proposal which is communicated to the appellant. One particular land, my lord, 19 acres, it appears they want to retain and the other portion they want to give. I have, my lord, conveyed the proposal.
These are the children
of the second.
from the second.
He is the husband.
Huh?
He is the husband, she is the wife. Second wife, my lord, and he is the son of the second wife.
Yeah, he is the son of the second wife.
Three appeals in total, all connected.
ಅವರು ಒಂದು ಹಾಕಿದಾರ?
MFA number 201.
ಸುಧೀರ್ ಕುಲಕರ್ಣಿ. ನಿಮ್ದೇನು?
The divorce petition filed by the husband is
That is regarding, ಅದು ಬೇರೆ. No, we are only concerned about this.
Yes. Partition suit.
Partitions. Partition suit ಅಲ್ಲಿ, what we found is that they will have 5 share. 4 ಜನ ಮಕ್ಕಳು ಪ್ಲಸ್
husband.
ವೈಫ್.
Daughter plus husband. ತಂದೆ. ಮಕ್ಕಳು ತಂದೆ 5 share ಹಿಡಿದಾರೆ.
ತಂದೆ
ತಾಯಿಗೆ ಹಿಡಿದಿಲ್ಲ. 1/5 share.
ತಾಯಿ ಇಲ್ಲ.
ತಾಯಿ ಇದ್ದಾರೆ.
Bombay school they will be entitled, my lord. Madras school they will, mother wife will not.
ಈ ಕಡೆ ಬರಲ್ಲ ಸರ್.
Lifetime of.
ಈ ಬಾಂಬೆ ಸ್ಕೂಲ್ ಆ ಕಡೆ ಬರುತ್ತೆ ಸರ್, ಬಿಜಾಪುರ್ ಆ ಕಡೆ ಆ ಸೈಡ್ ಬರುತ್ತೆ, ಈ ಕಡೆ ಬರಲ್ಲ ಸರ್. ವೈಫ್ ಇಸ್ ನಾಟ್ ಎಂಟೈಟಲ್ಡ್.
No, according to what you said last time. And
ಅಲ್ಲ ತಾವು ಲಾಸ್ಟ್ ಡೇಟ್ ಅಂದಿದ್ದು ಸರ್, 4 ಮಕ್ಕಳಿ ಪೈಲೆ there are 4 issues.
4 ಜನ ಮಕ್ಕಳು.
4 ಜನ ಮಕ್ಕಳು, father 1 and 3 issues born from the second widow. It total comes 8.
So you are also saying mother will not have a share?
No sir. She is demanding my lord maintenance for her livelihood.
During the lifetime, the husband, wife is only entitled for maintenance.
Maintenance.
In, this part of the Bombay school, my lord, wife is entitled once there is a partition. My lord, in Bombay school, beyond Bijapur, my lord, wife is also entitled. Not in this part.
There are total 3 items of properties, my lord. Survey number 70 measures 19 acre 38 gunta. Survey number 23 bar A measures 11 acre 10 gunta. And third one 87 bar 1 measures 5 acre 2 gunta sir.
ಇಲ್ಲಿ ಇಬ್ರು ಮಕ್ಕಳ?
3 ಜನ ಮಕ್ಕಳು.
3 ಜನ ಮಕ್ಕಳು ಸರ್ ಅವರು.
ಇಲ್ಲಿ 3 ಜನ. 3 ಜನ ಮಕ್ಕಳು.
Second wife. So law laid down as per my lord Reversion Siddhappa Mallikarjun case, my lord. Now it is settled and father is entitled for 1/7, my lord. In that again issues born from the first wife and.
Therefore, if the father is also supporting this side.
Let them. 1/7 ಅವ್ರಿಗೆ ಹೋಗುತ್ತೆ ಸರ್. 1/7 it goes, my lord, 7 acre 10 gunta.
ಆಗ್ಬಿಡುತ್ತಲ್ರಿ ಅವಾಗ. 4/4 ಆಗುತ್ತೆ.
Equal ಆಗಲ್ಲ ಸರ್.
ಹೌದು.
He is entitled for only 1/7 sir, as per Reversion Siddhappa's case.
1/7.
1/5 sir.
1/5.
First from first wedlock there are 4 issues. ತಂದೆ ಒಬ್ರು.
ಅದೇ 4+1.
ಹೌದು.
4+1 5 ಆಯ್ತು.
Please.
ಆಯ್ತಾ? ಇಲ್ಲಿ 3 ಜನ ಇದ್ದಾರೆ.
ಹೌದು. ಅದಕ್ಕೆ ವಾಟ್
ಜನ ಇದ್ದಾರೆ.
ಹೌದು.
But if the father also or if he is giving up that portion and that 5 can go to them and 3 can be retained by them. That is your proposal, isn't it?
Please sir.
That is
Total
your
extent, out
proposal.
of total extent is not 36 acre, 10 guntas. Out of that, my lord, we want to retain number 70 measuring 19 acre, 38
Acres,
guntas, sir.
10 guntas.
36 acre, 10 gunta is the total extent.
Ella ಮೂರು ಸೇರಿ.
Ella ಮೂರು sir.
ಮೂರು items ಸೇರಿ.
Yes. And out of this, my lord, three landed, comprising three landed properties. We want to retain survey number 70, which measures 19 acre, 38 guntas.
19
acre, 38 guntas. And the respondents wants to give survey number 23 bar A measures, my lord, 11 acre, 10 guntas. And survey number 87 bar 1 measures 5 acre, 2 guntas, sir. Total comes to 16 acre, 12 guntas, sir.
ಇದನ್ನ ಅವರು ಕೊಡಬೇಕು ಅಂತ
ಅವ್ರಿಗೆ ನಾವು ಕೊಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದೇವೆ. ಅವ್ರಿಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದೇವೆ.
ನೀವು ರೆಡಿ
Yes. And apart from this, my lord, my request is, there is one double storied building constructed, my lord, which is not subject matter of suit.
19 acres and 38 guntas is what you want to retain.
Please, sir. Please.
ಇನ್ನ ಅದು ಮಿಕ್ಕಿದ ಎರಡು ಪ್ರಾಪರ್ಟಿ 11 acres 10 guntas and
5 acre 2 gunta.
5 acres 5 acres 2 guntas.
16 acre 12 guntas, sir, total.
Yes.
And apart from this, my lord, one more request, my lord, apart from this, there are other non-suited properties. That is, one double storied building is there, one vacant site is there, tractor, car and lorry. So that is not subject matter of this suit, let them retain that property. We will not claim any right in those non-suited properties.
I have conveyed the proposal, my lord.
ಯೋಚನೆ ಮಾಡಿ, ಅದು ಒಳ್ಳೆ ಪ್ರಪೋಸಲ್ ಅವ್ರು ಕೊಡ್ತಾ ಇರೋದು ಇವಾಗ. ಈ 16 ಎಕರೆ 12 ಗುಂಟೆ ಜೊತೆಗೆ ಯಾವ್ದೋ ಇನ್ನೊಂದು ಬಿಲ್ಡಿಂಗ್ ಇದೆಯಂತಲ್ಲ, ಮನೆ ಬಿಲ್ಡಿಂಗಾ?
ಮನೆ 2 story building, my lord.
ಅದು ಕಾರು ಟ್ರ್ಯಾಕ್ಟರು ಎಲ್ಲ ನೀವೇ ಇಟ್ಕೊಬಹುದು ಅಂತ ಹೇಳ್ತಾರೆ. ಯೋಚನೆ ಮಾಡಿ ಬೇಗ ಹೇಳ್ಬೇಕು. ತೀರಾ ಜಾಸ್ತಿ ಟೈಮ್ ತಗೊಂಡ್ರೆ ಬೆಂಚ್ ಚೇಂಜ್ ಆಗುತ್ತೆ, ಆಮೇಲೆ ಮತ್ತೆ ಕಾಯ್ಬೇಕಾಗುತ್ತೆ. ಮುಂದಿನ ವಾರ ಇಟ್ಕೊಳ್ಳೋದಾ? ಮುಂದಿನ ವಾರ 10 days. ಸೊ 25ನೇ ತಾರೀಕು ಬರ್ತೀರಾ? ಸೋಮವಾರ 25 ಸೋಮವಾರ.
Regarding pension is also to be checked. Pension not given. Maintenance ಬೇಕಲ್ಲ ಹೆಂಡತಿಗೆ. Second wife is no more now. So on the 60,000 ರೂಪಾಯಿ pension.
I don't think that should be a problem.
Because of this we have come to that settlement. Once for all matter will be finished.
ಅಲ್ಲ, ಈ ಯಾರ್ದು ಪೆನ್ಷನ್ ಅವ್ರದ್ದು ತಾನೆ? ಈ ಸ್ಟಿಲ್
ಅಲ್ಲ ಆಕಿ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ಬೇಕಲ್ಲ.
ಮೇಂಟೆನೆನ್ಸ್ that will be considered in that family court case. The respondents have given a proposal to the appellants, which has been discussed in the open court. Full stop. One of the appellants, along with the father, is present before the court, while the daughter respondents, along with the mother, are also present before the court. Full stop. Next para. At the request of the appellant, release this matter on 25th of November. Yes.
Matrimonial cases, MFS, my lord, can be dealing with the first.
ನೋಡೋಣ.
Matter is not settled, my lord.
Solved, and that also can be solved. We will take it up. We'll see.
Case number 31 for reporting complaints, R.J. Busare.
This matter, my lord, last occasion I had taken the time to for compliance, my lord. Comply the order of the municipal judge.
My lord, on R.J. Busare and Classic Council, my have it on tomorrow. In relation, brother is died today morning, my R.J. Busare. Tomorrow, my lord.
ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಈಗ?
Compliance order, my lord.
ಕೊಡಿ. Learned government advocate has filed a compliance affidavit of the respondent director comma, municipal administration. Along with
Affidavit,
endorsement.
sorry, endorsement.
Endorsement dated 12/11/2024. Full stop. Copy of the same is served on the learned counsel for the complainant. Full stop. Next para. At the request of learned counsel for the complainant, release this matter.
Tomorrow.
Nale bartara.
Day after tomorrow.
Huh?
Day after tomorrow.
Yaar our brother.
Our brother expire again. RG Bosare brother. Cousin brother. Yes.
Release this matter on 19th of November.
Published.
Yes.
CL number 33, Babu H. Metagudda.
ಸ್ವಾಮಿ ಅದರ್ ಸೈಡ್ ಅವ್ರು ಡೇಟ್ ಕೇಳಿದ್ರಿ ಸ್ವಾಮಿ ಬೆಳಗ್ಗೆ
ಹಾ
ಇದ್ರಲ್ಲಿ ನಾನು ರೆಡಿ ಇದ್ದೀನಿ ಸ್ವಾಮಿ ಅರ್ಗ್ಯುಮೆಂಟಿಗೆ ಅದರ್ ಸೈಡ್ ದವ್ರು ಡೇಟ್ ಕೇಳಿದ್ರಿ ಸ್ವಾಮಿ ಅದಕ್ಕೆ ನಾನ್ ರೆಡಿ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅರ್ಜನ್ ಆಯ್ತಲ್ವ ಇದು ಸಂತೋಷ್ ಕುಮಾರ್ ಮರಡಿ ಅದಲ್ವಾ ಇದು
33
33 ಅದೇ
ನೀವು 32 ಅಂದ್ರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್.
he was asking for time.
ಅದೇ ನಾನು ರೆಡಿ ಇದ್ದೀನಿ ಬಟ್ ಅವ್ರ ಅದಕ್ಕೆ ಡೇಟ್ ಕೇಳಿದ್ರಿ ಸ್ವಾಮಿ. ಈ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸ್ವಾಮಿ.
At the request of learned counsel for respondent 2, release this matter
ನೆಕ್ಸ್ಟ್ ಎನಿ ಡೇಟ್
on 21st of November.
ಆಯ್ತು.
CL number 34, RS Lagali.
The appellate. These two appeals not though arise out of two different judgments. But my lords, however, both these matters arise out of a same common crime number, my lords. So happened that, my lords, in criminal appeal 20020 of 21, it pertains to the accused by name Arjun, who was arraigned as accused number 2 originally. And so far as Ningappa, my lords, he was arraigned as accused number 1. Now, my lords, in this case, my lords, so far as the case against Ningappa, my lords, he is accused of the offences under POCSO Act, my lords, primarily under section 6(376) being the principal offences. Rest other minor offences, my lords, he was accused of. Unfortunately, my lords, in this case, victim, my lords, was examined. Her examination chief was examined and cross was not, the counsel for the accused was absent. And the very next day, an application was filed seeking recall. However, my lords, that application came to be rejected. And my lords, the matter went on and proceeding to pass the judgment. My only concern, my lords, or my only submission would be, my lords, in view of the fact that the victim's evidence has gone uncontroverted, lords, I seek that, my lords, he's in custody from the date he was arrested, that is from 9/1/2019. He has been in custody. So, my lords, I request, my lords, that the matter can be remanded so far as this appeal in criminal appeal 23, because, my lords, it would be, I have given a judgment also, because it would be injustice, my lords, because section 33(5) though says the victim should not be repeatedly called, doesn't mean, my lords, it cannot be interpreted that he cannot be called, the victim cannot be called at all.
How many accused persons are there?
There are 2 accused persons.
2.
Yes, my lords.
So in respect of one, you are saying
Yes, my lords. The main accused, the main perpetrator
was not cross-examined by
accused number 1, against whom the allegation of rape was accused. Against accused number 1, against whom the allegation of rape has been attributed. In that case, my lords, the victim has not been cross-examined.
But the other
A2's, my lords, he is only assisted the accused number 1. He is the brother of accused number 1 who had assisted. He had dropped them near Faratabad. And then, my lords, A1 and the victim had gone places. So that is the case. And one more, my lords, so far as age, according to the prosecution, she was in PUC first year, my lords. And to establish this aspect, the POCSO being a case where minor is the victim of rape. So, my lords, the prosecution, my lords, has examined the headmaster.
Determination of the age.
Yes, my lords. PW 10, one Shivsharnappa Hadri, my lords, is the headmaster who was examined. Curiously, my lords, though she has passed 10th, her 10th mark sheet is not produced. Based on TC, the age confirmation certificate has been issued as per Exhibit P33. Even that, my lords, would not further the case of the prosecution. So, my lords, my submission would be all these can be tested if the matter is remanded so that the accused gets a fair chance to defend himself. Because till today, my lords, he is in custody. I had in fact relied on the judgment.
But let us see that cross-examination done by the other, one of the parties.
Yes, I would.
Page number 78 of
Yes,
paper.
78.
Ink page.
The thing would be. In fact, I have put a slip in the order sheet to show that the recall application was there. The very next day, the very next date, the application was filed. Now, my lords, so far as cross-examination conducted by accused number 2, my lords, the thrust of cross-examination would be different. Anyways, my lords, it is at page number 77 of paper book in criminal appeal 23 minutes.
Cross-examination is on 78.
You will revise that cross-examination.
Yes, page number 77 in criminal appeal number
78.
78.
78. We'll read the entire chief and cross. That would be better. CW 1 and 9, if my lords have found it, page number 77.
77.
Yes, ma'am. In criminal appeal number 20020 of 21 minutes. In that appeal.
Special case number 25 of 2000.
Adala Swami, 27 will.
Charge antide.
27. That is what it's little confusing because there are two appeals. CW 1 and 9 are my parents.
Examination chief. Cross-examination.
Cross-exam. Yes, next page. Minutes. It is true to say that our village is situated about 7 to 8 kilometers.
Examination by defense counsel.
Yes, minutes. This is by accused number.
Counsel, ibru ಬೇರೆ ಇದ್ರಲ್ವಾ?
ಬೇರೆ. So now only so far as accused number 2.
And it is not also clear which defense counsel. Illi.
No.
He said cross-examination by defense counsel.
No, the case was split up. A1 was tried in special case 25 of 2017. Whereas A2 was tried in special case 27 minutes. Case against A2 was split up. Later, when he was apprehended, he was brought before the court and then a separate trial was conducted. So, my lords, here the thrust of cross-examination would be only to prevent or protect the interest of accused number 2. I'll just read out. It is true to say that our village is situated about 7 to 8 kilometers away from Jevargi. It is true to say that there is bus facility to go from our village to Jevargi. It is true to say that bus passes are issued to the student. It is false to suggest that I also had the bus. The bus halts at Ranasangi village. It is true to say that my parents carry the lunch along with them in the morning itself. Our college timing is 10:30 a.m. to 2:30 p.m. On that day, I came from college in an auto rickshaw. I cannot say the registration number of the auto rickshaw. I cannot say the name of the auto driver. It is true to say that along with me, 8 to 10 students were there in the auto rickshaw. I cannot say all the students' name. It is false to say that out of them, my classmates are were present. It is true to say that CW10 is staying at home. It is true to say that since I am going to college, my parents and CW10 will not entrust me much work. It is true to say that our land is situated 2 to 2.5 kilometers away from our village. It is false to say that between our land, the village Siddhaya Mutya temple is existing. I do not know that near temple, the house of priest is existing and 8 to 10 persons are residing in the said house. I do not know that from our land to temple, the lands of one Janivar are existing. It is false to say that in these lands, the farmers were doing.
Yes, it's all insofar as
A2 is concerned.
Submissions. In submission.
And I had
what other side has argued, my lords. The
A recall application has been filed before the district court, I mean the sessions court, then
Yes.
same was rejected. And nothing was prevented them for sorting a revision before the high court. They are not. So. And another thing, my lords, the father of the victim has come. Father of and she has given marriage in along Maharashtra. If she once again called, his entire matrimonial life will be spoiled. ಏನೋ ಗುರುತಿರ್ಲಾರ್ದಂಗ್ ಮಾಡಿರ್ತಾರೆ ಸರ್. ಈಗ ಮತ್ ಕರೆದು ಮತ್ ಕೋರ್ಟಿಗೆ ಕರೆದು ಮತ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇದು ಮಾಡಿದ್ರೆ.
The accused was in JC.
Of course, my lords, I do agree. But nothing was prevented them. Definitely, my lords, whatever the cross examination that has been done in so far as accused number 2, that same be adopted. Taken into consideration. I could understand, my lords, I do agree. This is without cross examination, no value of the evidence of that particular victim or so whosoever he may be. But this is the thing, my lords, wherein her matrimonial life is going to be spoiled. What my grievance is.
He was on JC.
Do agree, my lords.
Counsel illa. It is the duty of the counsel court to appoint.
Yes. Yes.
Or refer to legal aid.
That is there, my lords. A2 ಗೆ ಮಾಡ್ತಾರೆ, A1 ಗೆ ಮಾಡ್ತಾರೆ.
ಅದೇ.
A2 was on bail.
That is there, my lords. He may be bail or not, that doesn't matter. But he was also being tried before by the sessions court itself. And he could have been I'll remind Madhu, I don't have any objection unless and until there is no cross examination, there is no evidentiary value at all. I do agree, my lords. But this is the grievance of this.
Time bound fixed on the date on which the case is fixed, we'll cross examine.
The very fact that she'll now be called to the witness box, that itself is going to disturb her matrimonial life.
One fix ಮಾಡಿ.
ಏನ್ ಮಾಡೋದು? See,
sir,
ultimately,
yes, my lords,
the principles of a criminal case is as being reiterated from the beginning.
Yes, my lords.
That let 100 accused persons,
yes,
guilty persons
yes,
go free.
Yes.
But one innocent person should not
be punished. Yes.
So therefore, if the learned counsel has pointed out, this is the requirement of law,
yes,
and that has not been followed.
That way I do agree, my lords. I do not have objection to that effect, my lords.
ಏನ್ ಮಾಡೋದು? ತರ್ಸ್ಲೇಬೇಕಾಗುತ್ತೆ. ಅದೇ that stands on a higher pedestal. Liberty under Article 21,
yes,
stands at a highest pedestal.
Yes.
We understand, yes, it may or may not cause. So there is so
but what defense counsel has submitted, my lords, the date has to be fixed on that day only.
That can be done.
And
we will ourselves fix the date, and we will say no further notice will be given.
Yes.
She has to be examined on the same day.
Yes.
The notice was complaint.
ಹೋಗಿದೆ she's been served.
Father, he is a father. ಅವ್ಳ ಮತ್ ಬಂದ್ರೆ ಮುಗಿದೋಗುತ್ತೆ. That is the only grievance which I have submitted. One day ಯಾವ್ದಾದ್ರು ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ But that would be the last, seems. No further notices.
Okay, which means the judgment has to be set aside.
Set aside.
It has to be set aside to enable cross-examination of the victim.
Yes.
And thereafter, the court will proceed to pass.
Anyhow, he is not on bail. He's been in custody.
Because
And only
A2
one more message.
A2 ಬೇಕಾದ್ರೆ
Judgment
ಬೇರೆ ಬೇರೆ ಡೇಟ್ ಇದೆ ಸ್ವಾಮಿ. ಅದಕ್ಕೇನೆ ನಾ ಹೇಳಿದ್ವಿ. There are two separate judgments. Only common factor is both arise out of same crime number. Maybe so far as ಅದನ್ನು ಮಾಡಿಲ್ಲ. Even that is wrong. Last occasion I had submitted that. Even there they could have clubbed the matters together and they could have done. Even that could have.
One more submission, my lord. The nearer to one festival, the date may be fixed.
So that
Yes, my lord.
festival
Yes.
ಬರ್ಲಿ.
Yes.
Yes. ಯಾವ್ದು ಏನಿದೆ ಡೇಟ್
ನೋಡ್ರಿ ಲಗಳಿವ್ರೆ.
January Sankranti should be good time, Lord, so that they can come. Our time nearest festival where they can come is Sankranti. That should be good time so that by the time trial court records also go. Any date.
Sankramana would be better, my lords. Sankramana.
Any date
anyhow,
around
14,
near-
15 Sankramana is there. Yes. 11th or 12th would be, otherwise after Sankramana, 16th, 17th.
Separate judgment, separate evidence, everything.
So the trial was started and by that time he was absconded. And he was secured and tried in separate special case matters.
ಆಯ್ತು. You can have it on 16th of January, na? 16th of January.
16th or 17th would be. 17th.
Uh,
ಯಾಕಂದ್ರೆ 15th January
ಅದೇ 15th will be the festival.
Yes, my lord. ಅದು ಕರಿ ಅಂತ ಮಾಡ್ತಾರೆ ಸರ್ 16th ಅವತ್ತು ಯಾರು ಬರಲ್ಲ. 17th.
17th of January.
17th.
Accused, my lord, since he is in custody, he can be enlarged now. He can at least.
That I have a.
ಅಲ್ಲ, but problem ಏನಾಗುತ್ತೆ? We are setting aside.
Yes, my lord.
So
and
once judgment is set aside.
Yes, my
What left?
What follows?
My lords, judgment is set aside if he was on bail. He was on bail during the trial. Yes, that is there. He is in judicial custody during the trial period.
Now, my lords, it would amount to pre-trial detention 5 years.
Once the judgment is set aside.
Set aside, my lords.
What follows?
But the judgment is set aside on the ground that the cross-examination has not been done. On that basis only, the matter is remaining back, my lords.
ಹೌದು, but how can we direct? No, he'll continue to be in custody.
As it is, ಇರಬೇಕಾಗುತ್ತೆ sir. As far as my knowledge is concerned.
Once we say we are
If
setting.
he was on bail, my lord, the thing would have been different. But he's been in custody since the registration of the case, and he was being tried in the being in judicial custody.
Only on the technical.
Yes, my lords. Technical ground, it is being remanded. Yes.
Then at least liberty be given that I can move bail application because 5 years I've been in.
That we only can do.
Yes.
Why should you go and ask them? Because we are reasoning it out, and why the reasons why we are making this is because of this technical reasons.
Yes.
So that decision we only can take. Why should we leave it to the trial court?
Because my bail application was also pending. I have.
All right. It's all right. Pending.
Suspension of sentence I have filed, my lords. It is pending.
ಅದೇ ಇವಾಗ ಬರೋದಿಲ್ಲ ಅದು.
So now, because 5 years, my lord, is in custody, it could amount to pre-trial detention if now the matter is remanded back without.
That is why we are saying, normally what should happen? The judgment
Set.
If we find that the judgment is not correct, we will quash it and set it aside, and we will say the accused person is not guilty.
Yes.
But adan ಮಾಡ್ತಲ್ಲ ನಾವಿಲ್ಲಿ. We are not doing that. We are saying for this reason, the matter requires reconsideration, but that can be done only after permitting you to cross-examine the witness. So for that purpose, we are passing this order. We are setting aside the judgment, enabling the cross-examination of the victim.
Yes.
So that is why we will say, no, this your request for suspension of sentence or grant of bail will be rejected till the matter is reheard and decided by the.
Yes. Yes. Yes.
Yes. Huh? Huh? Ida. ಕೊಟ್ಬಿಡಿ ಇಷ್ಟೇ, ಜಾಸ್ತಿ ಬೇಕಿಲ್ಲ.
And it may be recorded at any finding recorded, my lords, the trial court is liberty to afresh.
There in this judgment also it is there. We
Yes,
have not
ma'am.
expressed any opinion
Yes.
on the merits or demerits of the case.
Yes, precisely. That's.
Both appeals preferred by you.
Yes, ma'am. Both, yes, both them.
Number actually. Both appeals arise out of the special case POCSO number 25/2019 and
Illa, sir.
27/2019.
Criminal appeal 23 arises out of 25 and criminal appeal 20020 arises out of special case 27.
20023/2021 arise out of special case POCSO 25/2019 dated 29/9/2020 and another appeal 20020/2021 arise out of special case number POCSO 27/2019 dated 18/12/2020. The parties are referred to same rank. The brief facts leading to both appeals are that the Circle Inspector of Police J. Varghese has filed a charge sheet against the accused number 1 and 2, alleging the offences punishable under section 366A, 376, subclass 2, bracket E and N, 109 read with 34 of IPC and section 4, 6 and 17 of POCSO Act 2012. It is alleged that since 3-4 months, the accused number 1 was giving the signal to PW1 victim, minor girl aged about 17 years, was promising to marry her and was teasing. On 8/12/2018 at about 5 p.m., when the victim was returning home from her land near Rasanagi Old Road near Governalli village, the accused number 1 came near her, called her and proposed his love and to her and promised to marry her, stating that he cannot live without her, she refused his refusal. However, he put her cloth in her mouth dragged her towards bushes. The accused number 2 came on the motorcycle bearing registration number K 32/ED 6422. The accused number 1 and 2 took her on the motorcycle to the land bearing serial number 10/B belongs to CW7, situated within the limits of Mandarwad village. The accused number 2 left the accused number 1 and the victim in the said land and went back. On the same day at about 11 p.m., accused number 1 committed rape on her. On 9/12/2018, the accused number 2 brought the food to them on his motorcycle to the land during night hours. The accused number 1 and 2 took her up to Paratahabad. The accused number 2 left the accused number 1 and victim there, went back along with motorcycle. Thereafter, from there, accused number 1 took her to Kalaburagi railway station. From there to Bangalore by train, they reached on 10/12/2018. He took her to the room where CW4 and 5 were residing. Again, he took her to Srinivasapura area and Kottanur area, kept her in the shed. During night hours, he committed rape on her repeatedly against her will. Thus, the accused number 1 and 2 have committed the aforesaid alleged offences. After filing the charge sheet, case was registered. In special case number, first ಆಗಿದ್ದು 25 ಅಲ್ಲ
25, A1 25.
ಫಸ್ಟ್ ಆಗಿದ್ದು ಒಂದೇ ಕೇಸ್.
ಒಂದೇ sir, originally one case.
25/2019. ಅದ್ರಾಗ ಅಪಿಯರ್ ಆಗಲಿಲ್ಲ ನೀವು accused number
A2 remained absconding, lords. The case against A2 was
since
split
the
up.
accused number 2 was absconding. Split up charge sheet was filed.
Yes, lords.
NBW was also issued.
Yes, lords. Yes.
The special court has issued a NBW to secure the accused number 2, despite the concerned police have failed to secure him. Therefore, the case was separated from the charge sheet against accused number 2. And case was registered in special case number 27/2019.
19 lords.
27/2019. On hearing the charges, the special court has framed the charges for the alleged commission of offences. Same was read over and explained to the accused. Having understood the same, accused number 1 pleaded not guilty. Beginning in the accused number 1 was in JCL.
Yes, lords. From 9/1/2019, he's
Since
been.
from the date of arrest,
Yes, lords.
that is on
9/1/2019.
9/1/2019.
Yes,
The accused number 1
Yes.
is in judicial custody. Next paragraph. To prove the guilt of the accused, in all 16 witnesses were examined in ಅಲ್ಲ ಇದು ಫಸ್ಟ್ ಇದಾಗ್ರಿ
25 18 witnesses.
ಅಲ್ಲ ಫಸ್ಟ್ ಆಗಿದ್ದು 25 ಅಲ್ಲ
ಹೌದು ಸ್ವಾಮಿ, 18 witnesses.
18 witnesses were examined. ಅಲ್ಲ 16
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು
ಇದರಲ್ಲಿ 16 ಇದೆ.
ಇಲ್ಲ. Special case 25/2019 has 18 witnesses. ಅದು
ಸರಿ 18 witnesses, 45 documents were marked as exhibit P1 to 45 and 7 material objects were marked as MO number 1 to 7. Even ಯಾವ secure ಆಗಿದ್ದ accused number 2
10/10/2019 minutes.
during the pendency of this.
Yes, minutes.
During the pendency of the special case number 25/2019, accused number 2 was secured and produced before the court.
Yes, on 10/10/2019.
On
10/10/2019.
10/10/2000 ಅಲ್ಲ ಅವತ್ತು ರಿಲೀಸ್ ಆದವ. ಡೇಟ್ ಆಫ್ ರಿಮಾಂಡ್ ಅವತ್ತೇ ರಿಲೀಸ್ ಅವತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, I have gone through the
ಡೇಟ್ ಆಫ್ ರಿಮಾಂಡ್ 10/10/2019 ಇದೆ. Date of release 10/10/2019. ಆಯ್ತಾ? ಇದ್ರ ಸಪರೇಟ್ ಮಾಡಿದ್ರ ಎವಿಡೆನ್ಸ್?
ಸೆಪರೇಟ್ ಮಾಡಿದ್ರ ಸುಮ್ಮನೆ ಸೆಪರೇಟ್ ಮಾಡಿದ್ರು.
The trial court has in special case number 27 for 2019, the trial court, the prosecution has examined 16 witnesses as PW 1 to 16. 48 documents were marked as exhibit P 1 to 48. And same material objects are.
Similar, away from, away, they were.
And similar documents,
same.
Similar documents and material objects were marked as M number exhibit 1 to 48 and M number 1 to 7. On closure of prosecution said evidence, the statement under section 313 of CRPC was recorded. Both the accused have totally denied. ಏನಾದ್ರು ಹೇಳಿದಾರ ಬೇರೆ?
ಇಲ್ಲ.
Totally denied the
denial, general denial.
Evidence appearing against them, but they have not chosen to lead any defense evidence on their behalf. On hearing the arguments on both sides, the trial court has convicted the accused. Accused number 1, Ningappa, in special case number 25/2019, for the commission of offences punishable under section 6 of POCSO Act 2012, read with section 376 subclass 2 I and N of IPC. And sentenced to simple
rigorous imprisonment for life.
And and sentenced to undergo rigorous imprisonment for life and fine of rupees 50,000. ಇದು ಯಾವಾಗ ಅಫೆನ್ಸ್ ಆಗಿದ್ದೀವಿ?
ಇದು
ಡೇಟ್ ಆಫ್ ಅಫೆನ್ಸ್
8/12/2018 minutes.
ಅವಾಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿತ್ತ ಇದು ಪೋಕ್ಸೋ?
ಇಲ್ಲ.
ಮತ್ ಲೈಫ್ ಕೊಟ್ಟರಲ್ಲ ಇದು. ಅವಾಗ there was no punishment for life by that time.
In fact, it was only 10 years. Maximum was 10 years.
ಇದು ಲೈಫ್ ಕೊಟ್ಟರ ಇದು.
ಇಲ್ಲ.
ಅಲ್ಲ 376 N ಗೆ ಇರ್ಬೇಕು ನೋಡ್ರಿ. 376 I and N. ಅದಕ್ಕೇನಾದ್ರೂ ಲೈಫ್ ಇದೆಯಾ?
Section 6, even prior to amendment, life imprisonment was there. Rigorous imprisonment which may not be less than 10 years, but
ಈ ಅಫೆನ್ಸ್ ಆದ ಕಾಲಕ್ಕೆ ಇತ್ತ ಅದು?
Yes, that was there. Now it amended minimum 10 years ಇತ್ತು. ಈಗ now minimum is 20.
ಈಗ 20 years ಅದು.
ಅವಾಗ 10 ಇತ್ತು. But life was there.
6 under rupees 50,000 fine. And in default of payment of fine shall undergo imprisonment for 2 years. The accused also convicted for the commission of offence under section 366A of IPC and sentenced to undergo SI for 10 years and fine of rupees 50,000. In default of payment of fine, he shall undergo SI for a period of 2 years. The special court has also convicted the accused number 2 for the commission of offence under section under section 6 read with section 17 of POCSO Act 2012 and section 376(2) bracket N read with 109 of IPC and sentenced to undergo rigorous imprisonment for life and fine of rupees 50,000. In default, he shall undergo SI for 2 years. Further, the accused number 2 also convicted for the commission of offence under section 366A read with 34 IPC and sentenced to undergo rigorous imprisonment for 10 years and fine of rupees 50,000. Being aggrieved by both judgments of conviction and order on sentence, the appellants have preferred separate appeals in so and so appeals number. Yeah. After registration of this case, a notice was issued to the complainant. Same was duly served and appeared on the served. Same was duly served. Your father, you is the one of the witness, sir.
Also, PW2 in both the cases.
PW2.
Yes.
Yes, minutes.
PW2, the father of the victim,
Yes.
also present before this court. Next one. The learned counsel for the appellant in both cases would submit that would reiterated the averments made in the memorandum of appeal. And further, he has vehemently submitted that the victim, PW1, was not cross-examined by accused number 1. Yes. The PW1 was examined on 3/4/2019. On that day, the advocate of the accused number 1 was not present. Hence, the special court has recorded that the cross-examination was taken as nil. The application ಹಾಕಿದ್ದೆ ಯಾವಾಗ ಅವರು?
The application, but it was rejected on 15/6/2019 minutes. From the
after the application was filed under section 311 of CRPC to recall PW1. Same was partly allowed, but the application filed by the accused for a cross-examination of PW1 victim was rejected. The trial court has not provided opportunity to the accused number 1 who was in judicial custody, which is a violation of the personal liberty as provided under Article 21 of the Constitution. Even the trial court has not appointed any standing counsel to prosecute the case on behalf of the accused, as the accused number 1 was in judicial custody. Hence, he sought for remand the case for by providing opportunity to the accused number 1 for cross-examination of PW1. Though the trial court has secured the presence of accused number 2 during the pendency of the special case number 25 for 2019, which was against accused number 1, the trial court has not clubbed both cases and passed common judgment, though the prosecution has alleged that with the common object, the accused number 1 and 2 have committed the alleged commission of offences, which is not permissible under law. On all these grounds, sought for remand this case for fresh disposal in accordance with law. Next para. The learned SPP or the SRAG. To substantiate his argument, the learned counsel for the appellant relied on the co-equal bench, coordinate equal bench of this court, rendered in criminal appeal number 516 of 2019, dated 17/3/2022 between Betta Kurubara M. Suresh versus State of Karnataka. Next. As against this, the learned SP, additional SPP would, or SRAC would submit that, would support the judgment of the special court. And further, he would submit that the victim is already married.
Yes.
Married and residing in Bombay.
In Maharashtra.
In Maharashtra
Not,
state.
I'm not mentioning the name of the village, that particular.
If the victim again recalled by the trial court, it will cause much mental pain and agony to the victim.
And also victim's matrimonial
and also it will affect to the matrimonial
life of the
matrimonial
life
of the victim.
Yes.
On all these grounds, sought for dismissal of these appeals.
And even, my lords, one more submission. The more chance have been given to the accused number 1 for cross-examination. On that ground only.
More chance kottil onde.
More chance.
Even
then recall application has not been, that has been rejected. Yes. They have not sought any revision and
the accused number 1 has not preferred any revision.
Yes.
Against the order passed on application under section 311 CRPC.
Revision baradilla. They have to 482 ಹಾಕಬೇಕಾಗುತ್ತೆ.
Not challenged
ಅಷ್ಟೇ. That would be better.
482 not challenged. Not challenged. Now the appellants have no locus standi to say that no opportunity is given to the accused number 1 to cross-examine PW1 on all these grounds, sought for dismissal of this appeal.
Yes.
Next part. Having heard the arguments on both sides and examined the materials placed before this court, the following points would arise for our consideration. Whether the prosecution, whether the appellants have made out a grounds to remand the case by providing opportunity to the accused number 1 for cross-examination of PW1 as sought for. What order? Our finding to the above points are as under number 1, partly affirmative, 2, as per file order. You have examined the materials placed before us along with before appreciating the materials on record, it is appropriate to mention here as to the judgment rendered by our coordinate bench. Which is followed by the decisions of Honorable Apex Court. Judgment of the Honorable Supreme Court. Judgment of Honorable Apex Court. In para number 23.
Those here are the judgments we are made. Of judgments which are referred.
The coordinate bench has observed, relying on the judgment of Honorable Supreme Court in P. Ramesh versus State, represented by Inspector of Police reported in 2019 bracket 20 SCC 593 at para 18 to 23. Extract ಬೇಡ. ಇಷ್ಟೇ ಸರ್.
Rajaram Prasad Yadav's case.
Para 41.
21.
21.
ಒಳಗಡೆ ಇನ್ನು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಬೇಡ ಬಿಡಿ 41 ಬೇಡ 21.
Court office.
ಎರಡು ಮಾರ್ಕ್ ಕೇಳ್ಬೇಕು ಆಮೇಲೆ ಹೇಳಿ.
Considering the facts and circumstances of the case, we have come across several and also and it was held that the learned session judges, while discharging their duties and dealing with matters pertaining to major offences like 376 and POCSO cases, during trial when the accused counsel was absent, by recording that counsel was absent, closes the cross-examination of the defense as nil and proceed to pass the judgment of conviction and order of sentence against the accused. It is against the fundamental rights guaranteed to the accused persons under Article 21 and 22 and 39A of the Constitution of India, as well as the provisions of Section 303 and 304 of Code of Criminal Procedure. The case on hand. Next, in the case on hand, a perusal of the records which reveals that the trial court has recorded the statement of victim on
3/4/2019.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಅಕ್ಯೂಡ್ ನಂಬರ್ ಒನ್ ಗೆ ಸಂಬಂಧಪಟ್ಟ
3/4/2019.
3/4/2019 ಇದರಲ್ಲಿ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಅಥವಾ
ಇಲ್ಲ ಇಲ್ಲ
ಪ್ರೈವೇಟ್ ಕೌನ್ಸಿಲ್?
Private accused number 1.
The trial court has also recorded that the counsel absent. It is not in dispute that accused was in judicial custody at the time of recording evidence. Even now also the accused number one is in judicial custody. The trial court has not provided an opportunity to the accused to engage another counsel or through legal aid counsel through the concerned legal service authority. Accordingly, the trial court has failed to give free legal assistance to the accused by appointing some other advocate from the legal service authority though the accused number 2 counsel has cross-examined the PW1 that itself is not sufficient to come to the conclusion that fair opportunity was given to the accused number 1 as required under Article 21 and Section 303 and 304 of Code of Criminal Procedure. The cross-examination made by the accused on behalf of accused number 2 is also not binding on the accused number 1 who is in judicial custody. Next, considering the facts and circumstances of this case and keeping in the mind of the aforesaid decision, the trial court, we are of the considered view that the trial court has not providing the sufficient opportunity to the accused number 1 to cross-examine the victim, material witness PW1. Accordingly, the appellants have made out a grounds to remand the case by providing opportunity to the accused number 1 to cross-examine PW1. Hence, we answer point number 1 in affirmative. 2, for the aforesaid reasons and discussions, we proceed to pass the following order. Both criminal appeals, so and so, are allowed. The impugned judgment of conviction and order on sentence dated so and so are set aside. The matter is remanded back to the trial court with a direction to the learned session judge to provide an opportunity to the appellants to cross-examine the PW1 in the witness.
Only one.
As of now, no.
PW1.
Only one this one.
Only for this limited.
PW1. And dispose of the matter after providing a fair trial and strictly in accordance with law.
We proceed to fix a date for prosecution. Date for today.
Having regard to the submission,
No, order portion.
having regard to the submission made by the additional, the learned additional SPP, since the PW1 is a married woman and residing at Maharashtra, it is just and proper to fix a date for appearance of PW1 as requested by the learned SPP, additional SPP. Accordingly, we have fixed the date.
January 16th.
17 one.
17th.
17th.
January 17th, 2025.
17/1/2025. On that day, without seeking any time, any adjournments, the accused counsel.
The prosecution shall ensure PW1 will be present on that day.
The accused counsel shall cross-examine PW1 without seeking any adjournments.
Counsel for accused number 1.
Yes.
Huh?
Yes.
Yes. For accused number 1. Cross-examine PW1.
And as far as the two petitions, two appeals have been allowed,
As the crime is of the year, ಯಾವ crime the year?
2018 minutes. 2018.
2018, the trial court is directed to take up the matter day-to-day basis without any unnecessary adjournments and dispose of the matter within a period of 3 months.
and none.
from the date of recording the evidence of PW1.
Yes.
Cross-examination of PW1. Is the same, agree. We have not expressed any opinion in the merits or demerits of the case. Trial court shall dispose of the matter on merits without being influenced by any of the observation and ensure justice to be done in accordance with law. Trial court is also directed to the club both cases and pass. The trial court is also directed to club both cases together and pass a common judgment in accordance with law. The registry is directed to send the copy of the judgment.
So far as status of accused, A1 will be in custody.
ಅಲ್ಲ ಇದು ಕಾಪಿನೂ ಮತ್ತು ಬೈಲ್ ಕಳಿಸಬೇಕು.
A1 will be in custody. A2 since he's on bail, he'll have that benefit of bail last. ಅದನ್ನೊಂದು observe ಮಾಡಿದ್ರೆ. Since accused number 1 is in custody, let that detention continue. A2 milords had the bail even during trial and in the appeal.
Yes.
So let that benefit continue for A2.
So we will not say anything about A1. We'll say something about A2.
Yes, certainly.
Okay.
Yes. Yes.
It is submitted that accused number 2 was on bail during the pendency of the appeal trial, and only after passing judgment and he was in judicial custody.
Now he is enlarged on bail during ped.
Again after filing this.
ಅಲ್ಲ ಈಗ bail ತಾಂಡನಲ್ಲ.
A2 bail ಮೇಲೆ ಇದ್ದಾನೆ ಸ್ವಾಮಿ.
ಸರಿ.
So once again you should not be taken into custody.
A2 after conviction, his sentence is suspended. Now he is on bail, sir.
ಅಷ್ಟೇ ಬರೋದು. Since accused number 2 is on bail, same shall be in force till the disposal of the above.
Yes, sir.
As far as A1 is concerned, my lord, that is also same continue.
No. Since we are not saying that we
Yes,
have said something about A2, we are specifically not saying anything about A1.
And allowance of this particular appeal, my lord, they A1 should not take advantage of that.
No. It is as if the trial is again started again.
My lords.
So he continues to be in JC.
Yes.
ಅಷ್ಟೇ.
Yes.
ಬರಿಬೇಕಾ?
That A1 status has to be.
We don't want to take any chance.
Any chance. A1 status ಬರೆದ್ರೆ ಚೆನ್ನಾಗಿರುತ್ತೆ.
A1 continues to be in
Judicial custody. Yes.
Just because the matter is remanded.
Yes.
The
On technical.
A1 could not claim
Yes.
release.
Yes. Yes.
He will continue to be in judicial custody till the disposal of the case.
Yes. That's it.
Accused number 1 is in judicial custody from the date of his arrest.
Yes.
That is
Yes.
on
9/1/2019.
and this court has remanded the case only on technical grounds.
To enable cross-examination of
To
PW1.
enable the PW1
Cross-examination.
cross-examination of PW1. Hence, the
accused
no
number 1,
bail is granted to the accused number 1.
he shall continue to be in judicial
He
custody.
shall continue to be in judicial custody
Till the
Till the disposal of the case.
Yes.
Yes.
I'll obey.
All pending IS, if any, stand disposed of.
Yes.
ಇದು ಬರೋದು after receipt of the records, trial court is directed to concerned jail authorities to produce accused number 1 on 17/1/2025 without fail.
Before the trial court.
Before the trial court.
Yes.
Trial court is directed.
ಆ ದಿನ ಬೇಡ ಸ್ವಾಮಿ, ಅದಕ್ಕಿಂತ ಪೈಲಾನೆ let the proceedings commence, let that date be fixed. ಯಾಕಂದ್ರೆ on that day if they don't produce, before that one day at least be given so that the jail authorities will present him. There should not be any communication gap is my submission.
Trial court is directed to secure the accused number 1
On that day, on 17/1/2020.
and proceed with the case in accordance with
Yes.
law.
Yes, that's
Number 35, Ravindra Reddy.
I'm appearing for respondent number 4 alone. I have instructions, my lord, to file power on behalf of remaining, though, my lord, remaining respondents, my lord, respondent number 5 to 10, my lord. I was appearing before the learned, in the writ petition also.
You have now filed wakalat on whose behalf?
On behalf of respondent number 4 alone.
For only.
Yes.
So
on
you will undertake to
Yes.
appear for response number 5 to 10.
Yes, ma'am. Yes. As I was representing my lord before learned Singh.
Learned counsel, Shri Arun Kumar Gundappa submits that he has already entered appearance for response number 4. But he'll also undertake to appear for response number 5 to 10.
Lord, this is for the first time it is coming.
First time ಅಲ್ಲ, second, third time ಬಂದಿದೆ. This only short point, my lord.
Not short point. Lord, it is
Only point is, my lord, notification was issued, annexure B, my lord, for recruitment to the post of typists and computer operators. Lord, after issuance of notification, Lord, applications were filed by the petitioners as well as by the respondents for recruitment. The process was commenced, Lord. Last date for application, filing application was on 3/12/2015. But process was commenced. During the process, Lord, they went on issuing modified, in regard to annexure B notification, Lord, annexure A was the scorecard, which was applicable as on the date of notification. Lord, after commencement of the process, they went on modifying the scorecard. But in regard to modification of scorecard, Lord, it is a settled law. Scorecard cannot be modified once the process commences. But as on the date of notification, the scorecard which was prevailing, Lord, annexure A, which reads, Lord, your lordship may kindly peruse in page 82. But wherein it says qualification, experience and skill based post for the post of typist, computer operator. But the requirement was not merit in the prescribed qualification for the post, additional qualification over and above the prescribed in the area concerned to the job, experience in the concerned field, practical test suitable for the post, personality, performance in the interview, and after all this, Lord, your lordship may kindly please note, out of 50 marks earmarked for physical, for practical test, a candidate must score minimum 35 marks to be eligible for interview. This was the requirement. Lord. But after commencement of process, your lordship may kindly peruse annexure C, in page 93. They modified the scorecard once process was commenced on 9/4/2016. They modified by bringing new scorecard.
2016.
Oh, the 2016 notification was 2015. Recruitment notification, Lord. Annexure B was on 4/11/2015. And in page 84, your lordship.
4/11/2015.
15. And the application submitting last date was in page 91, my lord. On 3/12/2015. As on that date, not all applications were received, and even the process of selection was commenced. After that, my lord, on 9/4/2016, they issue modified scorecard. By modifying the scorecard requirement for the post of typist.
What was the modification?
Modification, Lord, they inserted general computer knowledge test 150 marks along with the practical test. In page 94. Next page, 93 is the annexure.
General computer knowledge test. 150 marks.
Weightage of 50% in the scorecard.
merit in the prescribed academic qualification for the post, additional qualification over and above prescribed in the area concerned the job. And in regard to eligibility which was fixed for the practical test, that was removed. That was 35 marks for practical test as per the scorecard for eligibility. That has been taken away. And the inserted portion, your lordship, explanatory notes for assignment of marks. General knowledge test, 150 multiple choice questions carrying 1 mark. That is apart from that, Lord, academic qualification 35 marks, additional qualification 5 marks. This was the total 100 marks. Not it was prescribed. But in regard to eligibility is concerned, for practical test and in regard to any other requirement that was removed, which was prescribed as per the first scorecard. But again, Lord, on 11/4/2016, Lord, they issued a corrigendum by modifying the recruitment notification and issued
must have not less than 1 year of experience in the concerned field in government statutory bodies.
Yes, ma'am. And accordingly, Lord, your lordship may kindly peruse Annexure E. Notice was issued for practical test dated 28/2/2017. By announcing the syllabus. Lord, even during this juncture, Lord, again they modify the scorecard. Wide Annexure F, in page 97.
Who is
Nine-
appearing for the university? You are appearing. The recent judgment of the Supreme Court.
K. Manjushri, which was referred to the larger bench.
Huh? Now the
Referred to larger bench. Now the larger bench has taken a view, my lord,
Adhe.
confirming the Manjushri.
Here is a case, my lord. They have accepted the changes made.
There is no,
ಹಂಗೆಲ್ಲ ಹೇಳಕ್ಕೆ ಬರೋದಿಲ್ಲ ನೀವು.
like, ಇದರಲ್ಲಿ ಏನೋ arbitrariness ಇಲ್ಲ. ಇದರಲ್ಲಿ ಏನೋ arbitrariness ಇಲ್ಲ. Your lordship may kindly see the
No, you
modification.
you can't change the rules of the game once the game has commenced. That is the judgment of the Supreme Court.
Larger bench, my lord, permitted to change, my lord, if law permits.
Huh? Correct.
Yes, that is.
That has to be.
Law permits.
That
So you
has to-
point out, if there is such provision, you please point out.
But it requires synopsis and all, my lord, next.
ಏನಿಲ್ಲ ರೀ.
ಇಲ್ಲ. ಇದೆ. ಇದರಲ್ಲಿ batch of writ petitions, my lord.
Please read the latest judgment of the Honorable
Yes.
Supreme Court. It says, you cannot change the rules of the game once the game has commenced,
Yes,
provided it is permissible in law.
yes, yes.
Only if rules are-
ಅಲ್ಲಿ ಆ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಅವರ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ರೂಲ್ಸ್ ಅಲ್ಲಿ
Yes,
if there is such a provision enabling changes, you will have to point out.
yes.
So it is for the university.
Kindly have it on Wednesday.
ಇಲ್ಲ. One.
Learned counsel for the
10
That
days.
is the latest judgment, Constitution Bench judgment.
petitioner. Appellant submits that
ಬೇಡ, ನಾನು ಹೇಳ್ತೀನಿ.
even in terms of the very recent judgment of the Honorable Supreme Court,
ಅದು
Constitutional bench of the
ಎಲ್ಲಿ ಐತಲ್ಲ ಅದು?
Honorable Court, larger bench,
Is larger bench.
ಇಲ್ಲ,
Earlier,
Constitution
my lord,
bench.
that judgment is considered by the learned single judgment. Manjushri case.
Constitution bench. In the case of Tej Prakash Patak and others versus Rajasthan High Court and others, decided on 7th of November 2024.
Para 42, page 42.
It is held that the recruitment process commences from the issuance of the advertisement calling for applications and ends with the filling up of vacancies. Full stop. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement, which is not contrary to the extant rules so permit. Full stop. The learned counsel would therefore submit that having regard to the admitted fact that the scorecard for awarding marks have been changed more than 3 times after the advertisement calling for recruitment was announced by the respondent university. And therefore, the appeal is required to be allowed. Full stop. Next para. Learned counsel for the respondent university seeks for a short accommodation to go through the said judgment and point out from the rules of recruitment of the university, respondent university, as to whether such changes are permitted. Full stop. Release this matter.
22. 20th. Instead of 22, 21st.
22.
Friday.
Friday beda. You want to on 25th, 26th,
25th.
25th.
Please.
All right. 25th. Next month is also same.
Seal number 36, Ravindra Reddy.
Same.
25th. Seal number 37, K. Ravishankar.
Appellant, I am appearing through video conference. Kindly pardon me to appear in the video conference. But, being agreed by the learned single judge order, in page number 9.
Put it order sheet. This some submission is made by the learned counsel for the respondent that
that is not correct.
You seem to be aggrieved of a promotion given to you
No.
from the post of process server to second division assistant.
I wanted to forego my promotion. Kindly see me at annexure page 9. My initial appointment is on 3/7/2012, annexure A, page 21, as a process server. Ink page number 21 is my date of appointment. Let the order. Let your last may kindly turn to page 22. My name is found at serial number 2 as a processor. Yes. Thereafter, Millet, I have been joined to the duty as per annexure B, page 24, reported to the duty. Thereafter, Millet, a provisional promotion has been granted as per annexure C, page 25. Last may kindly see the preamble. Considering, your lordship's got it, Millet, in page number 25. Considering the seniority come merit and fitness of the officials working in the cadre of process server and attendants about passing of the service of Kannada language examiners as prescribed so and so, secondary assistant as per rule so and so, computer literacy so and so. The order The below mentioned officials working in the cadre of process server and attenders are hereby promoted temporarily, kindly mark that, temporarily, as second division assistants on for a period of 1 year in the scale of so and so, subject to reversion, kindly mark. At any time, subject to the decisions of the writ petition and administrative tribunals on of the High Court of Karnataka, so and so, so and so, so and so. Thereafter, my name is shown in ink page number 26, serial 2, as a SDA from the process server to SDA. That a notification was called, Annexure D, page 27, on 27/1/2022. But also to fill up the process servers in the Sindagi, the process server vacant post was 6. Serial number 4. The lordships got it. A notification was called.
Process server.
Haudu. Puna process server ge karadru. I made an application as per Annexure E, page 29. Since my promotion to the post of the SDA itself is temporary basis, on my family ill health and also I sought to forego my promotion and revert back to the process server. This is the request is made on 13/4/2022. You lost me, kindly see the reason. The third para in the representation. Sir, due to some unavoidable circumstances, I am not able in a position to pull down with the present post of second division assistant since I am burdened with some familiar, she is a lady, my lord, difficulties. I desire to get reversion to the post of process server. Therefore, I request your honorable kindly to cause revert me from the post of SDA to the post of process server, which is my voluntary intention. I assure that the post of server I will serve better. This application was forwarded to the district judge with a concerned official. As per, he passes an order as per Annexure H, page 55. The reasonings your lordship will get it. The KCS rule 4A is quoted.
So your request has been rejected.
Rejected on the ground that there was no recommendation by the present presiding officer. Kindly see me. After 3, 3 is important. Though I am stressing because I am a lady, 3 you are lost me, kindly see. In the case where a reason given by the government for foregoing the promotion, your lordships got it in page number 56. Foregoing the promotion are not acceptable to the appointing authority, the same shall be communicated in writing to the concerned government servant, who shall immediately on reception of communication assume charge to the promotional post, failing which it shall be construed as a misconduct. Provided that, kindly mark, provided that such request seeking a permission to forego the promotion by a female government shall not ordinarily be refused.
Allah, see, going by what you have requested,
yes,
you have taken charge at the promoted post.
Correct, but
more than 1.5 years ago.
Correct.
Where it's not the question of you foregoing the promotion. These point out madidare, it refers to a stage where promotion is offered to you and you have the opportunity to forego.
But my promotion,
accept ಮಾಡಿ 1.5 ವರ್ಷದ ಮೇಲೆ ಆಗೋಗಿದೆ ಆಗಲೇ.
Submission.
This is not applicable to you at all.
My promotion itself, it is temporary. I am not confirmed. My promotion is not confirmed. Kindly see. That is why I said, Milord, you lost me. Kindly turn to the my appointment of Annexure C, page 25. That is why I stressed, Milord. It is subject to reversion at any time. Subject Annexure C, page 25.
That is because it has got reference to some case that was pending.
Now
consideration before the Karnataka Appellate Tribunal and Administrative Tribunal or this court.
My status even today has not been declared as permanent. My status as regards to my promotion post as an SDA with your great respect, that not been declared as as a permanent. That is why the records have been called for. Kindly see the cause list. The court felt the records are necessary. However,
please read the next paragraph.
Yes.
Next paragraph. That is what we were referring to.
Yes, yes.
The official has not submitted request for foregoing promotion
Yes,
within the stipulated period of 15 days.
Yes, 15 days. The present the present request of the official is for reversion of the lower post to the processor and forego the promotion to the post of second division assistant permanently on the ground of the burden with the familiar difficulty. The presiding officer has submitted the application of the official without any remarks or recommendations.
That is also another aspect.
That is also another aspect.
Yes,
Therefore, my submission, the learned single judge, what he does is kindly now the order. Only one paragraph order in page number 11, para 6.
Yes.
Having taken note of, having taken note of the factual aspects on record that the respondent number 1 has stated that in the order produced annexure H, there is no vacant post of process server in Vijaypura unit. The said post has to be filled up through direct recruitment. Therefore, I am of the view that the reasons stated by the petitioner cannot be a ground to interfere the implement order, and therefore, I am making a request alternatively also. Even if a post is called for the filling of the process server, let this be considered as in when the vacancy arises. Since because promotion to the post as on today still it is not confirmed. That is only my request, Miller.
No.
If the order my promotion as a permanent is being declared as permanent, I have no case at all. If it is still it is in the status of temporary, then the word stipulated within 15 days will not have any effect because my status is not declared.
No, see, such a liberty should have been made available to you in the notification itself. That is not possible, sir. Otherwise, it is not possible.
Otherwise, the clause 3 says a female government servant shall not ordinarily be refused. I have stated
that would apply only in terms of the provisions of law governing the process of promotion.
Yes.
And such a request to be made within a stipulated time.
Your lordships are correct. When my status has been declared as permanent, as a second division assistant, even now my status is temporary. I can forego my exercise my option wherever
you will have to point out to the relevant provision of law. No use making simple this kind of a statement. If the provision allows so, please point out.
Very well.
Barkale.
Let me take one indulgence.
No. We are not deciding the matter. Yes. We are giving you an opportunity.
Very well. I am obliged.
The contention of the learned counsel for the appellant is that even in terms of the impugned order passed by the learned principal district and session judge, Vijayapura, ordinarily, such a request made by a female government servant to forego promotion should not be refused. Full stop. It is further submitted that the notification of promotion itself says it would be a temporary
and subject to reversion.
Promotion subject to reversion at any time and subject to the decision of writ petitions or administrative appeals before this court or before this court. Full stop. Next para. Having heard the learned counsels on both the sides for some time, comma, we are of the considered opinion that the appellant is required to make legal submissions having regard to the relevant provisions of law governing the process of promotion and such other related provisions which would enable consideration of such request for reversion. Full stop. Next para. At the request of learned counsel for the appellant, release this matter on
Next week, Miller, any date.
26th of November.
Please, I'm deeply grateful.
Serial number 38, Krupa Sagar Party.
Lord, this is Clement's appeal for announcement, case of death, my lord. I am seeking dispensation of notice for respond number 1. Respond number 2 is Shriram General Insurance, my lord.
Shriram General.
Sangeeta Bhadrashetty, madam.
Learned counsel Srimati Sangeeta Bhadrashetty is requested to take notice for
Respond number 2, my lord.
respond number 2. Learned counsel for the appellant has filed a memo seeking dispensation of notice to respond number 1 on the ground that respond number 1 is the owner of the vehicle and the liability has been fastened on respond number 2, insurance companies. Full stop. Next para. At the risk of the appellants, notice to respond number 1 is dispensed with.
Please.
Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on learned counsel for respond number 2.
Please.
Number 39. Liaquat Farid Musa.
This is appeal against acquittal, my lord, by the complainant. The case of the prosecution is that under section 498A and 302, husband is the sole accused.
Learned additional SPP takes notice for respond number 1. Issue notice to respond number 2. Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned additional SPP.
Much.
Serial number 40, Sridevi J. Tuppal, Narendra M. Reddy.
Lord, I appear for the appellant, my lords. I am seeking dispensation of notice to respond number 1, my lords, claimant's appeal for enhancement. Respond number 2, my lords, is Bajaj Alliance, my lords. Any penal counsel may be directed to take notice.
Yaro?
Any penal counsel, my lords. Bajaj Alliance.
M. Sudarshan Obrana irodu.
Please, my lords.
For respond number 2, insurance company.
Yes, my lords.
Dispensation of respond number 1.
Yes, my lords.
Same. Yes.
Oblige. Yes, my lords, it may be.
ಅದು ಇವ್ರದ್ದು ಕೃಪಾಸಾಗರ್ ಪಾಟೀಲ್ ಅವ್ರದ್ದು ಕೇಳ್ಬೇಕಾಯ್ತು ನಾವು. ಆಯ್ತು. Matter stands referred to ಲೋಕದಲ್ಲ.
Please, my lord. Oblige.
Yes. ಅವ್ರು ಇವ್ರನ್ನ ಕೇಳ್ರಿ ಕೃಪಾಸಾಗರ್ ಪಾಟೀಲ್ ಅವ್ರನ್ನ. ಪ್ಲೀಸ್. ಇದನ್ನ ರೆಫರ್ ಮಾಡ್ಬೋದು ಅಂದ್ರೆ ರೆಫರ್ ಮಾಡ್ಬೋದು.
Number 55 notice. Lordship has heard this matter. Both the parties are present before the chamber. Last date of hearing, Lordship. The child is in the appellant was a this is the wife's petition, Lordship. On the ground, the cruelty has not been proved, Lordship. Both the parties are resident of Raichur, Lordship.
Gujarati.
Yes, yes, Gujarati. Yes, there is the urgency, Lordship. Taken the they are shifting to the Lordship, the entire family to the Gujarat. I will request to the Lordship, the matter may posted for orders on the
final hearing matters.
Number 53.
Already heard this matter on this month, but last date appearing 2 occasions, Lordship. But the cruelty has not been proved. That is
not heard the learned counsels on the merits of the matter.
Yes.
We had called them to the. chamber.
Earlier, that reasons, after subsequently, matter will report to mediation. After hearing the matter,
I thought.
yes, sir.
We have not
Yes,
heard the
yes.
learned counsels on the merits of the matter. No, no, ಅದು serial number 55. ಅದೇ release this matter on 25th.
Cell number,
Yes.
cell number 53, calculation, both side advocate calculate, dispose of.
ಇವಾಗ ಆಗೋದಿಲ್ಲ.
ಅಲ್ಲೇ
Have it,
reserve,
Monday.
reserve, dispose of,
No, no.
death case ಇದೆ, injury case ಇದೆ.
Unless we hear the learned counsels and come to the conclusion, yes, ಮಾಡಬಹುದು ಅಂತ.
ಅದೇ ಅವರು ನಾವು ಕೂಡ ಮಾಡಿದ್ವಿ ಸುಭಾಷ್ ಮಲ್ಲಪ್ಪ.
We'll have it on 19th.
19.
On the date.